Submit ಮಾಡ್ಬಿಡಿ ಸರ್. ಸಬ್ಮಿಷನ್ ವೆಕೇಶನ್ ಒಂದೇ ವಾರ ಇರೋದು. ಬೇರೆ ಬೇರೆ ಏನೇನೋ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಅದು ಎಮರ್ಜೆನ್ಸಿ ಇತ್ತು ಅಂದ್ರೆ
Court officer, am I audible? Court officer? Court officer? ಇನ್ನ ಲೇಟಾ? ಹೊರಟಿದಾರಾ? ಲೇಟಾ ಇನ್ನ ಹೇಗೆ?
ಸರ್ ಇನ್ನು ಕೋರ್ಟ್ ಬಂದಿಲ್ಲ ಮೇಡಮು. ನಾವೆಲ್ಲ ಅದಕ್ಕೆ ನೋಡಿ ನಾನು ಇವಾಗ ವಿಡಿಯೋ ಆನ್ ಮಾಡ್ಬಿಟ್ಟಿರ್ತೀನಿ ಆಯ್ತಾ?
ಹೌದು.
ನೋಡ್ಕೊಳ್ಳಿ ಸರ್, ನೋಡ್ಕೊಳ್ಳಿ.
ಓಕೆ
ಸರ್,
ಥ್ಯಾಂಕ್ ಯು. ಅಲ್ಲ ಚೇಂಬರ್ಗಾರು ಬಂದಿದಾರ ಅಂತ?
ಚೇಂಬರ್ ನನಗೆ ಕಾಣಿಸಲ್ವಲ್ಲ ಸರ್. ಚೇಂಬರ್ ನನಗೆ ಕಾಣಿಸಂಗಿದ್ರೆ ಐ ಕುಡ್ ಹ್ಯಾವ್ ಸೀನ್.
ಅಲ್ಲಿ ನಮಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಬರ್ತಾ ಇರುತ್ತಲ್ಲ ಹೊರಟ್ರು.
ಇಲ್ಲ ನನಗೆ ಅಲ್ಲಿಂದ ಏನು ಇನ್ಫಾರ್ಮೇಶನ್ ಬರಲ್ಲ. ಮೇಡಮ್ ಬಂದಾಗ್ಲೇ ನಾವು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕಮೆಂಟ್ಸ್ ಮಾಡ್ತೀವಿ.
ಇಲ್ಲ ನೀವು ಎಲ್ಲಾರ್ಗು ಹೇಳ್ತಾ ಇರ್ಬೇಕಲ್ಲ, ನಾವು ಕೇಳ್ದಂಗೆ ಎಲ್ಲಾರ್ಗು.
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ವೇಟ್ ಮಾಡಿ ಸರ್, ಒಂದ್ 5 ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ.
ಓಕೆ ಮೇಡಮ್, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Yes. What is urgency for the final hearing before vacation? But there is no time for the court. There is no time for the court to do it now. Yes, next. Huh? For release of the deposit amount. Yes. After vacation, yes.
Fresh matter first time, insurer appeal. Fresh matter first time, insurer.
Your insurance appeal, your lordship, challenging the quantum and liability in couple of matters.
Huh? Yes, is it, but which year is that? Fresh matter? What is the urgency for that? Don't give all this, let's court won't be able to do justice to all these matters. Yes,
When RPSC, madam, family got under section 125, maintenance was awarded. A husband filed a appeal, a revision petition and obtained the ex parte stay order. The full stay order, no maintenance is being paid, madam. And
yes,
tomorrow.
yes. You should continue like that. Yes,
For release of deposited amount, my lord.
huh?
Release of
Yes.
deposited amount, please.
Yes. Huh? Which year is that? Fresh matter? Yes.
No, I could ಬಂದಿದ್ದು sir, ಬೇಕು ಹೇಳ್ತಾರೆ.
Yes.
A miscellaneous second appeal, Malaz, arrived.
Afternoon.
Malaz, a fresh miscellaneous second appeal arising out of a partition suit. The rejection of plaintiff application was, Malaz, allowed by the trial court and rejected by the first appellate court. Malaz, the trial court, Malaz, is commencing with a trial in this matter, Malaz.
When was the order of the appellate court remanding the matter?
Malaz, November 2024, Malaz. I had moved a memo over the last 2 months, Malaz. It was not being listed, Malaz.
Don't tell the court. If when in my roster, any memo is moved, it is listed. Yes, no, will not take up now.
My lord, miscellaneous second appeal, my lord.
Huh?
One matter for today at 2:30, my lord, because urgency is there, the trial court has deposited the money, 50,000 rupees on second matter.
What is the nature of the case? What is the
The
case?
family court matter, my lord, family court.
Court matter.
The court is ordered to deposit 50,000 rupees to the respondent on the maintenance. Because I am ready to pay 10,000 rupees, even it is also stated in the trial court. But the trial court has made
It's a fresh matter.
fresh matter, my lord.
Yes.
But tomorrow, my lord.
Fresh matters need not be moved. All the fresh matters will come.
It will not listed, my lord. That's why I am requesting tomorrow, my lord.
Yes.
Tomorrow.
Your lordship, matter. I'm challenging the visitation rights, your lordship. I'm getting 2 Sundays, that too for 4 hours.
Was the
to me.
visitation granted?
3rd March, lay orders was passed. I filed this petition on 17th this month. I moved earlier memo, but due to some reason it didn't get listed, so I'm posting this second memo.
So how is it possible? What you couldn't get all these days, how is it possible in just 2-3 days?
So thing is, your lordship, she's from Kerala and now she's with the kid, with my 8-year daughter, she is
Understand,
shifting to
you should
Kerala.
have made all these best efforts before the other bench.
Sitting.
Take that.
This Tuesday, maximum this
No,
Tuesday.
whenever before vacation, whenever the list permits, then it will be listed. Yes.
Much obliged. Much-
GMFC fresh matter, my lords. It's for obtaining stay on interim maintenance.
GM?
GMFC.
Yes. Fresh matters do not move. All the fresh matters will be listed.
My lord, miscellaneous second appeal, my lord.
Huh?
One pending matter.
No, that I know. Fresh matters, those matters also, there was a direction to the registry to list. Yes.
One pending matter, this court has stayed registration of a perjury complaint in a family court case. But despite that, there's a summons issued for appearing on 26th. We filed an IA for stay. Despite staying of registration of complaint for perjury in a family court case, summons is issued in a criminal case for 26th appearance. So
When is
tomorrow,
that filed?
please, ma'am.
When is that case filed?
This case is 2023 pending matter, but despite stay being granted by this court,
So what the court will do now?
stay of summons and further
That's
proceedings.
what,
in
there
the-
is a stay by this court.
Please.
Now, if you move the matter, what this court has to do?
We filed an IA for stay of summons in the criminal case. This court has stayed family
When were
court.
the summons issued?
Summons was issued in February. Minutes.
Then,
It was
no.
no,
Yes,
it is
no,
26th.
GMFC fresh matter,
yes. Don't, all the fresh matters will come. Yes.
I filed an application for recall. Recall is dismissed without any grounds.
When is the order? When is the repetition?
15 was the order, 19th we have filed, it's not listed.
Yes.
But date was moved earlier, but date was given today.
For what?
Estimate.
Fresh matter?
Today,
I think instead of, hearing all these mentions, all the memos to be taken and to be listed, I think that's the easy way. I don't understand how everything has become so urgent at the fag end of the vacation. And you also have to understand how the court can, I have my own roster. How can the other court matters, everything urgent in this 1 week, which were not at all urgent throughout 2 months? Yes.
Plus fresh matter, custody matter. This was directed to be listed today. However, it is not finding in the list. May I ask for two?
All the matters, whatever memos that are given till 2nd, whenever it is convenient to the court, that they will be taken up. Take the memos.
Plus, may I request for end of the list, my lord? This one tomorrow at least, my lord.
We'll see whenever the list permits, we will take. Yes.
My lord, miscellaneous second appeal, my lord, covered by judgment. A similar matter already remanded or to the reference court, my lord. This is also same, my lord.
Why it can't be done after vacation? If it is remanded, the court is working in the vacation. Yes, no.
So the
Yes,
fresh
next.
matter, RPFC. RPFC, last week I moved a memo. Date was fixed for Tuesday. This is total 21 matter. Was not listed, my lord. Fresh matter. Tomorrow is the case. The respondent wife has filed a petition for recovery. That matter will be listed tomorrow, my lord. Kindly have done tomorrow.
So 21 RPFC has to be heard now.
No, my lord. It's 2025, fresh matter. I moved a memo before total 21. Date was fixed for Tuesday, day before yesterday. It was not listed.
Yes.
For tomorrow.
Not tomorrow. Whenever it is before vacation, some date will come.
My lord, GMFC, my lord. I filed an IA, my lord, for substitute service through embassy, my lord. Please consider the.
It also has to be considered now.
My lord, meanwhile, in the further process, it will be helpful in the vacation.
Please don't make these kind of requests. No, it will not come. Yes.
Fresh matter, madam.
Huh? What is that? Look at it. Which year is that?
Lordship. Fresh matter. Issue NBW against the petitioner in the case, my lord.
Yes. All these matters. Anita.
Your lordship.
All these matters, take the memos and as per the list, let all that be verified and listed. Yes.
Lordship, this matter was disposed by before Mr. Shiv Shankara Gowda, sir. The matter got disposed before Shiv Shankara Gowda, sir. It was remanded back. It was an owner's appeal, and now it has come for the owner.
I didn't understand, not even a word.
This matter got disposed on. This matter got disposed on December, your lordship. This was before Shiv Shankara Gowda, sir.
Yes.
The appeal was remanded back to the trial court.
Yes.
And insurance company was asked to pay the amount. Owner has deposited amount here, 1,70,000. I'm moving this matter. I have filed IA for return of the deposited amount of the owner. Matter may be taken.
That amount was in that order. It is not mentioned.
No, not mentioned.
Was dismissed for default. Restoration application filed over 6 months ago. Not even being listed for initial order. That's my request to your lordship. Properties of the estate are.
I think the same reply to you also. What was done 6 months back, no urgency now. After vacation, we'll see.
Case number 1. Case number 1 for disposal. Ravindranath K. For petitioner.
Lord, I appeal for this. I appeal for respondents. Lord, matter, Lord, the husband's petition here, Lord. The applications which has been filed. Lord, your lordship has earlier, Lord, directed me to file affidavit in respect of the, Lord, some of the.
No, why it is for disposal? At the request of non-counsel, the petitioner call these matters on 24/4/2025.
No, I read that order.
What is urgency in this?
Lord, only it is, stay is not been granted.
My lord, 10,000 order is due more than 2 years, not pay single pay, my lord. It's interim maintenance order 10,000 challenge. I also filed for enhancement of maintenance.
If
He's drawing 90,000
Have
salary.
you, as per the interim order, have you paid,
No.
are you paying the money?
No,
or
no, there is
not?
no interim order.
No, he has challenged the interim order in this writ petition only, my lord.
Interim application, not interim order.
Stay is there by this.
No, 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 there is no stay.
Then you file execution. Is this matter after vacation?
Cell number 2. Syed Abdul Sabur.
Yes, a week's time is granted.
Cell number
Default
3.
order. This also a week's time.
Cell number 4.
Post after service of notice.
Cell number 5.
What is this? Await report from medical board. Yes, Giri Mallaya.
In this case, matter was awaiting for the report from the medical board. Medical board.
When was the order passed? Medical board is requested to furnish the report by 15/4.
On
by
9/4
finding the
to- on 9/4
cognitive
to-
disability and whole body disability. What is the note on this?
On 9/4/2024,
Yes.
appeared before the medical
This
board.
is a white report from what did they do? Why it is not? You should write something, registry. List after vacation. And the registry shall mention what are the efforts made to get that order from the report from the medical board. Next 6.
Cell number 6.
Memo is filed seeking dispensation of notice to R1
Okay,
district
for the appellant.
at the risk of appellant.
Only quantum, my lord. Case of.
Huh?
She accepted.
It's only
Evening.
quantum. my lord.
List this matter before the Lok Adalat. It is submitted that the insurance company is ready to pay an amount of rupees 48,250 over and above what is granted by the tribunal. Even listed in the Lok Adalat in the evening. Yes, next.
Cell number 7.
2 week and compliance of office objection.
A week's time for compliance of office objections. Default order. Next.
Cell number 8. A week's time.
A week's time.
Cell number 9.
A week's time.
Malad, one submission, Malad. Malad, I already filed the application for dispensation of certified copy of the judgment, Malad. There is an ex parte judgment, Malad. There is a threat of execution. I am ready to deposit 50% of the award amount, Malad. Stay may kindly be granted.
What are the office objections? Look at it.
Production of certified copy. I have already filed the IA for dispensation.
The word company is not forthcoming in the seal affixed in Wakalat clarity.
That is why,
Company
Malad, that's why I filed. I have produced the last copy.
comply with the office objections within a week. This is
Malad,
not an.
Malad, pending the
This
compliance.
is
Malad,
matter
stay may
on
be granted.
second.
Second.
Next.
Much of it.
Then Pradeep B.
Malad, post on Malad, when Malad date.
Second.
2nd May, sir.
Malad, can it be on Monday or Tuesday? Monday or Tuesday?
My lord, counsel submission is, my lord, Liberty General Insurance Company Limited has been mentioned in the judgment. As for the Wakalat, my lord, Liberty General Insurance Limited. Company Limited is not forthcoming in the seal. Actually, my lord, it's Liberty General Insurance Limited. One and the
What
same,
is-
my lord, only that has
What is coming up in the seal is correct, but not in the cost item.
not cast. Before MSCT, my lord, they have did it, my lord, Company Limited. That is the only objection, my lord.
They said, message Liberty General Insurance Company.
Limited, as mentioned in the judgment,
Uh,
instead of Liberty General Insurance Limited. Company has added.
Company, they have added.
Added.
Yours is not a company. It is
Limited.
it is limited. Office objection. The submission of the counsel regarding the office objection is accepted. And the office objections are overruled.
Lord, this case, my lord, challenging negligence and quantum, my lord.
On quantum,
Negligence and
How much
quantum.
is granted?
I will deposit 50%, my lord, 8,26,000 awarded.
it is submitted that the insurance company is questioning the quantum. Considering the submission, they shall bestow of all further proceedings on the condition that he shall deposit 50% of the amount. And on such deposit, the claimants are at liberty to withdraw
Before MSCT, my lord.
before the embassy. Yes, next. Notice.
Cell number 11.
Yes.
Still S. Narayan.
a week's time for complaints of office objections. Next.
Serial number 12.
12, please, not vehicle number mentioned by the learned judge is K03Z42C. For correct number is K51EB5414, please. Motorcycle number is wrongly mentioned in the learned judge, in the judgment, please. There are two of the judgment, please. Motorcycle number K03Z4274. Correct number is, please, not K51EB.
How is this court concerned with all that? With the registry?
Allow the learned itself wrongly mentioned
Correct.
that.
So what you are supposed to do? You are supposed to seek a clarification from the trial court.
Trial court only.
What business registry has to take all these notes into consideration?
Now they are possible.
No. That can't be. Office objections are sustained. And the office objection shall be the acceptance of note below that is not accepted. Yes.
Serial number 13. Amparaju.
Yes. Time.
Serial number 14. Gita M.
I prefer a week's time to comply the office.
Yes, a week's time.
Serial number 15.
I number 1 of 23 is filed to condone the delay of 37 days in filing the appeal for the reasons stated in the accompanying affidavit. Delay is condoned. Admit. Post of final hearing.
Day
copy
before
of the
yesterday,
DCR.
it was enhanced to 485,000. Day before yesterday, it was decided.
That's it was decided and I get the instruction from my company, my lord, 4,85,282. That's it was.
You are ready?
2 days time.
2 days.
Posted
29.
26th.
It is submit. Shall record that the insurance company is ready.
Please, my lord, I will inform. And I will
This
get
is
the
matter before the
confirmation.
Lok Adalat. The next Lok Adalat on 26th Saturday we'll have.
Please.
This is matter on 26th before the Lok Adalat. Yes, next.
Serial number.
Give the file. Which is the insurance company in this?
Serial number 16.
Which is the insurance company? Huh? Mr. H.S. Lingaraj is directed to take notice on behalf of the respondent insurance company, and the counsel for the appellant shall serve the copy of the appeal memo on the counsel. IA number 1 of 25 is filed to condone the delay of 80 days for the reasons stated. Condone. Admit. Post for final hearing. Huh? Give that. A memo is filed seeking dispensation of notice to R1 at the risk of the appellant. Notice is dispensed with. Next.
Serial number 17.
Which is the insurance company? Look at it.
Kailashan.
Give the file.
It is Reliance General. Reliance General Auto.
Mr. B. Pradeep is directed to take notice on behalf of the insurance company. Notice to the respondent number 1. IA number 1 of 25 is filed to condone the delay of 421 days. Condoned on condition. Yes.
Serial number 17. 18.
So it is 91 days. 91 days condoned. Yes, no condition. Yes. Next, 18.
18.
Appearing for appellant, my lord, memo for dispensation notice to R1 to R3, my lord. United.
Dispensation notice to
R1 to R3.
R4 is?
R4 United India Insurance Company, my lord.
United India. Mr. L. Srikantra is directed to take notice on behalf of the insurance company and the counsel for the appellant to serve the copy of the appeal memo. IA number 1 of 25 is filed to condone the delay of 421 days on condition. Admit. Post for final hearing.
It may be referred to Lok Adalat.
It can be referred. When today?
No, madam. Usual course, madam.
Saturday.
Usual course. Saturday we cannot because we can serve the copy and they are filed the wakalat.
No, they can inform Mr. Srikantra. We'll have it on Saturday. Saturday refer to the matter is referred to the Lok Adalat. Yes, next. 19.
Cell number 19. Sophia.
Not
Lord.
for the petitioners. List number 1.
1 of 24 for the modification of the order dated
My lord, have-
11/12/2023.
My lord, have sought for enhancement of visitation right, my lord. The child is 6-year-old and is a special child, my lord. The
Well, let's
petition
see,
is,
where is this order of
My lord,
11/12/2023?
my lord, the order is 11/12/2023 of this honorable court, my lord. Wherein I was allowed to meet the child every Sunday, my lord, between 10 to 2 p.m.
Where is the respondent?
My lord, even on last day, the respondent did not appear.
Then what to do
My lord, this, it may be posted after vacation, noting
after
the,
vacation?
noting the absence of the respondent, my lord, and a date may be fixed.
No representation for the respondent in the last occasion and not today also. This is matter after vacation.
My lord, a date, my lord, please.
Date they will put. Yes, next.
Cell number 20.
Hearing for the petitioner.
M.
This
Veerapati.
application came to be filed in the part stage. The lordship said that however part is going on, then part is going on, we will consider the finally in that way the matter was posted.
IA 1 of 2025 is filed by me, my lord. That may kindly be taken up for consideration.
And I have
The limited prayer that I am making is
I'm,
an interim
I
order
want
has
time to
been
file
passed.
objection. Madam. If
And
that
in-
is pressing the IA now you before your lordship.
Vacation 20. Yes, 21.
Cell number 21. 21.
This is that.
I'm
Rohan
appearing for
Pandari.
the respondent, my lord. Kindly pass over the matter. My senior is held up in CH-14.
230 to Lord leadership.
Yes.
Much obliged to lordship.
22. Cell number 22.
Yes.
Gulati.
20 to appear for the respondent, my lord. This is a matter where, my lord, the IA for, my lord, 16(6), my lord, Article 16, Rule 6, my lord, has been dismissed by the trial court. But at the
Interim order in this.
interim order is there, but interim order is there, their favor.
Stay on
Stay
that,
of the, my
right?
lord, proceedings, my lord, at the stage of, my lord, when the matter posted for, my lord, final argument. In fact, my argument was heard.
Presentation for dismissal. You give some date.
28. 4.
Please, my lord, please.
Cell number 23.
For the respondent.
My lord, I'm appearing for the petitioner. I have come before this honorable court challenging the rejection of the IA filed under 7 Rule 11 by the family court. My lord, the facts of this case are thus. There was one petition filed under section 9 before the family court of Gautam Budh Nagar, and which came to be in which an ex parte restitution decree was passed on 21, my lord. 21. The petition can be found at page number 45, my lord, and the judgment has come on 21/2021. Subsequently, it has been the claim of the respondent wife that she became aware of the judgment on 15/4/2021. Another petition here came to be filed on the grounds of cruelty under 13(2)(2) and 13(1)(a) before this court. On those grounds, my lord, I have filed an application under Order 7 Rule 11D saying that it is barred by law, considering it barred by res judicata. So,
what is 9? One is a
Section 9.
restitution petition.
Yes, my lord.
Other is a divorce petition.
Yes, other is a divorce petition.
Restitution filed by whom?
Restitution filed by the husband. Divorce filed by the wife. My lord, in this case, though at that point of time on 15/4/20 on 21/2021, the plea that has been taken in MC, the present MC, could have been taken in that petition itself. However, she was placed ex parte. She did not come to the court. There was another GNWC that was filed again by the husband before that court. In that court, she appeared in that particular case. However, took absolutely no steps in order to either get this recalled or take a plea there. There is an order of restitution. It has not been challenged. That particular order is pending. It has attained a finality also, considering that there is absolutely no appeal that is placed against it. Therefore, my lord, in this peculiar circumstance, I would wish to convince this honorable court that a deliberation needs to be done as to how the principles of res judicata apply in this case, my lord. My lord, if your honorable court, if I may be allowed to present certain.
What did the trial court say?
My lord, the trial court, in between there was another aspect.
What
which
is the finding of the trial court?
My lord, the finding of the trial court is that res judicata is not applicable in the cases of family matter because one is on restitution and the other one is on divorce. Therefore, res judicata in this case is not applicable. My lord, however, if this honorable court may kindly look into the petition.
No urgency for this.
My lord, I have not been granted stay also. There is no interim order.
The
matter is before the family
family
court.
There are so many matters pending.
My lord,
it has no time to
the
hear
matter
all the matters.
is before this honorable, before the family court on 13/6.
Nothing will happen. Nothing will happen. Yes.
Cell number 23.
After vacation. Yes, next.
At least a date may be fixed, my lord, before 13/6.
For every case, date will be given. It will be basing on, because all the matters, if they given one date, it will be difficult for the court. Yes.
Court number 24. Pradeep B.
Yes, Mr. Pradeep.
Last occasion, the respondent has asked about the settlement matter, maybe about the local. It may have it 26th, my lord, we'll discuss on settlement.
Both the parties submitted the matter may be referred to the local adalat on 26th.
Some other local, next local. Only I have to ask the party to, he's a disabled person and he could not walk and things. Next, they may have to take a decision. My lord. They have to take a decision for the mediation.
If it can be done, it can be done. Why you want a date? If it doesn't, then we'll see. It will come on 26. Yes, next.
Cell number 25.
25, my lord, appearing for the second respondent, my lord. The one more connected matter has been listed on this number 3, serial number 22, my lord.
We'll take up along with that.
Please, my lord, any other day, my lord. He has served the copies today. In that, my lord, they have not served. Today, I will collect the copies.
In this, they have served.
In this served.
So we'll take up along with that. Now you look at it, because this is served, we can, any scope for settlement, we can see in this. Which is the insurance company?
If court, okay, my lord, sir.
If court. Then
when
when
do
do
you
you
want?
want? When do you want?
29th, sir.
20?
29th, my lord.
29.
Connected number.
Connected, serial number
Along
22.
with so and so in the third list.
In the third list, my lord, serial number 22, I will undertake to file wakala. It has served under.
Yes.
28 4. 29.
20.
Yes.
Cell number 26. Syed Abdul Sabur. PC Shivanya Gowda.
What about this?
29th, my lord. Talks are going on.
29.
Cell number
At the
27.
request of land counsel for the respondent. Yes, 27.
27.
Serial number 27 appear for the petitioner, my lord. In this case, my lord, this honorable court directed the respondent to deposit the medical expenses. I already furnished the medical bills ranging up to more than 7 lakhs because the second respondent's second petitioner is suffering from retinoblastoma cancer, my lord.
Respondent is liable to pay an amount of rupees 7 lakh 9,227, which is 60% of the medical expenses borne with for the say of the respondent. All on 24/4.
Lord.
Who?
The respondent direct. It was that this honorable court directed
Who
to.
respondent?
Respondent is the husband. Respondent is the husband.
Who is your representative?
Pradeep Nayak. Pradeep Nayak ke.
Pradeep Nayak.
Abu Bakar Shafi.
Yes, I am for the petitioner.
Yeah, where is Mr. Pradeep Nayak?
Pradeep Nayak.
No representation. After vacation?
After vacation, one date may be given, my lord, on the first week.
Give a date. After vacation, no representation for the respondent. Counsel for the petitioner is present.
Cell number 28.
First week, a date may be given, my lord.
Yes, yes.
I will give, sir.
Yeah.
Cell number 28.
Appearing for the petitioner, my lord. This is a matter basically on the revision what we have put.
On filing of acknowledgement for having paid 10,000 and also the arrears at the rate of rupees 10,000.
Yes, my lord. For that itself, actually, I wanted to make a submission. This is a case where mother was suffering from breast cancer and for which the wife left the place. And today he has 25 lakhs loan and he has been paying the loans where he's hardly
It's an order on 23/1/2025.
Oh, yes, ma'am.
So what happened to that order?
That order, currently he was able to pay, last time he had paid 10,000, my lord. He was able to pay that much, whatever was possible from his side. But reality of his situation is He spent for the marriage 10.5 lakhs. For mother, she passed away also recently. And the wife left because she was not ready to stay. Even in the last year.
Representation for the respondents post after vacation.
My lordships, one submission, they have ordered for attachment of his salary in the trial court. That may be stayed till then, my lord. Because, my lord, the very reason is that because it will be a very much injustice to the person, because it's not his mistake at all. This is the third 125 CRPC she had filed.
Already there is an order by the court asking you to pay. You
It
have
was
not
reduced. It was reduced, my lord, from 18 to 10,000.
Then where
And
is the 10,000?
it's not happening
We
for
can't
him.
help it. Whatever is the measures available to them, they'll.
At least, my lord, if that may be stayed before, if you can hear the full matter and then give that, it would be really helpful for my client, my lord.
Yes.
Till number 29.
My lord, I
For the
appear for
respondent,
NCR in
It
this
is on the
matter.
request, requesting a passover.
My lords, in fact, there is a, I have no objection to a
Passover next.
Can it be taken in the
Number
afternoon, my lords, 2:30?
We don't know. With all the lists you're seeing, at 2:30 it may be taken. Yes.
30, great.
Till number 30. Venkat Reddy, SK.
Petitioner, my lord.
Till number 30.
I seek for some accommodation, lord.
Can it go after vacation?
Interim order may kindly be extended.
Yes, next.
Interim order may kindly be extended.
Inter-alia granted is extended. Next part of.
Till number 31. Vijay Kumar T. Byrav.
This matter, my lord. They have filed execution and there is a arrest warrant issued, my lord. We have to pay 4,000 at least.
If you don't pay, they will execute. What to do?
He's not in a position here. I
But
am
we can't
finding
help
the
it.
documents also, my lord. He is suffering from heart problem and whereas she is also working, my lord. She has not filed even the assets and liabilities as envisaged.
What is the maintenance granted by the court?
4,000, my lord.
That 4,000 also you can't pay. What is
Right
occupation?
now, my lord. I will pay it little later. I want for some time to pay.
So
The
how much
earlier-
you are going to pay on that condition? There will be an order. There can't be any blanket order.
I'm not asking for
So how
blanket.
much you're going to pay?
I will pay 50% of it, my lord.
50% of
The amount that.
arrears at 4,000.
Yes, my lord, I have 2 months' time, my kindly. I will
The
pay.
council submits that the court had granted 4,000 as maintenance and the petitioner is not in a position to pay. However, it is submitted that if some time is granted, she would be paying the amount. Considering the same, they shall be stay of all further proceedings on the condition that the petitioner shall pay the arrears, 50% of the arrears within 2 months from the date of the receipt of the order and continue to pay an amount of rupees 4,000 by 5th of every succeeding month. Either the arrears or the petitioner fails to pay the 4,000 by 5th of the every succeeding month, the stay granted by this court stands vacated without further reference to the court. Yes, next.
Till number 32.
Hearing for the
From
petition.
Veerabhadraya.
Petition filed for
Item
mandamus.
20. Item 20 is urgent, my lord. It is between the same
No,
parties.
that is nothing to do with this.
Maybe
This
taken
is
after vacation.
mandamus, that's the maintenance.
After vacation.
My lord, serial number 20, interim order has to be extended.
That you should ask when the matter is
Sorry,
called.
Appellate.
Look at it, serial number 20, interim order is there, extended on the last occasion, please extend. Yes, next.
Much of
Till number 33.
Lord, in this case, I appear for the respondent father who has had his visitation rights curtailed by an order of the family court. There was a previous order dated 3/9/2022 by which the father was able to meet his daughter, who's now aged 11, on every Saturday and Sunday. By a modification order, which is the impugned order, his visitation is now curtailed to first and third Saturdays only. And after an interaction with the minor in chambers, this honorable court was pleased to find that the minor, who's now aged 11, has absolutely no problems with the father. And all that we are asking for is access to her over the weekend so that my mother and father may also spend time with this minor child. And I may have uninterrupted access to her, so as to build up my relationship with her, which has been curtailed for the past 4 years and a half.
Husband respondent is permitted to visit the minor child on first and third Saturday.
Yes, my lord.
After school hours at the Child Visitation Center, Family Court, Bangalore.
Yes, my
Any interim arrangement is made by this court?
Not yet, my lord.
The same is continued.
Same is continued.
What are your objections?
No, there is no urgency, Your Lordship. It may be filed after vacation. It may be continued, the order passed by the family court every first and third.
No, what is the difficulty? We can, the father can, the girl is on vacation.
She's on
If there is no
vacation.
difficulty, he can have, he can, because it's a vacation, why should it be in the family court if it is outside? What is the difficulty? That you can tell the court.
No, it has been in the page number 13, Your Lordship, in the petition. The judge's honorable family could have been observed because of father's alcohol consumption and harsh behavior. So the family court directed to only the first and third Saturday.
File your objections to this, any, whatever are your objections?
Please.
Your file?
We have
They have
filed
filed,
objection.
Where are they?
They have filed.
Please point out that.
Page 9, Your Lordship.
Page 9.
Para 21.
21, yes.
Page 9, Lordship. There you mentioned why we are rejecting the stable environment is not there in the, like the father is staying not, there is no female in at a family, Your Lordship.
Where are you reading? Para 21 starts, it is reiterated that
Page
petitioner
9,
does
Lordship.
not contribute financially.
Yes, page 9, Your Lordship.
Uh,
Below 14 line.
uh.
The stable element along with the respondent aged father, the respondent also live in a family help member because here the child is living with a mother along with it, there is a maid, Your Lordship. With the father resides, there is no female, Your Lordship. So the main condition is that because of that.
No, we are not sending the girl for overnight visitation.
Please.
Is only
His
the-
mother stays
in
with
the
them, my lord.
ensuing vacation. You can meet her in the daytime. If you want, if you may not be in that family court, outside somewhere.
They live 1 kilometer from each other, but she does not permit me to see my daughter except in that mall or the visitation center.
He says his grandma is.
My mother, page number 243, my mother's Aadhaar card with address is in my address.
Get instructions. This
Please.
is matter tomorrow.
Right.
Tell your client will grant visitation because you're just staying 1 hour, 1 kilometer away from your house.
Please.
Some reasonable time, 2 hours, 3 hours, because it is vacation. If you're out of station, that's fine. If you're going on vacation, as long as you're in Bangalore, that can be done.
Please, Your Lordship.
And she works from afternoon to night, 12 o'clock.
Yes, next.
Till number 34,
For the respondent,
Prasanna DP.
filed an
Yeah.
interim application for vacating of the stay, my lords. My lords, the impugned order was challenged by the writ petitioner, and an interim arrangement was done to pay 30,000 rupees out of the 1 lakh what was being granted to the wife.
Pay is granted by this court.
Yes, my lord. 75,000 to the child from the date of application per month. And 3 months time was given, and the third month is going to get over on May 10th. But before that, what happened, my lords? They filed a memo before the family court.
Where is the interim order by this
My
court?
lords,
Let us see
the interim order is dated, my lords.
Subject to the condition that the petitioner shall pay 30,000 per month from the date of the application till realization.
Yes, my lord.
And the arrears at the rate of 30,000 to the respondent within 3 months.
Yes, my lords.
Whether that is complied with.
That
or
is not being complied, my lords. That is not being complied.
Representation for the petitioner. It is submitted that the petitioner has failed to comply with the interim order passed by this court. This is matter day after tomorrow. But dismissal. Yes, 35.
35,
Lords, for the petitioner father, my lords, seeking for the
35,
visitation and interim custody during vacation. My lords, during the last date, the coordinate bench, my lords, has directed the registry to list the matter along with the connected matter. There is one more identical matter, my lords. That matter has not been listed. My lordship
List
may
along with
get
so
it
and so.
connected, my lords. I'm giving the order that has been passed during the last date, my lords,
Look,
by the coordinate bench.
I'm just placing memo that there is a mediation process that is going on in the Supreme Court, my lords.
My lords,
Connecting between the
thing is, my
parties.
lords, the daughter's
the
birthday
next-
is on the 2nd of the coming month, my lords. I have not visited my children for last 2 months. And also, my lords, the coordinate
Why
bench,
on which order the matter is carried to the Supreme Court?
My lords, the 498A that was filed as against me.
This is an independent.
It's an independent matter, my lord.
But
It doesn't have any bearing.
The mediation is between the parties.
Might be going on
No,
in
no,
a 498
I just,
manner.
plus I'll also file my objections, place all the material before your lordship. It's not just visitation. Once in a month, on a Sunday, visitation rights are granted to the father who stays in Mangalore. And because of all the material that is placed before the family court, and from the date that has been granted, not even once the father has exercised that visitation also.
In fact, he wants visitation on his birthday, we'll give him.
Millards, I will tomorrow itself, I will place all the material before your lordship. If your lordship feels I have no
List it on
difficulty.
Saturday.
Saturday.
Yes, next.
Plus, meanwhile, can I
Lord,
just
there is
file this
another
memo?
connected matter? Another connected matter, in fact. my
That
lord.
also, we'll list
Please.
along with the connected
Please.
matter. Next, 36.
Grateful, ma'am.
Cell number 36, Pawan Chandra Shetty.
Yes, Pradeep, any scope for settlement in this?
No, my lord, the contributory negligence,
I am
25% they have questioned.
After vacation,
Cell number 37,
37,
cell number 37.
Kindly have this matter.
after vacation, 38.
Cell number 38,
38, my lord, I am for the respondent. I am not well, my lord. May
After
taken
vacation,
upon 20.
For the petitioner, yes, next.
cell number list number 2, serial number 1, have been spoken to. Ronald,
You gave him the order yesterday. You are here, I recorded that no representation.
That's why I am sorry, Your Lordship.
38, in 38.
Petitioner.
At the request of land counsel, the respondent after vacation, interim order granted is extended. Yes.
I've seen that there is no difficulty at all. It is the registry that has misconstrued that order. And may I just take your lordship through that? What the court in the earlier decision has said is that this is a matter for the court to decide and not for the registry to decide.
No, in this case, you have not filed the application.
I have not.
So that's why now the registry cannot take a call and say, you don't have to, no issue notice to the registrar. You file it, and when it comes before the court, if you ask the court that no notice is required, that the court will do.
Yes.
So what follows is you have to file an application that will come up before the court.
I
The
do
court
not
will
want
say,
to file an application, is my submission.
But that is not the order.
The order simply says that this is the court, the registry. I will just read that last little bit. If the registry shall henceforth comply with 52/2. 52/2 is to send the notice if process has been paid, which also has to follow the order of the court. Whether to send the notice to the deputy commissioner.
That's a prerogative of the court. What they said, what is that order says is, as contemplated, whatever the procedure, the applications you have to file.
Yes.
Then the court will say, in this case, notice to the registrar is not necessary, and we may dispense with that.
My submission is, for that order to be decided by the court, there is no need for an application from me.
That I understood, because in the light of the amendment, as you said,
yes,
where the maximum amount court fee is, what is that, 1,000 or 25,000 you said. So that's a maximum amount. So when I'm paying that, the valuation of the deputy registrar is not necessary, is your submission. That I remember.
I am not concerned with that aspect at the moment now. The issue raised by the registry is, I have not filed an application. Not that the application has to be decided. What they are saying, what they have misconstrued.
If you file the procedure contemplates a notice to registrar.
Yes.
According to you, it is not necessary.
That way I will submit to the court, not to the registry.
As far as the office objections are concerned, when it is necessary, according to them, as per the checklist, it is necessary.
No, that is my submission.
But that order doesn't say so.
Exactly. Therefore, it can't be implied that tantamounts to a new rule being created in the rule book, which is not for the court to do. or the,
That I will, then I'll pass order. I just want you to have the benefit of looking at that order. That's why it is for being placed as a, under for being spoken to. Now I'll pass order. Yes. We'll pass
whether
order.
the application should be filed or not is the question.
I'll pass. Yes, next. Heard. Yes, next.
Cell number 2. Cell
My
number
lord,
2.
I am for no insurance, my lord. In their appeal, my lord, R6 is the mother of the deceased. My lord, I will undertake to file the wakalat and matter may be referred to Lok Adalat, but I will try to settle because no insurance at all. Correct.
What he will, with whom he will settle?
Owner of the vehicle.
Who represents owner of the vehicle? Where is Mr. Chandrasekhar? This is matter, Lok Adalat on schedule to be held on 26. Yes,
Cell
next.
number
3. Delete from part heard. Yes, 3.
Cell number 3.
Appearing for the appellate, my lord, in short, affirmative.
This is matter after vacation, delete from part heard.
Cell
Next
number
4.
Appearing for the appellate has already decided, my lord, for dictation today it has been posted. Other side has not come, my lord, on the day. It's a ECA matter, my lord. The income taken is on 15,000 wages instead of 8,000. My lordship has
With that 8,000, it is coming to
4,55,080
plus 5,000.
5,000, 4,60,080 instead of, my lord, 8,68,275.
The present appeal is filed by the insurance company, agreed with the orders passed in ECA number 19 of 2016, dated 12th August 2020. No, there is no evidence with regard to the income.
No, my lord, they have stated that, my lord, he was working as a driver and deceased was having 650
Please come
per
to
day.
that particular paragraph
Para
where it
13.
is decided.
Para 30.
Read.
The petitioner have contended that the deceased was having income of 650 per day. The deceased was the driver of maxi cab. His driving license shows that the first issued the license on 1978, driving license, transport so and so, so and so. Further, my lord, the experienced driver
So
considered
there
the
is no
fact
other
of
evidence except the
oral evidence.
The what is that license?
No, my lord, not
Agreed by the
employer
orders-
also not
agreed by the orders
disabled.
passed in ECA number 19 of 2016, dated 12th August 2020. The claimant is before this court. The insurance company is before this court questioning the quantum of compensation. Land counsel appearing for the insurance company submits that as per the notification issued by the government, the minimum wages for the year 2000.
31 12 2010, my lord.
31/12/2010 when the accident had taken place
On
is
17/10/2013. Accident taken place 17/10/2013.
17/10/2013, and as per the notification, the minimum wages are 8,000.
8,000.
8,000, and the tribunal had taken the income, that is 500 per month, means 15,000
15,000.
15,000 per month. It is submitted that when there is no other evidence to show what is the income of the claimant, the court has to consider the minimum wages as per the notification. He submits that the compensation that is awarded is on the higher side. This matter came up on This matter came up on 17/4/2025, and on the day, the counsel for the appellant, and there was no representation for the respondent. Hence, the matter was directed to be listed under part heard today. Today also, there is no representation. On behalf of the respondents, there is no representation on behalf of the respondents. Hence, having heard the land counsel for the appellant claimant, there is a material on record. This court, the tribunal, without any basis, had taken the income at 15,000 per month, as rightly contended with the land counsel for the insurance company. When there is no evidence on record, the amount has to be taken as per the notification, and as per the notification, as on the day the accident has happened, the minimum wages of 4,000, and the factor is 113.77.
Minimum wages 8,000.
8,000. Minimum wages 8,000, and as per I remember Remember that on the other occasion, who submitted? Somebody like Mr. Ravish Beni, I think. You were saying that it is it so? The other day you were saying 4,000, 8,000, 8,000, even in the earlier line also 8,000. Then the factor 113.77, it comes to 4,55,080. 5,000 towards
Funeral expenses.
funeral expenses. It comes to 4,60,080. Accordingly, the appeal of the insurance company is allowed, and the compensation partly allowed, and the compensation is reduced from 8,68,275 to 4,60,080. The amount in deposit shall be forthwith transferred to the trial court, and if
No, we have
any
deposited
excess
before
amount
MSC.
is deposited,
We have deposited before MSCT.
there only.
8,68,000.
If excess amount is deposited, the insurance company is at liberty to withdraw.
Delay.
Yes.
93 days delay in filing. 93 days delay may be condoned.
IN number so and so is filed to condone the delay of 93 days for the reason stated condoned. Next file.
Number 5, P.C. Shivane Gowda for appellant. Adish Ganapati.
Insurance company appeal only on quantum.
Only on quantum.
2017 is the accident.
Case of
Right.
death or injury.
Death. Major sons, malad. 50% only deducted before the MSCT.
Then what is your difficulty?
So 13,500 was the monthly income taken. 2017 accident. 11,000.
What is the material before the court?
No document were placed. Only 11,000 has to be
Come
taken.
to that particular paragraph. Come to that particular paragraph.
My file is misplaced. Therefore, I have noted.
Let me see. Give him the, if you have the trial court record is there in that.
No document were day before yesterday. The file was with me, Melad. It was misplaced now. That is the only point. 13,500 is on the.
Look at it. We'll look at it. What is the case and according to them, he's earning 25,000 per month.
Please.
From fishing activities. The petitioners have stated that at the time of the accident, the deceased was earning 25,000 for his livelihood from fishing activities. To prove the same, have produced bank passbook of the deceased, Exhibit P 14 and 15. On perusal of 14 and 15, it could be seen that deceased has account in Indian Overseas Bank, at Kutpadi, Udupi, as well as account in Corporation Bank. On perusal of Exhibit P 14, it could be seen that it pertains to the year 2013. This accident took place in the year 2017. The passbook could not help to prove this so. Exhibit P15 passbook contains the transaction of money from the month of May 2015 till April 2016. On careful perusal of the account statement, it could be seen that deceased has certain income and he was having income around 13,500 per month.
But basing on the bank statement, can it be prove the income, Melad?
Why not?
How can Melad for any other
For
transaction?
example,
Melad,
every month, every month there is a definite income.
correct, Melad. If he is doing a business, some transaction will be taken place. What was his net, the income, net income, it was not disclosed from that record. Therefore, my notional income has to be taken. If they produce some document from the certain sources of income, he is getting Milad, court can. But here is Milad only on the transaction, income cannot be taken into consideration.
It's the only ground.
That is the only road. And the major sons are the
And your 50% is deducted. You don't have to go into that aspect.
correct. 11,000 has to be taken instead of
The insurance company is before this court agreed with orders passed in MVC number 1096 of 2018, dated 1st February 2021. The claim petition is filed seeking compensation of an amount of rupees 20,60,000 for the death of the deceased in the accident. It is a case of the claimants that the deceased is doing the fixing activities and earning an amount of rupees 25,000. The tribunal had taken 13,500 as the income and granted the compensation. Agreed thereby, the insurance company is before this court. When counsel appearing for the insurance company submits that there is no evidence to come to the conclusion that the income of the deceased is 13,500. In that case, the court ought to have taken the notional income into consideration and not to have granted the compensation. It is submitted that taking the income at 13,500 is without any basis, and the amount that is granted with the tribunal is on the higher side. This matter came up on the last occasion, and even on today, there is no representation on behalf of the respondent. Hence this court is proceeding to decide the appeal on the merits of the matter. Next, for having heard so and so, there is a material on record. This court on at para number 20 and 21 of the award, the tribunal had discussed about the income of the deceased. The court had considered Exhibit P14 and P15. Those are the bank statements of the deceased. Exhibit P14 pertains to the year 2013. Then the accident had taken place in the year 2017. Court had not considered the same. Then Exhibit P15 passbook contains a transaction of money from the month of May 2015 till April 2016. Then the court found that for the whole year, the income, a certain income of 13,500 is found from the passbook. Basing on that, the court had arrived at the conclusion that the deceased income is 13,500. The submission of the learned counsel for the insurance company that unless and until there is other evidence to show the income, the court cannot take the said income into consideration is without any basis. When the bank statement shows that every month a person is receiving 13,500 and that is almost for a year, it is showing before the accident. In the considered opinion of the court had rightly taken the income at 13,500 or 500, and this court finds no reasons to interfere. Accordingly dismissed.
interest.
Amount in deposit shall be forthwith transferred.
Much.
Yes, next.
Cell number 6. Cell number 6. Gopal NT.
This is an appeal of 2018. Even till now, the respondents are not served and no steps are taken by the appellant. This matter came up before this court on 24/2/2025 before the other bench. There was no representation. Again, before this bench on 17/4/2025, there is no representation. Hence, this matter is directed to be listed in the caption for dismissal. Today also, there is no representation. It appears that the appellant is not interested to pursue the matter. Accordingly dismissed. Next, 7.
7.
Second is,
R. Lakshmana.
let we have satisfied the award.
You're satisfied?
He's entitled for little enhancement in the case, in this case. And the head of parent suffering another 10,000 rupees. Food and attendant premises another 21,000. 30 days inpatient for 30 days.
Please come to that. Please come to this.
The accident is of the year 2018.
What are the injuries?
Injuries para 17 of the statement. Sustained head injury,
multiple abrasions, sutured, sustained head injury.
Head injury,
sutured lacerated on the scalp
on
and
the
multiple
scalp,
on left.
multiple operation on the left.
Fracture with hemorrhagic on both sides. Fracture of right clavicle, fracture of right scapula, pelvic fracture, fracture of right femur, and fracture of left femur. So many injuries.
He still continued in the job.
I think pain and suffering needs to be 1 lakh.
Another, I'll do.
Then medical expenses as
medical expenses are reimbursed. But he is an ex-army. And another loss of amenities, another 20,000.
Then how many days he was in hospital?
30 days. It has enhanced by 21,000, another 21,000.
Nourishment.
Amenities, another 20,000.
He was in hospital for 20,000.
30 days.
30,000.
And one more month, loss of income during later period, 18,000. 18,400. 18,400 was, sir.
Is his income?
Yes.
Later period. 18,400 into 4.
3 months, 2 months it is granted.
It should be 4 months. When these kind of injuries, generally 3. These kind of injuries at least 4.
36,800.
18,400 into 4. It comes to 73,600.
Another 36,000.
We will say against. So like every calculation we will make. Then loss of earning capacity.
Earning capacity continued in the. He continued in the job.
But anyway, you have not preferred any appeal.
Company has not preferred any appeal.
So this income is 18,400 into 12. What is the?
No, the court has taken disability of 10%.
What is the evidence of the doctor?
I don't have the papers. Sorry. The doctor's evidence is he's a non-treating doctor. It's at
stated that he has 12% of right arm component,
para 17,
23% of the left arm component, 25% of the right lower limb, 35% of the left lower limb, and to the whole body of 30%. With all these injuries, how can it be 10%?
He still continued in the job. That's my contention. The company did not challenge the coordination.
We'll at least take it 20%.
I do. 15%. 15% could be taken.
What is the multiplier?
Multiplier is 14. It's 14. 42 years.
14.
Yes.
It is coming to 4,63,680. Then loss of amenities?
Another 20,000. Because again, they will come up with an application and recalling. That could be avoided.
Future medical expenses?
He's an ex-army and he got all reimbursement.
No. What was the evidence of the doctor?
It is the reimbursement is referred to at page para 14 of the judgment.
Para
examination.
14.
Para 14 of the judgment. 5th line, he took treatment as an inpatient for a month. Admittedly, he is an ex-army person and inpatient bills are reimbursed.
What I'm asking is the doctor's evidence with regard to the future medical expenses.
I'm sorry, it's not forthcoming in the judgment.
I think it is there somewhere.
It's not forthcoming in the judgment.
23. Rupees 60,000, he said. Court had granted 50,000. Will grant 60,000.
Yes. Another 10,000.
It comes to 8,25,330
Yes.
against the
5 lakh
awarded amount of
5,22,970.
5,22,970. Agreed with award passed in MBC number 4177 of 2018 dated 17 January 2020. The claimant is before this court seeking enhancement of the compensation. Filed seeking compensation of an amount of rupees 15 lakhs for the injury sustained by the claimant in the accident. As per the wound certificate, the claimant had sustained right clavicle fracture, right scapular neck fracture, comma, multiple rib fractures, comma, bilateral femur subtrochanteric fracture, comma, right superior public rami fracture, left ISCHIO pubic rami fracture, left actabular posterior column fracture, left humerus midshaft fracture, radial nerve palsy and other grievous injuries all over the body. And he underwent the surgery. As per the evidence of the doctor, he had sustained 30% disability. When it comes to the income, court had taken 18,400 and granted 2 months income as loss of income during the later period. When it comes to the disability, court had taken 10% and granted the compensation. Though this matter, when this matter was listed before the court on the last occasion, there was no representation on behalf of the appellant, and some matter was listed today under the caption for dismissal. Today also there is no representation, considering the fact that this is an appeal of 2021. This court is proceeding with the matter on the merits of it, and counsel appearing for the respondent insurance company submits that there are no grounds to enhance the compensation, and the compensation that was awarded is just and reasonable. Next, for having heard the counsel for the respondent peruse the material on record concerning the multiple injuries sustained by the claimant under the head of pain and suffering, this court is granting 1 lakh, and for the medical expenses, court had rightly granted. Coming to the food, nourishment and transport for 30 days hospitalization, this court is granting 30,000. For the loss of income during the later period, this court has inclined to grant for 4 months, that is 18,400 into 4 is 73,600. Coming to the loss of earning capacity, considering the injuries, this court has inclined to take 15% as disability, that is 8,400 into 12 into 14 by 15 into 15 by 100 is 4,63,680. Towards loss of amenities, this court is granting 40,000. Future medical expenses, as per the evidence of the doctor, it is 60,000. Court had granted 50,000, and this court is granting 60,000. In the light of the law laid down in Make Allowances, so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 8,25,330. Accordingly, appeal is partly allowed, enhancing the compensation from 5,22,970 to 8,25,330. Enhanced amount shall carry 6% interest. Yes, next. Look at it if there is any delay in that. If the delay is there for the delayed period, not interest.
Cell number 8, Manjunath ND.
Yes, Mr.
Janardhan
Janardhan
Reddy
Reddy.
for R2.
Pay and recovery, my lordship.
Pay and recovery. And they're seeking enhancement also.
Yes, my lordship.
Pay and recovery on what ground?
Lower court already awarded pay and there was no driving license as on the date of
Already awarded pay and recovery. Then what about
enhancement
no,
because
but in that pay and recovery case, respondent needs to be served.
yes, my lordship. That's last occasion also 17th for the steps to be taken. They are not taken steps also, my lordship.
But it is for dismissal.
Yes.
So this matter, this is an appeal of 2021. Even till now, the owner of the vehicle is not served, where the trial court had applied the principle of pay and recover. When this matter came up before the court on 17/4/2025, as there is no representation, this matter was actually listed today on the caption. Same. Today also no representation. Dismissed for non-prosecution.
Cell number
Yes.
9.
Yes.
Petitioner.
Await service of notice list after list after service, interim order is there.
Interim, yes.
Earlier granted is extended till the next date of hearing. Next matter.
Number 10, Chandrasekhar P. Patil.
Today only we got
It is
served, my
submitted.
lord. Today only we got served the notice, my lord. I may be permitted to file wakalat on behalf of respondent.
And you can proceed with the matter.
I pray for time next.
So and so submits that he has instructions to interim order earlier, and he'll come up with objections. Interim order earlier granted is extended. Pose this matter after vacation, give a date.
Seeking for a transfer of petition on Monday or Tuesday. Madam.
You have a stay?
Please.
Yes. Next 11.
Cell number 11.
Sure. My lord.
In the name of, it is submitted that as per the order passed by this court, the hand summons are served on the counsel appearing for the respondent. Counsel for the respondent, Ms. Jyoti, Registry is directed to print the name, list after vacation. You have interim order.
Yeah.
Interim order earlier granted is extended till then. Yes, next.
Cell
12.
number 12. Raghu MN.
What are the office objections?
My lord, the both cases are in same district.
Huh?
Both cases are in same district but different taluks. It is distance is 90 kilometers.
No, the office objection is you should have filed an application before the district court.
On section 24 is very clear. Either High Court or District Court.
That
can
is
file.
true. But you have an option. Why High Court is having no work?
That
You
already
should come.
filed.
You should come to the High
It is
Court for
already
a
filed.
remedy which you have before the trial court.
Yes, my lord. That is also, she is in available for Bangalore. That is
No, there should be some good reason
reason.
for
but-
coming to the High Court.
But already filed it, my lord. But that is the
And what are the other objections?
other.
Give that. What is the distance between both the places?
My lord,
What is the distance?
90 kilometer, my lord.
The office objections or overruled. The petition is filed seeking transfer of MC number 16 of 2025 pending before the senior civil judge KMFC at Shikaripura to the senior civil judge and JMFC at Bhadravati, Shumoga district. It is submitted that the distance between both the places is about 90 kilometers and it is difficult for the wife to travel. Considering the same, there shall be stay of all further proceedings. And summons on the council and a memo to that effect shall be filed by 12th. If it is filed on 12th, listed it on 13th, or else the stay granted with the court stands vacated. Yes, next.
Much obliged.
July. Not July, August.
Much obliged.
Yes.
Cell number 13. Ramesh Kumar RV.
If the appellant,
Umayesh.
Lord, I just, my lord, apologize to my lord. Lord, I've received it is in order. I have to place it in record, my lord, the translations. Kindly, I mean, days accommodation, my lord, I just filed it. It is not in order, notes.
Post it after vacation.
Cell number 14. Ingaraja MN. Navish Penny for R1.
Memo for dispensation is filed. Memo for dispensation is filed.
Who is fetching a dispensation of notice to R1, taken on record and dispensed with. This is matter after vacation. Yes,
There is
next.
time for taking
Cell
steps.
number
There is time for taking steps, my lord.
There are R1 and R2.
Yeah, my
R1 you're seeking dispensation.
Yeah.
R2 is served. For what steps you want time?
Trying time for.
Huh?
Trying time, my lord. For further steps.
That's what I've already posted it after vacation.
Okay, ma'am.
Yes, next.
Cell number 15.
Appearing for appellate.
Ingaraja MN.
For the rest.
And the postal share shows that the notice to R3 returned unclaimed amounts to deemed service of notice. What is the
Quantum,
matter?
let's wait.
Quantum. To whom?
Liability against company only, my lord.
Already second respondent so and so. Not required. Yes. View the file.
Actually, date of action to 2011, my lordship. The tribunal was taken 3,000 instead of 6,500.
Case of death or
Death, my lordship.
please come to that table.
Para 24,
2011 is the accident.
Yes, my lordship.
2011. Then
6,500, my lordship.
It should have been 6,500.
Yes, my lordship.
How many are the claimants?
Mother and brother, bachelor, my lordship.
The
50%.
bachelor. Future prospects at 40%.
40%, 2,000, my lordship. 2,600.
Comes to 2,600.
9,100. 50%, 4,550 to 12 into 18.
50% is 4,000?
4,550, my lordship.
550 into 12?
Into 18. 9,82,800, my lordship.
9,82,800.
800, my lordship.
Then how many are the?
Mother and brother, my lordship.
Only two.
Two, my lordship.
So 88,000.
88. And 30,000 is the funeral.
36,000.
36, my lordship.
10,000.
Yes.
It comes to 11,16,800.
Yes, my lordship.
What was granted by the tribunal?
Tribunal. 2,39,000.
2 lakhs?
39,000, my lordship.
Substantial increase.
Yes, my lordship.
Please come. Which is the MVC?
MVC 573, my lordship.
573. Agreed with the award pass in MVC number 573 of 2012, dated 8th March 2016. The claim is before this court. The claim petition is filed by the mother and sister.
Mother and brother.
Mother and brother for the seeking compensation for the death of the deceased in the accident. It is their case that is working as?
The agriculture, they have not said anything.
And what is his income according to them?
7,000, my lordship.
It is stated that the is working as agriculture coolie and earning an amount of rupees 6,000. And the tribunal had taken
3,000.
3,000 and granted compensation of an amount of rupees 2,39,000. Ex parallel counsel appearing for the appellant claimant submits that when the accident had taken place in the year 2011, the court had taken 3,500 as income, which is on the lower side, and that needs to be. And the court ought to have taken 6,500. Future prospects were considered.
Yes, no, earlier, no.
And it is submitted that the future prospects were also not considered by the tribunal, and the compensation needs to be enhanced. Next parallel, counsel appearing for respondent insurance companies submits that the compensation awarded is a just and reasonable compensation, and no enhancement is called for. Next parallel, having heard the counsel so and so. This accident has taken place in the year 2011, though there is no evidence on record with regard to the income. Considering the chart prepared with the Legal Services Authority, this court is taking the notional income at 6,500. Considering the age, future prospects at 40% would come to 2,600. That is 9,100. As is a bachelor, 50% has to be deducted towards the personal expenses. It comes to 4,550 into 12 into 18. Towards loss of dependency, it comes to 9,82,800. For the mother and the brother, for the two dependents on the head of consortium, 88,000. Funeral expenses, 36,000. In the light of the law laid down in Mekala also so and so, 10,000 towards legal expenses. Altogether, the claimant is entitled for an amount of rupees 11,16,800. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 2,39,000 to 11,16,800. The enhanced amount shall carry 6% interest.
Delay.
How much?
360.
It is already condoned.
No, my lordship.
The IN number so and so is filed to condone the delay of 316 days, and the same is condoned on condition that they will not be entitled for interest. That calculation. Yes, next. Yes, 16.
It's
United India, you appear.
Connected, this is connected, my lordship.
Connected to this.
I have to take notice.
Mr. Shall we dispose of? Or you want?
Waste time, my lord.
What is there basing on, no, like how it has happened in the other case, like that we'll dispose it of. Take that, give him the papers, we'll see. The, Mr. On behalf of the respondent insurance company, Mr. So-and-so is directed to take notice and he submits that he'll file wakalat within 1 week. Yes, please come to the table.
Para 25, my lord.
Para 25.
Yes, my lord. 576 of MECMR.
4135. There is no table, I think.
Yes, no, ma'am.
So let's come to the case of injury.
Yes, my lord.
Let's see the pain and suffering. How much is granted?
My lordship, 20,000, my lordship.
Let's see the injuries.
Injury, the exhibit P14, the disability certificate issued by the medical officer who is examined as case of commission as per P14, the petition has a loss of 70% of physical function of each limb and 4% additional weightage given to the dominant upper extremely. The total disability considered by 20% upper limb and 1/4 of disability is whole body. The petitioner aged about 26
Where
years.
are you reading?
Para 25, my lordship.
Paragraph. I think there is a wrong bundle, I think. MBC number is?
MBC 576, this is connected with
No,
common
give
judgment.
the other.
Common judgment.
This is not, no, this is a different matter. This is 4135 of 2017.
Connected. This is 349 connected, my lordship. Sorry, my lordship. 349 of 2018 connected. 576. I think that matter is interested.
That is, where is that? For this 16, what about R1? Liability on whom in this matter? 16?
I don't have any papers.
No, let me look at it.
You don't have papers.
The impetus itself is dismissed. Notice it is unclaimed. As per the postal shera, notice to R1 is unclaimed, amounts to deemed service of notice. Next, I number 1 of 17 is filed to condone the delay of 484 days, condoned on condition, admit post of final hearing, registry is direct to call for the DCR. Next 17.
17, K. Srinivas.
Each time I take steps. The owner of the vehicle, claim petition is dismissed.
R1, liability is on whom?
Owner of the vehicle. Claim petition is dismissed.
Dismissed. Finally, a week's time.
Please.
Default order. Next 18. United India Insurance Company.
New India.
New India Insurance Company, you are there. You appear? New India?
New India Assurance.
Janardhan Reddy takes notice is directed to take notice and then counsel for the appellant shall serve the copy of the appeal memo on the counsel. Yes.
Please.
Cell number 18. Ayavanna. 50 days.
Yes. A week's time finally, or else the appeal shall stand dismissed for no notice to R1. Yes.
Cell number 19. 19.
Liabilities on whom?
R1. Insurance company.
And then file a petition for dispensation for R2.
Please, I'll.
Write and give. A memo is filed.
Please.
Seeking dispensation of notice to R2. Dispense with at the risk of appellant. You have the papers in this?
Yes, ma'am.
Anupsita Ramarao.
Yes, ma'am.
Can we decide?
Yes, ma'am. The injury.
Case of death or injury?
Injured, ma'am. Aged about 8 years. Student, ma'am.
8 years.
8 years.
Then what is the disability? In that case, again, that issue will come.
Yes.
Whether to apply Master Mallikarjun or.
Lordship, 11%, 22% is the lower limb and 11% is the whole
For
body.
this, because again, that issue will come. Um, Admit post of final hearing, registry is directed to call for the DCR. Next,
Number 20, Raghu or
I have for recalling the order dated, my lord.
Huh?
I have for recalling the order dated
What is the order?
DNP order, my lord. Dismissal for non-prosecution order.
Why you have not appeared before the court?
I am filed no objection wakalat and now appear, my lord.
Huh?
I have filed the no objection wakalat and
So it is not an exemption. You are
My lord, yes, my lord.
representing your client.
kindly see the
Where is the order?
order, my lord. Not comply the office of objection, my lord. Some records are not there, my lord. Office of objection not complied, my lord. Two objections are there, my lord.
Order dated?
Order dated 25/9/2019, my lord.
20?
5/19, my lord. To 25/9/19, my lord.
For that, when did you file an application?
Now we filed the application.
In 25?
Yes, my lord.
For an order that is passed in 2019?
My lord. For recalling the order.
Hmm?
Recalling the order dated.
Why should we recall the order? What your client is doing for the last 6 years?
My lord, he is having a disability of 75%, my lord. 25% whole body.
Nobody asked him not to prosecute the matter. And how come he had suddenly came to know about
My
this
lord,
after 6 years?
My lord, in para number 5 of my application, my lord.
So we will say, right from 25/9/2019 till now, you'll not be interested, you will not be entitled for the interest. What is the now, at least even now, what is the stage of the process to the respondent?
My lord, that is the stage of office objection, my lord.
First comply, then we will see. Pending IA number so and so, the appellant shall comply with the office objections. If all the office objections are complied with, this is matter on Saturday.
Saturday, my lord. One day, my lord.
Huh?
Next week.
Why?
One day is there, my lord.
Huh?
Only one day is there, my lord.
You can't comply. List on Monday.
Monday.
28/4. Case number 21, Mohan K.
The claimant's appeal, my lord, the term deposit has become matured. I am seeking the order of this honorable court to read.
Fifth respondent,
Huh?
the matter itself may be disposed of.
No, what is the difficulty in
5
the
years.
MFA of, let us, I number 1 of 25 is filed. Release of the amount in deposit before the tribunal.
And the term deposit
Term deposit before the term deposit. Accordingly,
in
permission
syndicate.
is granted. I number 1 of 25 is allowed.
Much
Yes,
obliged.
next.
Case
Post
number
after vacation.
22 for admission, N. Gautam Raghunath.
For the petitioner. My lords, on the last occasion, a submission
The
was,
file.
on the last occasion, a submission was made that the GNWC is disposed of, but para 11 of my petition wherein I've stated that.
Where is he?
I'll just pass the judgment. The GNWC has been reopened. Thereafter,
That we will take, but he is not there after vacation.
my lords, interim order may be extended. my lords.
Interim order granted is extended till then. No
Great.
representation for the respondent. Next 23.
Number 23,
23, my lord, wife's petition for transfer.
From where to
Once-
where?
From Holenasipura to, from Bangalore to Holenasipura, 170 kilometers.
The present petition is filed seeking transfer of
Bangalore to Holenasipura.
transfer of MC number 97 of 2025 pending on the file of the principal senior civil judge Bangalore to the principal senior civil judge Holenasipura.
Holenasipura.
The distance is?
170 kilometers.
Yes. And for this also, my memo in the month of August, had someone's memo. Yes, next.
case number 24,
Wife's petition, my lord, seeking transfer from Davangere to Sorba. Last time and summons was issued. And the distance is 136 kilometers, my lord. And wife's petition for maintenance 187 for 23 is
Petition
pending.
seeking transfer of MC number 212 of 2024 pending on the file of the
Family
Court
Court,
Davangere to
Senior Civil Judge Sorba.
the
Senior Civil Judge Sorba.
to the civil judge at Soraba.
Please.
It is the facts of the case are the marriage was solemnized between the parties on 28/1/2017 in view of the differences between at Sirsi. In view of the differences between the parties, the parties started deciding separately, and on 17/6/2019, the wife had filed criminal miscellaneous number 83 of 2019, seeking maintenance before the courts at Sorba.
Please, please.
At Sorba. Thereafter, on 18/12/2021, a compromise order was passed and criminal miscellaneous number 83 of 2019 on the undertaking given by the husband that he will lead marital life with the wife as later as it didn't for fructify. Then again, criminal miscellaneous number 187 of 2023 is filed by the wife on 14/7/2023, and an interim order, interim maintenance of 7,000 was granted. Thereafter, the respondent filed the MC seeking dissolution of marriage on 29/5/2024. It is submitted that the distance between both the places is 136 kilometers and it's difficult for the wife to travel. Next para, the council has taken out hand summons on the council appearing before the trial court and filed memo to that effect. In spite of the same, no wakalat is filed on behalf of the respondent. Next para. Considering the fact that already the criminal miscellaneous is pending on the file of the courts at Sorba, and the distance between both the places is about 136 kilometers. This court deems it appropriate to allow this petition. Yes, next.
Then number 25, Anil R.
Appearing for petitioners, my lord.
For the respondent, my lord, I have filed a wakalat in the counter, my lord, in the morning, and I have not received the petition and the annexures copies, my lord.
Stay is there.
Pardon? There is no stay, my lord. Kindly grant the stay order. There is a petition copy. I'll serve now.
It is husband's petition.
Yes, my lord.
I'll file objections, my lord.
File objection.
Kindly grant the stay order, my lord. Because the only 20 kilometers and already she is appearing before the family court in Mysuru. Why I sought for this transfer means, my lord, in Nanjangoodu court, it is a senior division where the senior division is having
20 kilometers. You can also appear.
No, my lord, I am working, my lord. I am working. I'm unable to travel. And also the senior division is having multiple cases other than.
Objections will consider our objections and then we'll see.
Kindly grant the stay order, my lord, because hand summons was served and the respondent is already before the court.
Please summons was served, my lord.
Yes, my lord, I produced the copy also.
For granting stay,
Yes,
court has to first convince.
Yes,
because
my
other
lord.
side appeared
After vacation, the matter may be listed by kindly grant the stay order, my lords, because parallel proceedings between two different places. I sought for divorce. She sought.
After vacation. Yes,
kindly grant the stay order, my lords. My lords, very much needed, my lords. Otherwise, parallel proceedings between two courts, my lord. Two different
vacation,
courts.
there is nothing much is going to
No,
happen.
as soon as the vacation in Nanjangoodu, there is a date, my lords, because I cannot take further adjournment. Kindly grant stay order. This is not the normal petition because I sought because only multiple cases are there in Nanjangoodu court, my lords.
Number 26, Suresh M. Latur.
Yes.
For appellant, R. Gopalan.
My lord, kindly pass over, my lord.
Go pass over after vacation. Yes, next.
Then number 27, Nagabhushan S.
Appearing for the
27.
appellant, my lords. Pray
Who
for
appears
short
to the
date, my lord.
Renuka,
Will it appear?
it can be disposed of.
Yes. Let appeal by the owner, my lord.
Appeal by the owner, questioning the liability.
My lord, only one, on the basis of a document, if your lordship could see that document, my lord, which is filed along with the application, it's only a certificate issued by the Transport Department of Officers Association. My lord, the
There are no other documents.
MACT has held that the owner has to pay on the ground that it
Senior
was.
wants to come or you argue?
Pray for short date, my lord. Senior is not feeling well, my lords.
Anyhow, it has to be dismissed. Let him come.
Yes.
After vacation,
Much obliged, my lord.
at the request of land council, the appellant.
Cell number 28,
Yes,
Mustaq Ahmad.
no representation after vacation. Yes, 28.
Yes, President.
A.N. Krishnaswamy.
Enhancement?
Yes, my lord, case of injury, my lord. The tribunal has
Why are
awarded.
you not coming when your matter is called? Why are you not representing?
Senior took a file, my lord, so that reason.
Let him keep the file, we'll pass orders. Yes. Come to the table.
Internal page 12, my lord, para 18, sorry, 19, my lord. The
So
tribunal has awarded
what are the injuries sustained?
injuries, my
How
lord.
many are the injuries? The petitioner has sustained 3 grievous injuries
Yes,
and undergone surgery. He was hospitalized for a pretty length of time. Pain he has suffered. We will grant another 10,000. Next, how many days he was in
The
hospital?
tribunal has considered 10 days he was inpatient. Tribunal has considered for 3 months, my lord.
I am saying how many days he was in hospital?
10 days, my lord. He has stated 4 months, my lord. The petitioner was attending his last.
So as far as conveyance transport, you are not agreed with that. 10,000 is fine.
No, my lord.
That's why I'm asking you, how many days you were there in hospital?
The hospital, my lord, 4 months here they have stated in the findings, my
Now,
lord.
where do you get it in the order?
Required for 4 months.
4
rest.
months.
Not required for 4 month rest.
We are not on rest. So then that 10,000 is fine. Next, medical expenses as it is. 65,913. Then loss of income. Which year is the accident?
2013, my lord.
Huh?
13.
13 accident. It should have been 7,000. How much was taken?
Are taken, my lord.
7,000 only taken.
12 accident.
12 accident.
Sorry, 12, my lord.
12 it is 7,000.
Yes.
How much the court had taken?
No, my lord, the future income is not awarded. The tribunal has taken 4,500.
That's what I'm asking, Mr. Counsel.
The doctor has stated.
Then what is the disability? Evidence
Here,
of
my
the
lord, one
doctor.
Dr. Rajesh has stated in his evidence
Page
that
number, paragraph number.
paragraph 17, my lord.
Please read.
The Dr. Rajesh Krishna has stated in his evidence that the petitioner has left his propounded hearing loss, my lord. But he has not assessed the disability, my lord.
Yes, some. Yes, Pradeep. Complete loss of hearing in the left ear.
CW1 evidence has to be
Huh?
CW1 evidence has to be looking. CW1 whether any stated with regard to the disability or not.
Let's see. Have the records are there?
This one.
Records are not there.
Yes, my lord.
Are not called for till now. Admit post for filing, final hearing. Registry is directed to call for the TCR. Yes, 29.
Cell number 29.
For Appellant's counsel, my lord, is connected with the MFA 8258 bench matter, division bench matter.
It has to go before the division bench. It is submitted that this matter is connected to so and so, which is before the division bench. The list is along with the.
In the meantime, I may be permitted to serve the notice to the opponent counsel.
That there you can. Yes, next.
Cell number 30. B.M.
Yes, 30.
Malaswamy.
30, I appear for respondent 1A to E, my lords. My name is shown as, my lords, appearing for respondent number 1. Maybe order to be corrected, my lords, 1A to E now. In view of the death.
You must have filed Wakalat Accord.
I have filed, my lords. I have filed.
Give the order sheet.
My lords, I have entered appearance on, my lords, 23rd April, my lords.
No. Then it must be the registry.
After the death of respondent number 1, notices are ordered to respondent number LRs of R1.
We'll record that
Yes,
you are appearing
yes.
for the.
Yes.
So what is to be
My
done
lord,
now?
kindly see, my lord. This is suit
to enforce a gift deed, my lord. Suit directing to execute the gift deed, my lord.
No stay.
No, that's why I'm stopped for a stay, my lord. Now the
21, my
We
lord.
can't grant a stay now. What is the stage of the proceeding?
stage, my lord. Now the witnesses have been summoned, my lord.
No, what were you doing from 21 till now? That's how I have adjourned this matter on the last occasion,
Yes.
if I remember.
No, my lord. What happened?
Without a stay from 21, court has spent 4 years of time on this case.
No, my lord. What happened?
Have you come for
No,
the-
it was filed as a
I
RSM
asked for the proceeding sheet also. Where is that? On the last occasion.
proceeding sheet. Sorry, my lord.
What has transpired before the trial court? And I wanted to dismiss it. Dismiss MSA on the very same, on the ground. Having wasted 4 years of
No, my
court's
lord.
time.
We have moved, my lord. It kindly see, my lord. It was earlier filed as a RSM, my lord.
Answers the court cannot. Tell you
RSM, my
what
lord.
is-
Kindly see, my lord. After it was converted, my lord, even the file was so many times you have moved, my lord, it was not traceable before the pending.
Ultimately, the result is the court has proceeded with the matter.
Pro-
You also cooperated with the trial and everything was going on. So why should we stop everything? Let that be decided.
No, kindly see, my lord. Even if the, my lord, one more round of litigation will be.
Next, list this matter after vacation, let it go on. We can't grant stay in this. List this matter after vacation, in the month of August, give a date.
No, let it be in the month of June, my lord.
Yes, next.
Great. My name may be my lord, sir. That also.
It is submitted that Mr. Rajshekhar is appearing for respondent
1A to E.
1A to E.
Yes.
Yes, it should be reflected in the cause list.
Great, sir.
Yes,
Cell
next.
number 31, AM Venkatesh for appellant, Spurti Hegde.
Where is he?
He's not keeping well.
Huh?
Venkatesh is not keeping well.
Venkatesh is not?
Keeping well. But his colleague was present.
Whoever it is, where is there? Where are they?
Maybe past.
Pass over 13 appeal.
Cell number 32,
Yes, 32.
FS Dabali for appellant.
Kindly pass over.
Suresh
Why
Chandra.
all the matters to be passed over?
Senior is engaged in another court matter.
I appeal for the respondent, they have to serve copy in this, the next appeal, where this is an appeal by the owner.
In 32.1, in which case you need to be served a copy?
32.1.
In 32.1, Mr. K. Vassal submits that the copy is not served on the council. The council appearing for the appellant shall serve. List all these matters after vacation. Yes, 33.
Cell number 33,
I'm for appellant in this. Ready or not? Kindly.
Suresh M.
You are
Lathur.
ready?
No, my senior is ready.
Oh, so even so many matters are listed. Importance should be given to this court.
He is engaged in another.
The court has no other work to adjourn all the matters and take up in the afternoon. Yes, after vacation.
Cell number 33,
33 only after vacation.
cell number 34,
Claimants, my
For
lord.
the appellant. Claim is by the.
Case of death,
Just
my lord.
Litraj.
Appeal is by the insurer. Lord, now I notice earlier, the claim, there is no, this may have to be transferred to either Kalburgi bench or this. This was under Harapnalli MSCT. Now it has gone to Vijayanagar district. So Vijayanagar district, I think this court has no.
It has to be transferred to Kalburgi bench.
Kalburgi.
My lord,
Harvard bench.
at the time of filing of the appeal, my lord,
If it is,
That is what matters. No, we can't.
then
Point of
I thought I should bring it to.
We can decide.
This is a claim, this is an appeal filed by the company challenging the liability on the ground that the driver of the.
Yes.
On the ground that the driver of the vehicle was implicated. And in the FIR and the charge and the merger, one Ravi of Masroor was shown to be the driver of the offending Tata Ace. I'm sorry, madam. The accident occurred between two vehicles, Tata Ace, insured with my company, and another motorcycle, scooter, on which the deceased was traveling as a pillion rider. There is a head-on collision, and he succumbs to the injuries, the pillion rider. There is no injury to the rider. One in the complaint given by one Basura Sopin, who was admittedly witness there, he says I inquired with the driver. His name is shown to be Ravi Masroor. That is and even in the merger also the same name is shown. But suddenly in the investigation, in the FI, and in the charge sheet, the name is changed as Shivkumar Jadar. And Shivkumar Jadar comes before the MACT and admits that I was the driver, but I was not rash and negligent. Admittedly, the owner and this person have colluded because the actual driver was not having a DL. They have implicated.
After vacation.
My lord, in this case, my lord, the charge sheet has not been challenged, my lord. I was not examined.
That's the only
my
ground
lord.
which.
It's not the ground. Why will they, sir, challenge the charge sheet? Yes,
My
next.
lord,
That's the only ground
the
on which
liability
MACT
fixed on
has,
the liability since 2011, my lord. They are not kindly allow the my withdrawal application, my lord. I have heard of it. They are not even single rupee, my lord. Death case, my lord. Therefore, at the time of accident, is deceased or 22 years age, my lord.
Crop is filed in 2023.
Yes, my lord.
After
And,
vacation, it's certified.
Cell number 35.
After vacation.
Maruti
After
GB.
vacation. Yes.
Cell number 36. 36.
230. Yes.
Number 3.
Yes, call list number 3.
Number 3. Cell number 1.
Please.
Shifat B. Shastri.
My lord, I am for appellant, my lord, there is some mistake as far as taking steps is concerned. I will rectify all the things, my lord. First one is a furnishing of PF, my lord. In 458, I will furnish during the course.
The liability is fixed on whom?
My lord, it is on owner and
Then,
the
owner is R3.
R3. I will take the steps, my lord. And the
R3 is
dispensation.
served. Mr. Shastri, R3 is served.
Yes.
No, in that
Well,
case, they're ready. They're ready with the calculation. We'll see what is
No,
to
no,
be
my
done.
lord, there is a, no, that cannot be done because, my lord, pay and recovery is a main question before this court. That is why it is to be clarified properly,
For the
my
owner
lord.
of the
Yeah, claimant is fine.
Then,
My lord, kindly have, my lord, as far as dispensation is concerned, my lord, I am not pressing that dispensation memo, and in one of the cases, my lord, it is already ordered. Recalling order is already ordered. That is why, my lord, one by one, I want to clarify, my lord. First point is, my lord, first case, 458 of 23, my lord. In 458 of 23, my lord, I have to furnish the process. My lord, notice to R1. For R1, I will pay the process, my lord. And
Who is
second
R1?
one is
Who is R1?
my lord, R1 is the owner.
You are not aggrieved by the pay and recovery.
My lord, pay and recovery is ordered, and insurance companies already satisfied the award. But the respondent owner, there is a 2 vehicles involved. That is why pay and recovery order indirectly this claimant is challenging.
Yes.
Cell number 2.
My lord, I agree for the appellant, my lord, I am filing a move for dispensation. R2.
Awaiting for the
Seeking dispensation
respondent number
notice
1.
To R2. I number 1 of 23 is filed to condone the delay of 7 days in filing the appeal condoned. You're on liability.
Quantum, my lord, TCR is required. Medical bills is disputed, and my lord, other
Yes,
rates.
I admit. Call for the TCR. Next 3.
Ma'am, I have an humble submission. They have deposited the 50% of the amount. Can you release the amount, 50%?
You have not filed any application.
We'll file in the next.
Where is the application?
We'll file in the next process.
So anyhow, it is you are only on the quantum. Half of it, let them deposit, let them withdraw.
Lord, here, raised the 2 grounds. The medical bills, my lord, advance bills are
What is
produced,
the
my lord.
difference that is coming
Please,
according
my
to your calculation? The remaining amount we will say. It won't be more than half, I think. Even if there is difference also. The amount that is deposited by the insurance company, the claimant is at liberty to withdraw, which is subject to the final result of the writ petition. Yes, next.
Cell number 3. Pradeep.
That is what? Yes.
Liabilities.
First steps, a week's time in respect of R2. 4,
Serial number 4.
memo is filed seeking dispensation of notice to R1 and R3. Memo is taken on record and notice is dispensed with. Yes, what about this?
My lord, there was
Who appears the respondent? Anup Sitaramara. Yes, he's here. It's a case of death or?
Case of death, my lord. Wife and
Yes.
my lord, 50% each was held to be liable by the two companies, my lord, that is R2 and R4, my lord.
Yes.
Liability aspect is concerned. My lord, the case of death where, my lord, wife and daughter are the claimants, my lord. In order to prove the income, my lord, there was evidence was led. His claimed income was 18,792, my lord. Salary certificate was produced, employer was examined, and my lord, the license to run the security business was also produced by the employer, and appointment letter was also produced. Lord, in spite of that, court below takes the notional income of 12,500 per month.
What was the accident?
Lord, accident was dated 4/8/2018. 45 years, my lord. Deceased was 45
Court had
years.
taken how much?
12,500. Notional income was taken. My grievance was that, my lord, there was evidence to prove that he was working as a security guard, and evidence was tendered and document were placed. Therefore, my lord, taking
Document is placed. Who was examined?
PW2 senior manager of the
What do you say?
Karnataka security.
It is stated that petitioner has produced the salary certificate of deceased exhibit P30. It's declared that he was drawing 18,000 so and so. The petitioner has considered deceased was being a secretary guard so and so. Suratkal, Mangalore, drawing 18,000 per month. In support of the senior manager Karnataka security examination, he has produced so and so.
When they're running a security agency,
yes,
if they're paying you any amount, there
yes,
should be a record for that.
My lord, we
Without
have,
that, how can the court, just like that, somebody says, I'm giving this much, how it has to be? That is an agency,
my lord,
security agency.
there, my lord, we have produced the muster roll, my lord, and the, my lord, salary payment register also we have produced.
That is not forthcoming.
My lord,
Let us see from the exhibits, then we will, if you have produced the salary register, then we'll consider what are the documents. No. From the doc, that is marked as exhibit?
That was not referred to by the MACT, my lord.
No. If it might not be referred, it must be marked.
Yes, my lord.
If you look at the exhibits, what it says, salary certificate, DL, appointment letter, license. That's it. In that case, if you want, then the matter needs to be remanded.
My difficulty was, my lord.
Let him produce his passbook. The payment is made to him to that check. Let him produce his passbook.
Then that also you can do instead of remanding. You can produce a passbook for the such payment.
My lord, may I pass on one document, my lord, just for reference?
Give it to you.
In fact, this was settled for 10 lakhs, my lord, in the Adalat, but since there are two companies, my lord, it was not settled.
Which are the companies?
I have given, my lord, all papers to my
No, which are the companies?
Ravindra. National Insurance and, my lord,
Who appears National Insurance? Huh? Who appears for them?
Ashok Kumar.
So that's not acceptable for them.
Sitaram Rao for that.
ಮಧ್ಯದಲ್ಲಿ ನೋಡಿ ರವೀಂದ್ರ.
How much was granted?
ಇದೆ ಸರ್, ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆ. ಮಸ್ಟರ್ ರೋಲ್ ಇದು.
No, 18 lakhs 60,000 is granted. Another 10 lakhs.
Yes, they have, my lord, agreed for that.
Who?
Shriram General Insurance.
On what basis the 10 lakhs will come?
Blindly. My lord, by taking into the
that 18,000.
Come proved, my lord.
No, insurance company without their any evidence on it, how will they agree for 10 lakhs?
Evidence is there, my lord. Evidence is there. If
no, let's see only this salary certificate, DL appointment.
My lord, that was, my lord, referred to in the index, my lord. But PW2, my lord, evidence, if my lord looks into. My lord, PW2, my lord, says.
No, I think it might have not come. It is not, the record is not there in this. Memo for, seems that memo for dispensation of notice are against R1 and R3. Like, maybe has taken on record notice is dispensed with. This is matter after vacation. Call for the admit, call for the TCR. Yes. In 5 also, memo is filed seeking dispensation of notice to R1 dispensed with. I think it's a owner's, I think no insurance in this. Admit post for finalizing, call for the DCR. Next 6.
Clear number 6.
Memo is filed seeking dispensation of notice to R1 dispensed with.
My lord, in this case, my lord, earlier insurance company has preferred an appeal challenging the negligence and quantum. That matter has been disposed of on 16th November 2022. After dispose of this matter, my lord, they have filed an appeal 5330 of 23. The claimant has appeared before the appeal prepared by the company. At that time,
What happened to that?
they have not filed any class. Our appeal has dismissed.
Hmm.
The last paragraph may kindly be seen. Quantum and negligence, everything has been discussed. And counsel was also appearing for the claimant. After passing of this judgment, my lord, again they have preferred an appeal.
Delay is condoned.
No, my lord, dispensation, I think, my lord, delay is
No,
pending.
delay must be there if your appeal
Delay is not condoned, my lord. Delay is pending.
Not even there. IA is not there.
IA is there, my lord, but not shown in the cause list.
Is it there? He contested that.
Yes, my lord. That's what my lord mentioned.
No representation for dismissal tomorrow. Next 7.
Serial number 7.
Appearing for the appellant in this matter, but I have paid the PF in respect, R1
Yes,
is
it is
paid.
what about
R2 is concerned, my lord.
Huh? Exonerated.
My lord, R2 may be directed to take notice to, my lord, the Shriram General Insurance Company.
Mr. Sivanagowda is directed to take notice on behalf of the second respondent insurance company. Admit post for finalizing TCR.
I have served the copy.
No, what about the owner of the vehicle is said to be served?
I have paid the PF today, my lord.
And then no admit. No, it is submitted that the process is paid for R1. Post after service of notice. Next.
Serial number 8.
Serial number 8 and 9, my lord, will take steps, my lord. Liability issues there.
Yes, first steps. 1 week. Next 9.
Serial number
9 also, my lord.
9 also. Next 10.
10, my lord, 1,50,000.
Under check.
Agreed?
Agreed.
It memo is passing dispensation of notice to R1. Dispense with IA number 1 of 24 to condone the delay of 235 days in filing, condoned on condition. Both the council submits that the insurance company is ready to pay an amount of rupees.
1,50,000 lump sum, inclusive of interest.
1,50,000 50,000 lump sum, inclusive of interest. And they'll file a memo to that effect. List is before the Lok Adalat to be
5:30.
today.
5:30.
Yes, next. 11.
Serial number 11. 11. Vishwanath K.
For this is matter after vacation. Next 12.
Serial number 12.
R2 is Shriram General Insurance.
12.
Blood accident, my lord. Case of injury, my lord.
So Mr. Sivanagowda takes notice on behalf of the, is directed to take notice on behalf of the respondent insurance company. Yes.
24/5.
R2 is the insurance company.
Yes, my lord. 24/5/2020, my lord.
The case of death or injury.
Injury, my lord.
Come to the table first.
Yes. Page number, my lord. Table, my lord, is at page number 18, my lord.
How many injuries he has sustained?
Issue number 2, page number 12, my lord.
Then in that case, pain and suffering 60,000 is reasonable. Medical expenses as
As
it
per
is.
the bills, my lord.
Please come to the table one by one. We will go.
Page number
How many
18.
days you was in hospital?
Lord, he was hospital, my lord, for 6 days, my lord.
That is also reasonable.
Amenities, my lord, only, my
1
lord.
minute, 1 minute. 6,000. What is disability?
Disability, my lord. That was not considered.
According to the doctor.
As per the doctor, my lord, 10% to the compression injury and 25% to the 1 and 2 vertebral bodies, my lord.
That is 35% to the limb.
35% to the Yes, ma'am.
And then how much will consider?
Not it has to be, should be taken as 13%.
So which year is accident?
2020, my lord. 14,500 has to be taken.
14,500 into 12, what is the multiplier? 500. It comes to 2,71,440. Loss of amenities, how much is granted?
Loss of amenities, my lord, only 10,000 is given.
We'll grant another 20,000.
And laid up period, my lord, 3 months is to be given.
Huh?
3 months, my lord.
Will come during laid up period. Quoted granted, not granted.
13,000 was
13,000 is granted, so 14,500 into 3.
balance is, my lord,
43,500. So all are covered?
Future loss of disability, 50,000 is granted.
That we will not grant because it is all. It comes to 4,66,124. Joint memo. It is submitted that the insurance company is ready to pay an amount of rupees 4,66,124 against the award passed by the tribunal for an amount of rupees 1,94,183, and they'll file a joint memo today before the Lok Adalat. Huh? 5:30. Next.
Let delay of 101 days, my lord.
101 days condoned.
Serial number 13, Tippeswamy BC.
Yes, 13. You are there in this? 13. No policy. For the steps, a week's time is granted. Default order. 14.
Serial number 14, BC Shivanegowda.
For the needful shall be done in a week, or else the appeal shall stand dismissed. 15.
Number 15,
Where is Mr. Janardhan Reddy?
15,
15. You are on what ground? Passover? Janardhan Reddy.
Yes.
Passover?
Passover.
Yes, next. 16.
serial number 16,
I will take steps for R6.
R6, as per the postal shara, notice to R6 returned as unclaimed, amounts to deemed service of notice. On what ground you are?
No nexus between injury and death.
Huh?
my lord. Liability on the ground that no nexus between injury and death. my lord.
Admit post for, notice admit post for final hearing, call for the DCR. Next, 17.
serial number 17,
Sent to R1. Postal shara left, my lord, unclaimed. R1 is the claimant.
16.
17.
17.
17, 16 is
Same. Postal shara for R1 unclaimed to deemed service of notice. Then R2.
We'll take steps to R2. Liability.
For steps to R2 a week's time. Next, 18.
serial number 18, Prakash.
Liability on you.
Serial number 18, Prakash.
Give the file. Case of death. Accident is on 13/10 20. Age.
Age greater than 55 years. Court has taken 68 years based on the PM.
Based on PM report. And what is other evidence of 55? So as per the PM it is 68.
He is a mason, 20,000.
Quota taken.
20,500 is
How much it should be?
20 lakh.
It is also 14,500 only. Then
Is the claim.
How much is deducted? Huh? We'll deduct 1/3 then. And then what else? Where else? And what about consortium?
50,000, low and affection 50,000 is more granted.
Only one. Your appeal is not there. Wherever it is not granted, we'll grant. Wherever X is granted, we'll not reduce. He has come.
By the appellant, Your Lordship.
So 2020 accident, 14,500 is taken. So nothing to be added in that.
50% has been deducted.
So 1/3 we will do it. And remaining, there cannot be any enhancement.
Yes, sir.
So come to that. So 14,500. In that, 100 into 1 divided by 2. It comes to 4,833 minus. It is 9,666 into 12. What is the multiplier? 5. It comes to 5,80,000. And 50,000, 30,000. 16, 6. So it is 6,60,000. 6,60,000. 6,50,000.
Please.
What is granted is?
5,60,000.
It is submitted that the insurance company is ready to pay an amount of 6,50,000 against the award of 5,60,000, and a joint memo is filed today at 5:30. Yes, before the Lok Adalat.
Pleasure.
Cell number 19. Petition.
Huh? Huh? In which case, next one, it is submitted. It is submitted that the insurance company has also preferred appeal. Post along with that after vacation.
Cell
Yes,
number
next.
20.
Memo is filed seeking dispensation of notice to R2 dispensed with.
There is a contributory negligence fixed on the part of the.
Admit post for final hearing.
There is a delay of 3 days, my lords. The delay of 3 days is there, my lords.
I think that is not listed anyhow. Once it comes, we'll see.
Please.
Yes, next 21.
20. VC Shivanagowda has to take notice for R1.
Oh, response Sriram. So VC Savanagowda is directed to take notice on behalf of the insurance company, and the counsel for the appellant shall serve the copy of the appeal memo. Next 21.
Cell number 21. 21.
A notice to R4 returned as unclaimed amounts to give service of notice. And as far as the second notice to R5, a week's time is granted.
Cell number 22 urgent. 23.
22 adjourned. When is it adjourned? Next 23.
Cell number 23. Ravi Shankar Shastri ji.
Service is awaited, my lord.
Liability on?
Liability on the insurance company.
Then
Income tax returns were produced, my lord, to show prove the income. That was not taken into consideration.
what do you say? Any scope for? Huh? No. If whatever is the amount that you're ready, whatever if you say, we will calculate, or else we will. You are ready for what amount?
That's what in the year 2021-22, he paid the income tax return to the 4,120,000. But he said that he is running a mechanical shop. So our contention there is no loss of income because he has not paid any income tax to show that there was a reduce in the income.
That is the usual ground. Next.
Therefore, court, without considering that, the court has not considered that personal income was taken.
It's only on the income now. What, according to you, how much it should be?
My lord, as per our claim, my lord, 4,120,000 was the income tax returns filed for the year 20.
Per month, how much it is?
35,000 about 35,000.
How much you are ready for that? 5,000 more than what?
15,000, it may be taken 20,000.
If it is, you're agreeable to that, we'll make a calculation or else we can hear it in the usual course.
Party may feel, since income tax returns are there, my lord, lordship may admit the appeal and.
Admit course of final hearing.
Please.
R1 dispense with?
Please.
R1 is owner of the
Owner
vehicle.
of the.
A memo is filed seeking dispensation of notice to R1. Mr. B. Shivanagowda is directed to take notice on behalf of the insurance company. It's 24.
Serial number 20.
My lord, liability not in dispute, only quantum. Actually, earlier, my lord, I have discussed with Pradeep. R2 is the insurance company, and we discussed for 1,72,000, my lord.
It is submitted that the insurance company is ready to pay an amount of rupees 1,72,000 against over and above or against?
Over and above. Over and above.
Over and above the granted compensation by the tribunal. They'll file a memo to that effect when? Memo when, Mr. Shastri?
Okay, insurance companies.
Today. Yes, next. 25.
25 minutes, 1 lakh.
1 lakh?
1 lakh.
Mr. Pradeep takes notice on behalf of the respondent insurance company. Next 25.
Serial number 25.
25 only.
25 only 1 lakh.
25 only is submitted. 1 lakh.
No, it's for Shripal Shastri.
Shripal says 1 lakh 70.
This is 1 lakh?
1 lakh.
1 lakh. In this also joint memo in the evening. Yes, 26.
Serial number 26 will be joint memo. 26.
What about this? For complying the office objection a week's time. Next 27.
Serial number 27. Naveed Ahmed.
Exonerated. This also a week's time.
Serial
Next
number
28.
28.
Memo is filed seeking dispensation notice to R1 and R3. Dispense with at the risk of appellant. I number 1 of 24 is filed to condone the delay of 344 days on condition. Yes.
25,000 plus 6% interest.
It's agreed. 25,000
with 6% interest.
25 agreed for 25,000 at 6% interest. Today.
The date of petition will
from the
date of petition. Here, my lord, from COVID period.
From the date of petition.
Not excluding interest for 344 days.
And 344 days, the delay for 344 days, interest is excluded. Yes. 29.
Evening. Evening only will file.
Serial number 29.
29 minutes connected matter, my lord. 90,000% same order.
90?
90. 90,000.
1,000?
Plus 6%.
Insurance company is ready to pay an amount of rupees 90,000 over and above the amount that is granted by the tribunal at 6% interest.
From the date of petition till.
From the date of
petition until the deposit.
Till the deposit.
Excluding interest 344 days.
In this also 344 days. Same. 344 days condoned on condition. Same thing should reflect in the order also.
Serial number 30.
Yes.
Girisha SN.
What about this? You have come. But in that case, the notice has to go to the owner.
Non-compliant.
You know, he has not questioned it, the owner. So it's a claimant's appeal. Can we do the correct calculation? Yes. Give that. It's a case of death or injury.
2018 accident.
Death or injury. Page number. There are two MBCs. Which MBC is this? 1693. 90. Yes. For pain and suffering, how many are the injuries? Wound certificate as sustained sutured lacerated wound measuring so and so over right forehead extending to frontal region of the scalp head with surrounding swelling. Lacerated wound over posterior aspect of the right elbow region so and so and the upper part of the right forearm with surrounding swelling. Deformity over mid part of the right forearm with painful restricted range of movement. So for the under the head of pain and suffering, head injury till the scalp, 60,000. Next, how many days he was in hospital? Hmm?
Disability was assessed by the doctor.
I'm asking how many days he was in hospital?
20 days.
50. 20,000. Then no, the court had granted 30,000. So we'll continue that 30,000 because attendant charges, amenities and it's amenities and nutrition. So 20,000. What is the disability according to the doctor? No, I think it's no, it's a boy. Aged about age of the boy. Loss of income. Huh? Loss of income to the parents is granted. Will not hear this then. Admit. No, office objections to be complied with a week's time. So complying with office objections a week's
Number
time.
31.
Yes, 31.
31. Kavita HC.
What about this? Huh?
Satisfied.
Yes.
Para 12.
12. Actually, there are 2 MBCs.
This is 844. Have 16 of it.
So, what are the injuries?
Femur fracture.
Swelling, so fracture, so said. How much is granted?
2 fractures.
How much is granted? Towards pain and suffering. We'll grant another 10,000. Then?
Disability is 12.64% is taken. 30.56% to the lower. 9.86.
According to the doctor, it is 12.64. Court has also taken the same. So, how much is his salary taken? Pain and suffering, 50,000 is awarded towards conveyance, nourishment, so and so. How many days he was in hospital? 7 days. So conveyance, 7,000. Then his salary?
He says that he was working in a supervisory hotel.
So court taken 13,000. Which year is the accident? 20. We'll take 14,500. So coming to loss of income, how many months court had granted? 2 months is granted. We'll grant 3 months. So 14,500 into 3. It comes to 43,500. Now coming to the future loss of income, 14,500 into 12. What is the multiplier? 18. 18. What is his age? 18 into 12.5. Three lakh 91,000 500. Then loss of amenities,
25,000.
that is including
Amenities only.
how much is granted towards discomfort, loss 25,000, another 5,000, 30,000. So all are covered. Medical expenses, 3 lakh 695. Any future operation? It's coming to 11 lakhs 005. 11 lakhs 5,000. Against 7 lakh 87,626. It is submitted that the insurance company is ready to pay an amount of 7 lakh 5,000 against the compensation of an amount of rupees 7 lakh 87,626. List this matter before the Lok Adalat today for filing the joint memo.
Number 32, PC Shivanji
For paying the process. This is a week's time is granted. Default order is 33.
33,
What about 33?
Girish B. Baldare,
Yes. Girish P. Baldare is for whom?
climate.
18/12/20 is the date of accident.
1812.
Wife and major sons are maybe.
Wife and major, how many are in number? Age?
Wife is
Not the wife's age, children age. 30, 28. 2 children, 2 sons, all 3 in number. So we'll consider them as dependents. According to him, what is his income?
30,000 according to them.
30,000?
According to them.
So 20 we have to take 14,500. And his age is?
68 years.
68. Where is it? Court also taken 14,500 only.
Under the convention, independent court has not granted the compensation granted. That's the reason we are.
Consortium is not granted. What is granted? Loss of dependency 11 lakh 48,000. Funeral expenses 16,000. Loss of consortium 44,000 is granted. So,
Another 2%.
no. As far as 11 lakh 48,400 is concerned, there cannot be any enhancement. So, in respect of consortium, 3 into 40, 1 lakh 20. So 1 lakh 20, 36. Yes, so it comes to 12 lakh 98,400. What is awarded? 12 lakh 25,000. That's the only difference. It is submitted that the insurance company is ready to pay an amount of 12 lakh 98,400 against the granted compensation of 12 lakh 25,400 for joint memo today.
And
Yes.
number 34,
Exonerated. Yes, for compliance with office objections a week's time. 35
number 35, Vijay Kumar P.
is also there. List along with company appeal number. So and so, give the rate, give the number.
Number ಕೊಡಿ sir. Serial number 36.
36.
Oja Raja.
Memo is filed seeking the dispensation of notice to R1.
R1.
Dispensed with. There is a delay of 438 days. Condoned on condition.
Case of injury, my lord. Date of accident is
For the respondent insurance company, Mr. Sivanagowda is directed to take notice.
on 4/10/2016.
Page number.
Page number 32, ink page 32, my lord. In MSc number 7929. Para 21.
One appears to be a case of death at page number.
First is case of death, my lord. Para page 30.
70, para number.
32, my lord. Page 32, ink page 32.
Yes.
Relevant paragraph 21, my lord.
So first of all, come to that, the table.
Please.
For pain and suffering, how many are the injuries?
Both bones of right, segmental fracture of right femur. Two.
Two injuries. So 60,000 towards pain and suffering. Then how many days was in hospital?
31 days, my lord.
31.
Please.
So 31,000. Medical expenses as it is. 44,706. Then what is this disability according to the doctor?
12%, my lord. The trial
How much
court-
the court had taken?
10%.
We'll take 12%. And income?
Income 9,500, my lord.
Which year is the accident?
2016.
2016, same.
Please.
Future 9,500 into 12. So it would be the same amount as taken.
My lord,
But
instead of 2% is extra.
9,500 into 12. What is the multiplier? Multiplier.
Multiplier, my lord, 18. Age in the year 2000.
18 into 12.
12.
It comes to 2,46,240. Amenities, how much is granted?
15,000.
We'll make it 30,000, Mr. Sivanagowda.
Laid up
And
period.
loss of earning during laid up period?
My lord, he was in inpatient on 31 days, my lord. 2 months has been granted by the trial court, my lord. Another 4 months.
Total 4 months will grant.
My lord,
9,500 into 4. It comes to 38,000.
marriage prospectus has not been awarded by the trial court.
What is the impact on marriage prospects with this injury?
But the injury is in type 2 communicated fracture of femur.
What is? No, for that will not grant. Plus 30,000. 46,000. 2, 4. It comes to 4,49,946 against 3,13,906. It is submitted by both the council that the insurance company is ready to pay an amount of rupees 4,49,946 against award amount of 3,13,906. Next, as there is a delay of 438 days, the claimant is not entitled for interest for the said period. Interest at 6%.
Oblige.
Yes, next.
Serial number 30.
Evening today for joint memo. Yes, next.
Serial number 37.
Memo is filed seeking dispensation of notice to R1 dispensed with I number 1025 to condone the delay of 68 days condone. Yes, Pramod?
It's a pain recovery order, my lord. I have discussed, my lord. 60,000 he has agreed, lump sum, inclusive of interest.
No, where are the respondents?
I am appearing for second respondent.
Be ready for R.
No, 37. Pramod. Oh,
Pramod, the claimant of
R1.
yes. Where is he? They're ready?
Yes, ready, my lord. We have discussed 60,000 he has agreed.
So it is submitted that the insurance company is ready to pay 50,
60, 60.
60 as a against,
Addition.
in addition to what has been granted by the tribunal, and they'll file a joint memo in this regard.
Pay and
Next.
recovery order has to be confirmed.
Pay and recovery has to be passed.
Serial number 38.
As the insurance company is exonerated from the liability on the ground,
No, my lord. Pay and recovery order has been passed.
already passed. Yes. Insurance, already the pay and recovery order is passed by the tribunal. Yes, next 38.
38.
Company appeal is challenging involvement of payments.
Memo is filed seeking dispensation of notice to R1 in 38, dispensed with. IN number 1025 is filed, condone the delay of 58 days, condone. Then 39 also, same memo for dispensation, delay. How many days IA 1 of 25? It is not mentioned. Look at it if it is more than 100 on condition. Admit post of final hearing, call for the DCR. Yes, 40.
Serial number 40.
Memo for dispensation of notice.
Dispensation of notice to? Yes, memo is taken and notice
I'll-
of dispense to R1
DCR may be called for.
Huh?
DCR.
is required.
Please.
Why the petition is dismissed?
No, my lord.
Huh?
Case of death may not.
Then why DCR is required?
But with regard to the income, my lord,
No, with regard to the income, there must be been a discussion. According to
Please.
you, what is your income?
income, my lord, according to me, my lord,
Give the file.
25,000 per month.
Basing on what you said, what is the evidence adduced? by
Doing,
the-
my lord, plumbing work.
No, evidence. For that you wanted the TCR, isn't it?
Please.
So please come to the award, or judgment. What are the documents? Notarized copy of the Aadhaar card, notarized copy of the DL, notarized copy of the voter ID, notarized copy of the Aadhaar card, notarized copy of ration card. These are all the documents. So what is the use in calling for the TCR? Which year is the accident?
Accident, my lord,
20?
24 to 2021,
21. Court had taken how much?
15,000.
What about the consortium and other things? If they are
Consortium
granted,
also rightly given.
Huh?
Rightly given.
So just like that appeal is filed, then we'll dismiss it. Huh? This appeal is filed, agreed with the order passed in MVC number 2056 of 2021, dated 4th June 2024, whereby the tribunal had granted compensation of an amount of rupees 26,22,500, seeking enhancement. The claimant is before this court. Land counsel appearing for the claimant submits that the tribunal had taken 15,000 as the income, when it is a case of the claimant that he is earning 25,000 and all the aspects were not considered by the court. Who appears to the respondent? Land counsel Mr. B. Pradeep submits in the docket order. B. Pradeep takes notice on behalf of the respondent insurance company. Land counsel appearing for the insurance company submits that the insurance and he will file wakalat within 1 week. Land counsel appearing for the insurance company submits that the tribunal had rightly considered and granted the compensation. This court has perused the order passed by the tribunal, having heard the counsels on either side. There is no evidence to show that he's earning 25,000. The court had rightly taken 15,000 as this is an accident of the year 2021 and rightly granted the compensation. And also, even under the conventional heads also, the compensation that is awarded by the tribunal is just and reasonable. Hence, this court finds no reasons to interfere. Dismissed. Next.
Delay of 107 days.
A delay of 107 days in filing is condoned.
Serial number 30.
40.
41.
What about this?
Kavita HC.
Yes. 2020 is the date of accident. Case of death? Injury case. Come to the table then. How many injuries? No, let's see how many are the injuries.
18 of the
Appeal dismissal. Delay confirmed.
not stated what was the issue, but he says that 10% for the order. Right public.
That pain and swelling of the right forearm, pain and swelling of right elbow, and abrasion of right forearm, and side injuries are grievous in nature.
10% liability was assessed.
Now we'll take 40,000 medical expenses as it is. 30,000. Then how many days he was in hospital?
4 days.
Huh?
4 days.
4 days.
Yes.
Court had granted 20,000. Loss of income during laid up period. Which year is this?
Only 30,000,
15,000 then. 15 into 3, 45. Then loss of future income. What is the evidence of the doctor?
10%.
No, I think it is 12%. Okay. No, if you look at, he said the limb disability is 24%. It comes to 8% if it is correctly calculated. Court had taken 10. So 15 into 12 into what is the multiplier? 18 into 10. Into 12 into 10 divided by 100. 3,24,000. Then loss of amenities, how much is granted? Another 20,000. $30,000 altogether. So it comes to 4,89,000 against 3,90,750. Same against 3,90,750 awarded amount. Insurance company is ready to pay 4,89,000. Any delay in this?
PC Shivanagowda takes notice for response.
That's fine. So BC Shivanagowda takes notice on behalf of the, is directed to take notice on behalf of the respondents. Yes, next 42.
Serial number 42.
Number 42 and 43, liability in dispute.
Liability is in question.
This question.
Post
Notice has to
after
go to the heart.
Memo is filed seeking dispensation of notice to R2 and R4. Dispensed with post after service of notice. Same 43 also same. 44.
44, I appear for appeal in this case, my lord. There's a connected matter in this. 3402 of 24, my lord. Company appeal.
Yes, list along with the company appeal after vacation. Yes,
Much
45.
obliged.
Serial number 45.
What is 45?
Office objection.
Uncomplained. Rajashekar S.
Yes, sir.
KSRTC appeal. For all complying with the office objection in a
My lord,
week's
we have
time.
already complied with the office objections.
It is submitted that the office objections are already complied with. Yes, 46. Admit, no.
46
Respondents needs to be
also,
served.
we have
Yes.
complied with the office objections. 46 also we have complied, my lord.
Yes, it is submitted that the office objections are complied with. Next, 47.
Serial number 47.
Exonerated for compliance with the office objections a week's time. 48.
Serial number 48. Pradeep P.
This case, my lord, it's a fresh matter. No?
Maintainability of
Yes,
the
the
What
office
is
has
this,
raised an
maintainability?
objection as maintainability, my lord.
No.
As per section 173 subclass 1, my lord, the amount involved is 1 lakh. Below 1 lakh, my lord, is not
Appeal is
maintainable.
not maintained.
Please, my lord, in that regard, here, my lord, claim petition filed under section 166 subclass 3 is bad will limitation. There is no sum shall be payable to the insurer, my lord. maintainability of the claim petition itself you are disputed. Therefore, it is maintainable, my lord.
No, whatever it is.
Wherever the quantum is, wherever the quantum, my lord, kindly come to
So
the, my
is
lord,
there a distinction?
173,
You
subclass 2,
that.
may kindly.
You that.
Please.
Motor Vehicles Act.
Yes.
Earlier, my lord, it is 10,000, my lord. In Yellava case, my lord, in 3 judgments of the Honorable Court has held that the pain recovery order has been passed in that. The award amount is only 1,000. The liability issue is there on that, my lord. Passenger carried in goods vehicle that.
170?
173, subclass 2, my lord.
We'll continue after lunch.
Please. I'll bring the judgment also.
On submissions, my lord. Please, serial number 22, list number 1, my lord. The case is called out at that time. I am engaging in quota number 7, my lord. That's why I'm unable to attend that case. That case is posted for dismissal, my lord. That's why no. The Allah.
Coming tomorrow.
Please, my lord.
When is it coming for dismissal?
28, my lord, please.
It will come that day.
Till then, interim order is there, my lord. Kindly extend the interim order also, please.
Look at
Sorry.
it, 28.
Apology to
Let's
this
just
honorable.
matter on 28 only. No, not in dismissal. Interim order granted is extended.
Much obliged.
Pen is not working. Pick another pen.
ಅವತ್ತೇ ಡೇಟ್
23rd and
What is this
24th.
memo for submissions?
No, my lord. On 23rd, there was no sitting before this court. And I was supposed to have, in fact, the party was supposed to.
Whatever facts you want to bring to the notice of the court, it should be by an affidavit.
Affidavit, yes, my lord. I've had, may I, my lord?
Where are the medical reports?
I've submitted along with
Take
this.
that.
I'll have.
So when is she going to be discharged from the hospital?
No, she is discharged from the hospital. There's no discharge issue with the discharge. She was unwell. My lord, if I may, page number. After the affidavit, the first one, my lord, from Motherhood Hospital. She was taken to the hospital and the remarks, my lord.
Mr. Counsel, the other day when you appeared,
Yes.
did you instruct your client properly and what is her submission? That's what I want to know.
Lord, insofar as we are willing to have the child available for visitations, my lord, there is absolutely no problem to that effect.
When is that? What is you have no problem now? You will tutor her properly to, not to look at the father, not to
Lord,
talk,
if I may, my lord.
do whatever she wants to do. And she will be sitting in a registrar's office the whole day. And the whole, this tamasha, the registrar will see and, place a report before the court.
No.
I'm telling, if the mother is going to convince the girl and see that the things happen in the manner which they are supposed to be, or else the order that is passed by Justice Erur, with all the, if required, the police force, let them take and let them execute the order.
If I may, my lord.
I don't want any suggestions. I want, how is it going to be?
In order to make that happen, my lord.
Yes.
In fact, on 5th, there was, I suppose, there was a mediation that was scheduled between the parties as well as the child before the mediation center.
What mediation will do?
If I may, my lord, if I may, please let me kindly make this one small submission, my lord. So the mediation was initially scheduled to have happened. On the day of 2 days were supposed to be scheduled. And for mediation, my lord, 2 dates were fixed. The first date, the child could not have been present because on that day, examinations were scheduled and it was intimated to the party that on the first date could not have been. On the second day, we were ready to attend that mediation also, but the party did not, that is, the petitioner did not show up. So, my lord, it all started from there. All I'm requesting is taking into account the existing circumstances. If a cycle, insofar as the
Justice Erur will confirm that order.
Yes.
And will pass, with all any
No.
help that is required.
Insofar as the order that is passed by Erur, my lord, there is a very simple point that the child, insofar as the entire.
That order is appealed against and it is.
I'm not on that, my lord. I'm not on that. My only request to this court would be on this point, that this court has also seen the fact that the child is not ready to go forward. If I may, my lord. On day one, it is not just about how the mother has made those, got the child to behave in that manner per se.
I'll tell
But
you, Mr. Counsel, before.
yes, ma'am. Yes, ma'am.
So you will also listen to the court.
Yes, ma'am.
Yes. Of all the orders that are passed, going all the way to the Supreme Court, getting an order.
Yes.
And not complying with any of the orders of any of the courts, still your client has a courage to say all these things before the court and the court has to accommodate. That is what is it what you're submitting?
Absolutely not, my lord.
Then what are you submitting?
My lord,
Why are you
insofar as
going
the
to
order.
mediation?
No, my lord, insofar as the orders, if I may, my lord. Initially, the trial court, if I'm not wrong, my lord, initially the trial court had passed an order wherein 9 visitations were supposed to be scheduled. Out of the 9 visitations, only 7 visitations the petitioner did not avail. Insofar as
Forget about
no, my lord,
everything.
I have,
Let's
insofar
forget
as
about
how
what
I have complied. What I have not complied is what I'm trying to press upon.
Mr. Counsel, in the facts and circumstances, I only want you to tell me what is that client is going to do.
My lord, insofar as I'm going to address that, my lord. Insofar as all the orders that is passed, what I have missed is, if I may, my lord, then only I'll be able to put it across. I'm just going to take 30 seconds and I'll conclude in 30 seconds. Insofar as what I have not complied by, I was supposed to take the child to the mall, which on that day, child did not come forward, and we have seen that how the child is adamant. But they were invited home. They did not come home. That could not have been complied by. Subsequent to that, 50% was ordered by this court, my lord. That, my lord, insofar as the 50% that was ordered, my client intended to challenge it. The orders were not uploaded due to XYZ reasons. It could not have been, and further it was challenged. Insofar as the order that is placed now, my lord, on 21st, my party was present here. On 22nd, also the child and the mother was present here. Insofar as 23rd and 24th, my lord, being today, unexpected circumstances, my lord, I have submitted the report. Insofar as the report is concerned, the doctor is also advised that the child needs to be taken for child counseling or psychiatry. Insofar as this,
Mother never realized that. Child requires counseling?
I am going by what this court is saying, my lord, that the child requires. I am going by what the doctor is also saying, that the child requires.
That the court need not tell you. If you are a responsible mother, if your daughter is so adamant and that her whatever she's talking, she's thinking is not as per her age, then what a responsible mother should do?
I have taken, my lord. On 23rd, my lord, insofar as what happened on 20.
Understand, Mr. Counsel, I've told you
I am
yesterday
not.
also here, you have to, when you are representing before the court, before you are advocate to your client, you are an officer of the court, please understand the situation and accordingly you make submissions. For argument, you can make 101 arguments.
My lord, I am not intending to make any argument, my lord. I am only saying that
first of
both
all,
this court as well as I am
girl-
sure the petitioner as well as
first of
myself
all,
are of the understanding that
I'll tell you what is going to be. First, let the girl meet the father.
Yes, my lord.
And because now the holidays for her?
Yes, my lord.
Holidays for her?
Yes, my lord. Yes.
So from tomorrow, that is, tomorrow is, what is the date? 25th. 25th, 26th, 27th, 28th, 29th, 30th, or continuous basis till 2nd, till 1st, she'll be meeting the father. And she will be meeting the father.
Yes.
Then, basing on what transpires on all these days, we will pass an order on 2nd, because already there is an order staring at you. You can't afford to tell the court anything else but to do what the court is telling you.
Yes, my lord.
You have to, and where is it going to happen? And with all these elements, the same thing continues. Then we have to come to give a finding that the way the girl is being brought up is not something. She's a completely tutored. So now the same, let her do the tutoring to her and tell her that she should be meeting the father, and he will not. I also told her, he will not, she doesn't want the father to touch her and all. No, he will not do. Let her sit and talk at a distance. This should happen for a week till 1st.
I am not going to state anything against it, my lord. I clearly understand this court intention is very well for the betterment of the child. And my intentions are also the same. Therefore, I will not. Only issue here is.
Then about the counseling and other things, we will do. They should be, it is not always one-sided.
On the same point, my lord, if I am permitted.
No,
I am on the same point. My lord, I am on the same point.
You are not at a position where you can have.
I am on the same point. What my lord has stated.
The father will meet. The mother will facilitate the father to exercise a visitation and will make the girl understand. Then whatever submissions you will make on 2nd, we'll listen to all that.
On the same point, my only request is, if I may, my
yes.
lord, let the father meet, let the mother also be there, let the child also be there. Along with this, let it be a counseling session itself, where all the parties are there. In fact, the mother and father and the
3
counselor.
years of tutoring is not going to be solved in one counseling.
Let there not be a tutoring itself. My lord has stated that from tomorrow.
Counseling of an hour and 24 hours, 23 hours remaining tutoring, no counselor in this world is so competent to get over 23 hours.
Let there be a counseling for 1 hour. Let there be half a day of visitation with the father on the same day following the same thing.
First of all, let this order be complied with, then we'll talk about the counseling.
And tomorrow to have the child, I'm not very much sure, my lord. Let it be day after tomorrow.
It is not.
Because of the, my lord, please, the record states that I've had the child under the circumstances that it is right now.
What are the circumstances?
My lord, if I may, the remarks, my lord. 2 dates, my lord. That is one on 22nd.
Counseled about stress management, coping skills advised.
It will be advised basing on what it is said.
And in fact, your leadership, just 2 points I want to add. When I filed this application, keeping in mind.
Crossed all the barriers.
Yes.
Mother has crossed all. Now she thinks that she can do things on her own, on whatever she feels. And there are no courts, there are no orders, nothing. What she wants and her daughter wants should prevail.
Yes,
it's the present situation.
Just two, 3 small points, just for your leadership passes in the order.
Yes.
When this writ petition was filed back in the year 2023, we had recognized that there had been alienating behaviors that had seeped into the child. Recognizing those facts, keeping in mind not how much we want to separate the mother from the child or how much we want to keep the child with us. We had filed an application for the appointment of a child psychologist as an expert to assist this honorable court back in the year 2023. Tooth and nail, that application has been opposed till date.
Where is that application?
Yes, Your Ladyship. Along with the writ petition, IA number 2. IA number 1, Your Ladyship.
I number?
IA number 1, Your Ladyship.
One is
the application. Now, I want Your Ladyship for a moment to have that application. Recognize the fact that it has been filed more than 2.5 years ago, almost 2 years ago. And till date, they have opposed.
This is not IA number 1 of which year?
Of 23. Then Your Ladyship may have IA number 2 in my office copy. Interlocutory application for appointment of child counselor under section 12.
Yes.
Your Ladyship has that?
IA number 2.
Now, that IA, Your Ladyship may just hold on to for a moment. The factum of its filing, the factum of its service, the factum of its pendency, the factum of its disputation is on record. If what the mother is saying is indeed true, how does she explain, or how can this be explained? Another matter of record, Your Ladyship may have for a moment the WhatsApp chats that I have produced as a part of my petition, not only over here, but before the trial court. The mother's behavior, or rather parenting, and I'm sorry to say this, is one that not only has been creating alienating behaviors within the child, creating a feeling of reluctance to meet the father, but furthering them. When the grandparents, against whom on record there is no allegation, at least as far as the trial court was concerned, at least as far as this is concerned, made pleas that Swadha se baat karao, they are speaking in the vernacular on text. She says she does not want to speak. I'm not going to force her to speak. If the mother was truly concerned that the child have some form of a relationship with the paternal side, then at least there should be one response to the effect of saying, I'll try. Let me try. The responses are always, I am busy. She does not want to speak. Don't force her to speak. She is a child, not a toy. That's the conversation that's been had. And I'll take Your Ladyship through that. For a moment, Your Ladyship may have these conversations. If the mother truly had an intention to ensure that the child's welfare was taken care of, that she truly had a relationship with her father's parents, then from the year 2022-23 onwards, the cultivation of alienating behaviors in the daughter would not have been commenced with. That has resulted in a child who till the age of 6 or 7 was frolicking with her grandparents, as evident on the record. Photographs are there, videos are there. Between 7 and 10, a very formative age, developing a deep antagonism towards her parents, towards her father and his parents. Those 3 years, even if now she's realizing that her sustained non-compliance can be in some manner conceded with by appointment of a child specialist, what was causing her to be reluctant to appoint a child specialist when I first asked for it? This was an application I filed in the trial court as well. If she truly had her child's best interest at heart and not the interest of alienating the child from her father, then why would she object to it? On the very first hearing, when Your Ladyship heard the matter in 2023 in March, 24 March, I had said, let this application be allowed. It may not be in the memory of the court, but I remember very clearly the counsel on record said, no, there's no reason. Why should she undergo psychologist sessions? You're going to create a further difficulty in her mind. All of these matters are on record. And as far as Your Ladyship's order regarding mediation is concerned, it was a discussion between the court and the parties. When will the child and the mother be available? Your Ladyship will recall she said she's available on this date. On her convenience, I decided to fly down. And we had understood and realized that one mediation session may not be enough. That is why 2 days were asked for, back to back. If you don't come on the first day, after the father has flown down, what's the point?
What about the cases between the parties, apart from this?
There are 5 cases, Your Ladyship. 7 cases, Your Ladyship.
What happened to the matrimonial?
It's pending at the stage of pleadings. I have
filed the divorce.
Both have filed divorce against each other. Both have filed divorce against each other. She's filed a case against me and my father in relation to 498A and 506. There's
both of you want divorce. Who is stopping you?
Nothing is stopping us from getting a divorce. In fact, what happened in the Supreme Court between 2014 and 2024 and 25, when the settlement was being mooted, was that parties would separate, there would be a judicial decree of divorce by consent, but she retained custody and visitation without access to me. When I initially decided I'll go through with it because of the pressure of the matrimonial and criminal litigations on me, the settlement was agreed upon in writing. But immediately thereafter, a week or two thereafter, I realized that I cannot have a situation where I have zero contact with the daughter. My parents are restricted from having any contact with the daughter. So I filed an affidavit in court, all of which are on record of this court as well, saying I don't mind separating, but I cannot have a situation of no access. Even today, I am stating on record, I don't want full custody. You keep custody, but give me some modicum of a relationship with my daughter. I have till this date, from the date on which I filed this petition.
Oh, no, there is no dispute on alimony and all?
There is
So
no
also-
alimony.
She's not asked for it. She's filed a petition under the DV Act claiming some amounts. She has not pressed it. And in fact, as far as that allegation is concerned, she has stated very clearly she's financially self-sustainable. At one point when your ladyship was hearing the matter and thereafter Justice Yerur was hearing the matter, she said, as again a way of justifying her non-compliance, that if you're so interested in meeting the child, why aren't you bearing her school fees? I immediately said, I'll bear the school fees, even without an order. And those school fees have been borne. Even to this date, I'm stating, if you have, for example, a request for me to bear or a demand for me to bear childcare expenses to the best of my financial ability, I will bear them. Give me an opportunity to at least have a relationship with my child. Now, as on date, parties have means, but parties don't have infinite means. From the day on which this petition has been filed, from every time there has been an increased order of visitation, I fly down, sometimes on my own, sometimes with my parents, at my own expense. Till date, I've spent around 6 lakhs on just air travel. Now, if your ladyship, if they say that, okay, we will comply with this order, whatever your ladyship passes, and suddenly I fly down at my expense, and she does not comply, and she does not bring the child, then again, I'm out of pocket. The only request I have, your ladyship, is the order that has been passed by Justice Yerur, which was taken to the Supreme Court. There is enough and more basis on which that can be restored. The addition I would want to it is that for the remainder of the summer break, let me have custody. After that, your leadership can take the matter up for further hearing on not only the issue of the final decision in the writ petition, but also on the appointment of a childcare expert or a child psychologist. In fact, I'll go to the extent of stating right now that if your leadership says that bring us a list of child psychologists that you can have the child visit during my visitation with her, I'll provide 2-3 experts that I can come up with and let them also consent to it. While she's with me, we'll go for childcare counseling sessions and let the lady come to Gurgaon. I have made so many trips to Bangalore without having any benefit of those trips being given to me. Let her do some work now. I'm not saying don't appoint a childcare psychologist. By all means, do it, and do it under the auspices of the court. She decides on her own that she will not comply with the Supreme Court order. She says without any record, child is unwell. She goes, appoints a child psychologist on her own, gets a report, submits it. There has to be some sanctity to the process. Let me also have some idea of who this person is, who's giving these advices. Let the court appoint it. In fact, I wanted to place this on record. It is an opportunity for this court to set down law. Childcare alienation, appointment of guardians, appointment of childcare experts is an underdeveloped field. The UK Family Division has laid down guidelines. I wanted to place those on record on the manner in which childcare psychologists have to be appointed, on the manner in which alienating behaviors have to be identified, and what the court does in those circumstances. We have material we can use, and this is a perfect case for it because the extremity of alienating behavior that is being exhibited in this case, we don't see very often. Your leadership has met with the child.
Then how do you think that the father is going to take the child and spend time with her?
Your leadership, my suggestion would be, till date, every time there has been an order in my favor or there has been an order by consent, I have scrupulously complied with it. On the date, on the time, on the second that I'm required to be present, I've been here. Let an order be passed for the child to be in my custody for the remainder of the vacation, and let that order also stipulate that the mother drop the child off to my residence in Gurgaon, where the child lived for the last few years before she came to India, before she came to Bangalore. Let the mother drop her off. I have been under constant stress of having to meet my child, not knowing whether she'll come or not, bearing the expense of dealing with these orders, while the respondent goes scot-free. Till date, coercive action has not been taken on account of sustained non-compliance. I don't want to take coercive action. I've already been villainized. I'll be penalized even more. I just want access to the child for a short amount of time. I'm not asking that I'm going to take the child and let custody be transferred fully. That's not even something that I can pray for given the confines of the petition.
I only have one point, my lord. Insofar as what my learned friend has made submissions, he knows very well the condition of the child. No father should in fact force knowing the condition of the child if the child's well-being is the case. If I may, my lord.
What a mother should do.
Should convince. I agree to that. The mother should convince.
So always don't point out at what father should do.
I am not. I am absolutely not. I am
Already-
from day.
no, it
My lord,
is like
what
this.
happened before I came on record? I am not. I cannot.
The mother, what mother is supposed to do, she has not done.
If I
So have introspection on that. What is to be done instead of pointing out what shouldn't be done.
my lord had stated that I should be acting as an officer of the court. I am intending to do that in all its entirety. No father, knowing the fact that last 2 days, what actually transpired, should say that no matter what it is, send the child to me for the given days of custody. No father should actually say that.
So that is a weapon.
No.
That is a weapon.
My lord, we are not here to fight. That is what, my lord, if I am to fight the case insofar as my client is concerned, and only in terms of what my client is concerned, then I would say that the reason why the child is not going forward is because of this very attitude wherein hostility is built, wherein violence is built. My lord, if I say that I like Bangalore, my the husband says or the father says entire South India is Pakistan. I'm just saying this is all on record.
No.
They will not deny that because this is a fact. No, I'm not going into such petty issues. I'm going into the factor. My lord, I'm going into the factor of a very simple point that the child is the primary subject here, and that is the most important thing. 2 days we have seen where 2 judicial officers were there. We have seen the grandmother, grandfather, the mother, everybody was there. Still, we found out and we have come to an understanding that the child is completely hostile. I am doing my very best. I brought the child 2 days, irrespective of the fact that there is an order. I made an attempt. Insofar as the father's submission is that irrespective of what you give me custody, whatever happens to the child's mental state, it does not matter to me. I am of the point that, my lord, we'll go with this. Under the circumstances, the child has gone to the hospital. The child is under some sort of treatment. 2-3 days later, let us have a counselor. How they stated that there be a counselor, father, mother continuously for a week, 10 days, no problem. They will have time together. The father, the counselor.
Why did she not come up with such an application before? If she really was in the interest of
I
the
was
child.
ready to, my lord, on that point, my lord, I am complying by the very order that was passed by the trial court. I have complied by it. They challenged it and came before this court. Trial court's order was very clear. Video calls were there. Visitations were there. They wanted more. They came challenging it here.
Don't compel the court
No,
to
my lord.
pass some other order.
My lord, my only point here is, let us look at the child's welfare. And to that effect, my
That
lord,
is exactly where the thing is. Who has to? When the mother is not
I
conscious.
will take her. I will get the child, the mother, for example, I will get the
When
child.
will you do it? After all this, after going to Supreme Court, coming back, after defying all the orders of the court.
My lord,
Can
I
you
did
tell
not,
that?
my lord, it is not my intention that I make my child sick. The child became, no, the child was sick for the last.
Want to use the daughter as a tool. That is what it is. And
Where is it, my lord?
don't
I am
compel the
ready
court.
to-
Don't compel the court to give a finding that the child's welfare is not being with the mother.
That is not at all.
That's what I'm
I am
saying.
not pushing it.
The more you make submissions in that regard, I have to make an observation that it is a complete case of parental alienation, and being the daughter with the mother is not in her interest, and the custody needs to be shifted.
Only one submission, my lord. What harm will it cause to my friend insofar as having a counselor? Let us agree with their application. I have not gone through. I do not have the copy of the application.
Sir, what the registrar said. A child of 10 years old, no child at the age of 10 will speak all these things unless and until she's tutored. What she says, when the undersigned, after some time again trying to convince the child to accompany the father, she states that her father used to scold her and she will not pardon him. When it was informed to her that as per agreement between her parents, a court has passed order that it is a right to enjoy the company of her father. She says that court has not asked her consent and she does not bother about any agreement between her parents, and she just don't want to go with her father and just want to go back home. She was telling that she is not an object but a human being. She has right to decide whether to go with her father or not, and she has decided not to go with the father. She was also telling that even her mother cannot agree to send her to her father against her wishes.
This line your ladyship has
All
read.
these gives, she wrote something else. All these gives an impression that the child is under great influence of her mother and was repeatedly avoiding interaction, conversation with her father.
This line your ladyship read, that I'm not an object. 4 years ago, very same line, exactly was messaged to me by the mother. She's not an object, she's not a toy, she'll decide on her own.
It is a simple
I'm not
thing.
saying, it's on record, it's her message. So,
No, what I'll do is I'll ask the registry to give a copy of this report, and you can whatever the earlier proceedings or earlier those messages and
Yes,
all,
sir.
and what has happened, you can place all that on record.
It's already on
We'll,
record.
no, in one
Yes,
form,
yes,
so that
yes.
it will be easy for the court.
Yes,
We will
for a
pass all
comparison. Yes, your ladyship. And just one point I want to raise for your ladyship's attention.
Is it believable that a girl of 10 years speaks? This is a tone or tenor of.
I was surprised
we
myself.
live in a point,
you
my
know,
lord,
we
8-year-olds have gone and they've gone ahead to start having companies, my lord. So anything is possible in today's.
I was
It's true, my lord. 8 years has a startup which is now, I think, valuated to be $1 billion company, if I'm not wrong. Very from Bangalore. So let us not go
What
into
was
that,
what
my
was
lord.
amazing for
The
me to
existing
hear.
mindset of the child,
The council, please don't make this.
my lord. The existing mindset of the child.
Let us not, please don't tell the court a hypothetical situation.
It's a fact, my lord. Children today are growing up too fast.
So at least I can understand the client making those kind of submissions, but not as an advocate.
Lord, I
You
am at the
cannot,
point where I'm saying that, my lord, the child is not in its best state of mind. Let's have a psychiatrist or a counselor
that
or
we'll see. And my
or a
question,
counselor,
I didn't
and let's
ask you
have the
for-
father
Mr.
and mother
Counsel,
both together.
I didn't ask you to respond.
Yes.
I was addressing him.
My apologies.
Yes.
Yes, your ladyship. Just 2 points I want to ask. I want for the honorable court's attention to raise 2 points, and hopefully it changes, if not the submissions that are being made, but at least the understanding of why the court is progressing in a particular way. An order of transfer of custody, even at an interim stage, like the one we are seeking, like the one Justice Yerur passed, it cannot come from a place of punishment. The reason I'm asking for transfer of custody is not to sanction the woman because she disobeyed your ladyship's orders or the Supreme Court's orders. It's because I want to stall the alienating behaviors that have already reached fever pitch. And because it is in the child's best interest and her welfare to have a gap between the person who's causing these alienating behaviors to exist and a relationship to develop with the rest of her family, that I'm asking for this. I'm not asking because
The order of Justice Yerur dated.
your ladyship. 21st March 2024, 2025.
I don't have that.
And the Supreme Court order also.
Yes.
Where is that? It is
16th
there in
April.
that.
Copy ಕೊಟ್ಟಿದ್ದೀವಿ. Copy. Give a copy. Supreme Court. Your ladyship, I've already placed on record a copy. If you have an extra copy.
You said the order is dated?
The Supreme Court's order is
No, no,
16th
no.
of
This is
April.
Yerur's order.
21st of March. It's a
Just
detailed
March.
order. And it may be kept in mind that none of the findings, factual findings in that order have been disturbed. The leadership requires a copy. And I've just, for the court's convenience, prepared a list of dates on which there has been non-compliance, so that with every passing order, what has happened in respect of the parties' compliances.
So where is the operative portion of this order?
Your Ladyship. The Supreme Court's order, Justice Yerur's order, Your Ladyship, is at page, just for a moment, at page 13 and 26.
26.
Page 13 first, your ladyship may have.
13.
Yes, the second paragraph. Therefore, this court is of the opinion that for the time being during the summer vacation, the petitioner father as well as the grandparents shall have custody and visiting rights for 50%. That paragraph. And then your ladyship will see a more proper articulation of that at the bottom of page 26. Respondent is directed to bring the child to the court premises on 7/4 to keep the child present. That's the operative portion. Everything else is a summarization of the factual record. And there is an observation regarding the respondent mother's conduct at page 11, which in fact is not very different from your ladyship's observations on a prior date. Your ladyship had made similar observations in the order dated 18/3/24. On an overall reading of the orders of this court and the behavior and attitude of respondent mother. I'm reading page 11 from the 10th line.
What will as per the order of the court, will fix the day, that is tomorrow, and let this order be executed.
There's one addition to that. I'm working in Gurgaon. For me to immediately come at short
And
notice,
when do you want to take the child?
just can I have a moment? If I could request your ladyship this weekend.
Let it be a working day.
26.
Because they have to come to the
Very
court.
well. Then
Saturday.
Saturday is a working day.
Saturday.
Saturday is a
we
working
can pick
day.
up the child.
And I know this is not subject matter of this, but I have spent enormous amounts of money in doing this. Let a deposit be made to this court towards some expense that I'm going to undertake towards this travel by the mother. Because at my expense, I have come a dozen times.
That we will see later.
Very well.
A coordinate bench of this court on 21/3/2025 has passed an order whereby where do you get that 50% custody?
Your ladyship is at page 13. At page 13 and then page 26. 13 is
The court, I granted the 50% of the summer vacation starting from 6/4/2025 to 2/5/2025, where the father and the grandparents shall have the custody of the minor child at Gurgaon, which is the very same place where the minor child grew up from the year 2014 and spent quality, loving and affectionate time with the parents and the grandparents until 2021. Thereafter, and also court had passed a slew of directions how the visitation has to go on, and finally the mother is directed to bring the child to the court premises on 7/4/2025 and keep the child present before the registrar at 11 a.m. On 8/4/2025, another order is passed as the mother has failed to get the child before the registrar judicial, and the court, in order to provide one more opportunity, directed the mother to keep the minor child present on 9/4/2025 2:30 p.m., failing which coercive action will be taken, including issuance of bailable and non-bailable warrants against the mother for flagrant disobedience of the orders of the court. When on the next date of hearing, when it is brought to the notice of the court that even the counsel and the senior counsel, they're unaware of the whereabouts of the mother and the minor child, has directed the Commissioner of Police to find out the correct whereabouts of the mother thereafter. When the matter came up on 16/4/2025, it is brought to the notice of the court that the order passed by the order dated 8/4/2025 or 21/3/2025.
Yes, sir.
21/3/2025 was questioned before the apex court. And the apex court had modified the order. Where is that order? Then the Honorable Apex Court had passed the order observing that both the parties have agreed for the following arrangement: extract this arrangement, and further the entire order, extract the entire order. And accordingly, an order was passed on 16/4/2025. The coordinated bench of this court had directed the parties in the Registrar Judicial to comply and act in accordance with the order passed by the apex court. On 21/4/2025, when this matter is listed before the court, this court has made it clear that no clarification needs to be required. The order passed by the Honorable Apex Court, and the order has to be complied in its true spirit. And the Registrar Judicial is directed to make all efforts to see that the order of the Honorable Apex Court is implemented in its true spirit. Then the report is placed before this court by the Registrar Judicial. This entire report extract as it is. Today, when the matter came up before the court, land counsel appearing for the mother submits that after the whole day in the court, the daughter was not feeling well. She was taken to the hospital. She was completely stressed, and the doctors also advised that she should have the counseling. It is submitted that all the parties shall they have to go for the counseling, and the girl shall be convinced to go to the father. As of now, she is reluctant to meet the father. Land counsel appearing for the father submits that so far as he is staying in Gurgaon, to come to Bangalore and to exercise the visitation, he has been spending huge amounts, and even this time also, even as per the order of the court, when he has come before this court, has come to Bangalore, the orders were not complied with. It is submitted that it is a clear case of parental alienation, and in the year 2023 or 21, you filed the application.
2023.
2023, he has filed an application that the child requires counseling
Along with this writ petition.
along with the writ petition, and that was the that was opposed by the mother, and as such, that application was not considered till now. It is a submission that any of the actions of the mother are not in the interest of the child. It is submitted that as the Supreme Court, the directions issued by the Honorable Apex Court were not complied with. Hence, orders needs to be passed by this court for the arrangement for the summer vacation. This court has perused the report that is placed by the registrar, and particularly paragraph number 8 of the report, which clearly shows that it's a clear case of parental alienation, tutoring by the custodial parent. Whatever are the disputes between the mother and the father, and now the daughter is aged about 10 years. It is also an admitted fact from the day she is 4, they are residing separately.
No, Your Ladyship. She resided with the father in Gurgaon till she was about 6.5 years old. 6.5, she came to Bangalore in 2022. Since 2022 till date, they are residing separately. So 3.5 years, there's been separation.
She was residing with the father till 2022. But thereafter, they came down to Bangalore. And admittedly, father has never met her till the orders were passed by the court.
He has never met her for more than a few minutes, as in chambers or wherever else.
Even from that day, he never met her. And the kind of hatred and the kind of aggression the daughter is showing against the father, and to the extent of saying that she is not an object and she will not meet the father. It all appears that there is the manner the daughter is tutored and brought up by the mother is definitely not in the interest of the minor. If no, as the daughter is staying with the mother, no, just because she says that she doesn't want to see the father, that cannot alone be the reason for this court not to consider the request made by the father. The coordinate bench of this court in the month of March, that is
21st March.
21st March, has passed a reasoned order. Against that, the appeal is filed, and the said order is not set aside by the Honorable Apex Court. But however, the court had, as per the agreement made between the parties, arrived at between the parties, had had granted the visitation on 21/4, 22, 23, and 25. And admittedly, the said orders of the Honorable Apex Court are not complied with, and it appears that the mother is not inclined. There is no inclination on the part of the mother to comply with the orders of the court, which is also reflected with the daughter. Hence, this court is of the view that the order that is passed by the coordinate bench dated so and so is a well considered order, and as for the directions of the court, where the court had directed that after considering the report, the High Court on the next date of hearing pass further appropriate orders as it may think fit with regard to the interim custody and visitation. This court feels that the said order passed dated so and so holds good, and accordingly, in the light of the order dated so and so on Saturday, that is 26th of April, by 11 o'clock, the custody of the daughter shall be given to the registrar judicial, and the father can take the child. And during the stay with him, the father shall take the girl for counseling on every day at Gurgaon.
In the event she does not bring the child, or the child expresses reluctance physically or otherwise with the registrar, then there has to be some means in which this order is given effect to, Your Ladyship. What those means would be, I don't know if we want to suggest the involvement of police or anything like that, but there has to be some fail-safe, because if I come once again, this will be the 8th or 9th time that I come, and if there is a difficulty created, then it will be again a non-compliance, so to speak.
Shall we say, like how the earlier order to the superintendent of police, if you don't come, let them get the mother and daughter to the court. Huh? Child?
I would stick to the same submission that I made earlier, my lord, that the child is not in its best state of mind to be sent. Whatever this court feels fit, taking into account all those factors, court is to decide. I'll not be able to make any submission.
Let it be listed on Saturday for.
Oh, list this matter on Saturday. If she doesn't, then we will pass a copy or something. Yes.
Till number 29.
My lords, I appear for the petitioner. My lords, this matter was in fact mentioned after an order of the Honorable Supreme Court. Can I just pass it on, my lords?
Who is before this court?
The mother.
Copy.
Copy 1 minute. It was already given the copy. I believe it was also given. Sorry, I just share it with you. My lords, this is an order dated 24/3/25. We dispose of this writ petition by reserving liberty to petitioner herein to seek appropriate interim orders either in.
What was the order that you have questioned?
No, my lords, that was a separate Article 32 petition I had filed. Now, my lords, what I'm seeking now is a very short issue. My lords, by virtue of the.
I don't have the copy of the order. Whatever the order is passed, please give us a copy at least.
One minute.
It's not even been heard in that.
Yes. Now, my lords, the child here is about 13 and a half, almost 14 years old. Child, as per the orders, my lords may just for a moment, there were orders, there was a habeas corpus petition filed earlier. As per the habeas corpus petition interim orders, my habeas corpus petition was rejected. In fact, the child
corpus petition filed by mother.
Filed by the mother, because we were all living in the US. The father suddenly in 2019, this is an old matter, 2019 took away the child on the pretext of coming here for some puja and then never went back. Thereafter, I filed a habeas corpus petition. Mother is still in the US. She's in fact here now. And in the habeas corpus petition, while the petition was dismissed since the father had brought the child here and initiated a GNWC, the court said you work out your remedies before the guardians and guardianship case. In the meanwhile, we will pass some interim orders that whenever the mother comes here, she should have exclusive custody of the child. Child should be exclusively with her. Now, in pursuance to that, of course, there were many difficulties even in getting that implemented. Now, for example, she has come for the child's vacation and she's here. In fact, the child is also here. He's in the 8th standard, going now to 9th standard. Now, my lords, what I'm the only limited thereafter, my lords, this writ petition has come out of the orders that I had filed in the petition saying that the guardianship family court had no jurisdiction. That was rejected. Against that, I filed this petition. My lords, now my only limited prayer, I had filed an application saying that when she comes here, can she take the child for a few days to the US and bring the child back? Initially, that is the limited issue. Now, my lords, the child is here. She is with the child. She came, I think, about on 10th of April. From 10th of April, initially, again, for a few days, a child was not given. Thereafter, the child was handed over. Now, my lords, I just want to pass on the school calendar, madam. The school calendar of the child. The child is now going to grade 9, 9th standard. And the date of reopening is 22nd May. Child is now with her. In fact, he's here. My lords can even, all we are seeking is, anyway, as per the habeas corpus visitation order, which is on record, child is supposed to be with her. Can she not take the child for few days, bring him back? He has never, in fact, been to the US after he has been removed from in 2019. We will give an undertaking. She lives in New Jersey. It will be an opportunity for her to, for the child to, in fact, go to the US. In fact, my lords, may just for a moment, we had filed initially an application in the views of the child were taken by the family court.
No.
Yes.
Mother, she belongs to which place?
Mother is in the US. She's working there. Sorry.
India. She belongs.
Yes,
to
yes, she's here.
No, she belongs to which place? I'm asking.
Here in Manipur.
To Bangalore.
Yes.
No, her mother lives in Manipal, in Karnataka. They were both mother and father were both, husband and wife were both living in the US. Until 2019, the child was studying there, and they were both living there and both were working there. Suddenly in 2019, he brings the child, she is working there. He says, I will go for a puja to his parents' house. He brings the child. There was no difficulty. He brought the child. She had no suspicion at all that anything drastic like this would happen. He brings her here, he brings the child here, admits him into a school here. In fact, now he has changed 3 schools. From 2019 to 2025, 3 schools have been changed of the child. Anyway, be that as it may, we are now not going into.
What do you say?
All I'm seeking, my lords, may I just, 2 things I'll point out. Child is with me. I want to take permission of the court to take the child. In fact, the passport application also has been held up for all these reasons. I will apply for some tatkal procedure. Let the father give permission. After I'll take the child. I will give an affidavit undertaking that I will come back by 19th, 20th before the school reopens, and I will hand over the passport also with the court. Just for the child to be in the US. In fact, just one thing. The child statement.
For example, if you don't turn up, what is to be done?
That is the
Correct,
whole.
correct,
That is
correct.
the whole apprehension.
I can anticipate, my learned friend would
They
say
have
that.
an order of the foreign court, my
No,
lords.
one minute.
Yes,
I can anticipate, my learned friend would say that, anybody would say that, okay, you take the permission of the court, you go, you never come back. Yes, he may say that. For that, what I can say is, I will give an affidavit of undertaking. Council will give an affidavit of undertaking. As we will show the tickets, we will give the return tickets, we'll produce it and ensure that we come back. In fact, I want to put on record that I have never violated a court order.
Must be a citizen of yours.
Yes.
She is.
He must be, even the kid must
He has
be.
a green
No,
card.
no, he is not.
He's not a
He is
citizen.
not.
He's not a citizen. At the moment, he has a green card. They all had a green card. Right now, his passport has had expired. A new passport application is pending. They have to, of course, in the next 3-4 days, make some tatkal application and get that passport with both the parents' signatures. Now, I will give that undertaking. I will give that affidavit. In fact, I just want to point out, there were court orders in the US when these proceedings were going on, violating court orders. The father has taken the son out. I have
Not
never
violating the orders. Let the facts be clear.
Okay,
It is
in any
after
way-
me coming to Bangalore.
No,
They have filed
whatever
a
it is.
petition before the
Whatever it is,
foreign
what I
court,
want
and
to-
thereafter they have secured an
No,
order.
there is a court.
It is not in violation of the order that they have got
What
the
I want
child.
to say is I've never violated.
Let the facts be clear.
Why the son was brought to India, leaving the mother?
Milords, it was under the understanding that, Milords, that both parties would go there, work for some time, and Milords, only because of the fact that the father of the respondent here in Milords was suffering from serious illness, he was, Milords, constrained to come back to India along with the child. Mother did not agree to stay back. She left. He got his child enrolled. Mail has been sent on the very same day, but she immediately left to US. And Milords, there's a writ which is being filed. If Milords would kindly consider for a moment my statement of objections for a moment. This application is already been filed. Trial court has already considered similar application and it has been rejected. That application is already been rejected. If Milords would kindly peruse for a moment.
Disputes are between you and your wife. The
Yes.
wife doesn't want to come. And what is the wish of the child, where he wants to live?
The child has expressed the court that he wants to stay here in India itself.
May
I will take Milords.
Can I just point out the order?
I will take
of
my
the
lord's
family?
attention to the
1 minute,
orders.
sir.
I filed
in
my
fact,
objections.
Yes, in fact, my friend has only filed the order. Just for a moment, my lords may just see page 66 of his objections. I'm grateful that he has filed it. Yes, the objections by the respondent, page 66 of his objections. Yes, 1 minute, sir. Page 66, it starts with para 5 on top. My lords have found it, para 5 of his objections.
Para 60?
No, page 66, para 5.
Of his objection.
Of his objections, respondent's objection. Page, ink page 66, para 5, right on top, my lords may just see. Para 5 on top. The court interacted with child master Vihan on 4/3/23 in the chambers. The child Vihan interacted very well and expressed his willingness to continue his education in India and to visit the US during vacation for some time, to visit his mother, friends and cousins. Child expressed he's more comfortable in India than US and he has no health issues. And thereafter,
He's born in US?
No, born in India.
He was born. He was born.
He was born in 2011.
11. He's going to be 14 at
13 years, my lords.
He's going to be 14 in August.
When you people went to US?
Lords, we moved in 16.
In 2014.
He was 5 years old.
2014 they moved.
He was in US only for 3 years.
No.
Yes. Before that, they were in UK for 2 years, and before that, they were in India. It was only for the purpose of work, my lords, they had been there. And the mother was, my lords, enrolled in an MBA program in US. She completed her certification out there. And thereafter, my lords, owing to the ill health of the father, my lords, they had to rush out, came to Bangalore. And my lords, thereafter, the mother did not agree to stay back here.
My lords, 20.
If my lords would kindly peruse.
The only child.
Only child.
Only son. And my lords,
If my lords
he's
would
a
kindly.
grown-up boy.
Okay.
Yes.
My lords, if my lords would kindly peruse, if my lords would have statement of objections of mine.
Yes.
If my lords would kindly peruse the order dated 29/1/2020.
Page number.
Page starts at 73. This was the first order, my lords, passed in the habeas corpus petition, my lords. The relevant portion, my lords, would find at page 76. My lords, got it, my lords? This is the order dated 29/1/2020, passed in the habeas corpus petition. Roman 5. There was a direction given by this court directing the father to send the child to USA to the mother during the summer and winter vacation of every year, followed by an order, my lords, on 22/12/2020. That's at page 77 to 81. And the relevant portion, my lords, would find at page 80. And again, a direction was given, my lords, page 80. Number 1, minor child Viryan shall travel to USA at the earliest, preferably this week itself, depending on the availability of an air ticket. Much before that, my lords, if my lords would kindly come to page 79, third para. This was my apprehension. It was further submitted that the respondent father apprehends that once the child visits his mother at USA, there is a possibility of the mother not returning the child to the father, and consequently, it would not cause a greater rift between the parents, but would also cause legal complications and undue hardship to the child itself, and that would not be in the interest of the child. Now, my lords, being agreed by these two orders, I approach the Supreme Court. That, my lords, would find it in the next document. Page 82. These two orders were stayed. Subsequently, my lords, by order dated 2010-2021, my lords, at document number 7, the Supreme Court disposed of the SLP, directing the High Court to expeditiously adjudicate on the matter on the SLP. Now, my lords, the order dated 22/12/2021, for a moment, page 104. I would not take much of my lords' time. This is the order passed in the habeas corpus petition, my lords, page 104. Para 14.
Yes.
Before that, my lords, page 101 for a moment, my lords. para 13. The issue with regard to the best interest and welfare of the child has to be answered bearing in mind the totality of the facts and circumstances of each case. In the instant case, following circumstances, reasons have to be taken into account. Admittedly, the son was born on 38/2011 at Bangalore. The son is not a US citizen and is residing in India for the past 2 years and 5 months and has developed roots here. The son is studying in school at Bangalore. Now please come to para 14 at page 104. For the aforementioned reasons, this is the reasoning, my lords. For the aforementioned reasons, in our opinion, in the best interest of the child, he should be allowed to stay with the respondent in India till decision of the issue pertaining to custody of the son in a proceeding under Guardian and Wards Act is adjudicated. And subsequently, my lords, both the parties were put on terms. The terms are at page 106. The mother is entitled to communicate with the child through phone or video call, Skype at any time. Every day they have been interacting. The next is the respondent shall provide the school calendar of the child with list of holidays along with the dates of examination to the petitioner. Clause 4 and clause 5. The respondent shall provide tickets by air to the petitioner every 6 months to enable her to travel to India to meet the child at her convenience. The petitioner shall intimate her desire to visit India to meet the child to respondent in advance to enable him to procure the tickets. During the period of her stay, when she comes to India from the USA as aforesaid, the child will be in the exclusive custody of the petitioner.
Don't the parents feel that they're spoiling his childhood?
Milords, as regards the terms that's been imposed, Milords, I have been strictly complying the orders.
For terms.
Please.
The boy is staying at yours. Both of you are staying at yours. One fine day you will get him to India. Now you want him to retain in India. She wants to take him to US, and she will stay in US. And what is the mistake of the boy for all this?
Milords,
Because of both of you, he is made to face all this.
With all due respect, Milords, we have utmost care. The best interests of the child has to be considered, Milords.
The interest of the child is not about giving the facilities and sending him to a good school or doing what he wants. His best interest is with living with both the parents, at least, if not under one roof,
Milords,
in one country at least.
Milords, it is the mother who chose.
Either she should have come to India, you should have been
Correct.
in US.
It is the mother who chose to go back. She was here to attend the function. Despite several requests, she did not. She did not, my lords.
So,
she did not chose to stay back here.
No, for his age, don't he need the love and
Definitely
affection
yes.
of the mother?
I'm definitely yes, my lords. I have no second word on that.
Then, if you are interested to come to India and mother is not interested, you could have come alone.
My lords, no.
The boy we dragged
No,
to
my
India.
lords, it was not that I was supposed to come alone. I wanted to move to Bangalore. That was expressed. That was clearly told. And my lords, she also comes back to Bangalore. She attends the puja. Then thereafter, my lords, she goes back. If my lords should kindly see.
Habeas corpus is filed. Senior counsel is saying that you brought him to India.
My lords, the boy, my lords, owing to ill health and puja, my lords, was supposed to be performed. We came. Both father and the son came. The following day, the mother came. They attended the puja. The father stayed back. Requested the wife to stay along with the father. She did not choose to stay back. She went back to US. That is what her claim is also.
Any other proceedings with regard to the divorce?
There is MC petition also, and there are there's a GNWC proceeding.
Want to make a submission.
And that apart, my lords, a similar application has been already filed, and that came to be rejected by the trial court. They haven't preferred any appeal, and there is no application now being filed. That the previous application that was filed, my lords, the coordinate bench, my lords, on the previous occasion did not grant any order.
Earlier
1 minute.
Earlier in the habeas corpus petition,
Please.
there was an order to send him
Against which I preferred an appeal. My whole apprehension was that, my lords, if at all, if he is now taken, now mother being a citizen, my lords, she will ensure that the child gets the citizenship, and I will not be in a position to get back the child. Please, my lords, kindly appreciate the legal consequences behind this.
My lords,
Why should I be put to this hardship? For me to secure back the child, what should I do then? Why should I be made to run pillar and post?
Let me make.
Is it not that, my lords, I'm not complying with the terms?
I'm the
No,
petitioner.
mother
Let
will
me
come
argue.
only once in a year.
Twice a year.
1 minute, sir. Can I please argue? You please finish your arguments. I'm the petitioner. Should I not make my arguments? I can't understand this kind of
Can you please
thing.
make submission?
Yes. I want to just make my submission. My lords, page 33 of the main petition. Kindly just see for a
No, no,
moment.
before going
Yes.
into all that, when the mother comes in a year. to
Now,
see
my
the child-
lords, the mother tries to come as often as she can. She tries to come, I think, twice a year. Yes. Once
Stays
in
how
the,
much, stays how much time here?
she stays maximum 3 to 4 weeks. This time she has come, I believe, for 3 weeks. She has
And
taken.
from 2019 till 2024.
Yes.
She's visiting India like for about, 3 weeks to 4 weeks, 2 times.
Twice. In fact, I want to make this submission. In the habeas corpus, the submission made by my friend on his.
Till the exams or till the school reopens.
Yes.
She can stay back in India and spend time with him.
No, now, my lords, she has come around 10th of April she came. It has already been about 10, 12 days. She has got 3 weeks leave. Never mind her leave. That is not important. She is coming here for the child. The child is close to 14 years old. He's 13 and a half, 9th standard boy who's going to the 9th standard. Wants to travel to the US. My lords, in fact, twice there were orders passed during the habeas corpus to let him go to the US. Then interim orders were passed by the Supreme Court staying those orders since the Supreme Court.
It couldn't be fructified at any point of time.
Yes. Thereafter, the habeas corpus final orders were passed, which my learned friend read out, that when she comes, exclusive custody with her. Yes. Now, all we are saying is, during this period, let her get the permission. If the worry is that I will not come back, my lords may put me to affidavit to terms and all of that.
What will put her?
My lords, is this court?
We have seen cases and cases of this nature.
My lords may have seen, certainly as counsels we have seen cases. There is no dispute about that. But my lords, is this a case? My lords heard that previous case. I was listening to that. The previous case where a party has repeatedly violated court orders. My lords, here, this is not a case, for example, where she has violated a single court order. Let my friend say she has violated any court order. In fact, despite the exclusive visitation directed by the division bench, whenever she comes, she has to move pillar and post to even get him, because when she comes, he will take the child and go off somewhere for a few days.
No, no.
In fact, even on 10th when she came, she didn't get the child on 10th.
Unfortunate state of affairs.
Yes, it is the unfortunate.
No.
I'm only
My lords,
saying
let her
no,
not
1
make
minute, sir.
allegations, my lords.
No, 1 minute. I will make
Child was required to
statements.
attend a sports meet, my lords, which was held in Chennai. It was rather, my lords, she did not even inform as to when she is coming.
I'm making
No,
a.
if she is in India until the till
Now-
his vacation.
My lords, as regards the exclusive
minute, sir.
custody.
Vacations are completed, let her stay with
No,
him.
now my lords, my one submission is, I will leave it to my lords. We had filed initially an application in the family court asking not for this vacation period, to say that can we take the child to the US as a larger measure. In that context, the Honorable Family Court interviewed the child, interacted with the child in chambers, and the child said, I'm studying here. At this moment, I don't want to shift to the US, but I want to go there for holidays. Now, my lords, all we are seeking is, let her take the child for holidays and bring the child back. My lords, where is the worry that there is going to be any violations? His friends are there, his old school friends are there. He can at least go take a round of New York and the US and come back, my lords, at her cost. To that extent, my lords may put whatever conditions. We will deposit the passport. We will ensure that the affidavits are given, tickets
Will
are
she go to
given.
US by depositing the passport?
No, after she comes back. Now she has
Point
to
is
first
that
get
when
it.
she
After
comes
she comes.
and how she comes, whether she comes or not.
That is the
But
whole.
my lords, where is, my lords,
You know, in
have my
these kind
lords
of-
not,
When the parties are with these kind of.
my lords, ultimately what
It
this,
doesn't matter 1 year if he doesn't go to US, nothing is going to happen. Happily, let her spend the whole time.
my lords
till
may
he-
at least,
till
my
he-
lords,
if you want,
my
if
lords may
that-
at least interact with the child, if my lords feel free. Of course, we are not,
Let him be, will.
let my lords at least interact with the
decided.
child.
Let the GNWC be decided, and now she is in, as long as she is in India, she'll have the company of the child.
She is with the child now when she's in India. Then my lords I'm only requesting, let my lords, if my lords feel fit, to have a few
I'm
words with
telling
the
you,
child.
even after interaction with the boy, even if the boy says he
My lords, should
wants
the
to go-
child be deprived, my lords raise this
he
issue.
wants to go to the US, still the court will not.
My
grant
lords,
permission.
what we are seeing now, certainly I'm in my Lord's hands. My ladyship, what we are seeing is in September 2019, father takes the child on the pretext of a puja and doesn't come back. And the same person is now saying, what if you go with a court order, you will not come back? Does it lie in the mouth of a party who has, in fact, by stealth brought a child? In fact, my submission, what has been recorded in the habeas corpus order, I want to just read out 2 lines. In the summer vacation of the school of the son was from last week of
That
June.
is stayed with the Honorable Apex Court.
No, this is not stayed. After the Honorable Apex Court stayed interim orders, the court directed the High Court to pass final orders. In the final orders, which are now, the final order is operative. That was not set aside. In the final order, the court records, it is the case of the petitioner that while she boarded the flight for traveling to New Jersey, they came here, performed the puja, she went back because she didn't get more leave. It is the case of the petitioner that while she boarded the flight for traveling to New Jersey, an email dated 26/8/2019 was received by the respondent, by which petitioner received from the respondent, by which the petitioner was informed that the son has been admitted to NAFIL school. The day she takes the flight back after the puja, she is informed that I've admitted your son and we are not coming back.
So, you know, it's happened about 5 years back, 6 years.
It is true. Now, from 5-6 years, the child is unable to even go to the US on a holiday, my lords, on a visit.
Not taking the child to the USA is not something he's deprived of.
India has really good places to
It is not. No. It is.
He's deprived of the love and affection of both the parents at a time.
Definitely, that is a larger.
Let them concentrate more on.
He is in fact coming twice a year.
She is
coming twice a year religiously.
Children who have never seen US are very happy still in India.
No, it is not about the US or UK. That is not the issue. Then, my lords, may I request at least for a moment, if my lords are not considering 2 other things, at least let my lords list this matter, because we have challenged the jurisdiction of the family court. My lords may list it immediately on reopening so that it can be taken up.
This is by the request of senior counsel.
Yes.
This is matter on
2nd or 3rd, first week of June, my lord. Some date
Anytime
it could
after
be.
5th is my only request, my lords. I'm
this
not
is matter on 9th of June.
9th. Great. 9th of June.
Grateful.
List number 2, serial number 31.
Yes.
List number 2, serial number 31, passed over matter.
No.
Bring for the appellant, my lord. Insurers appeal, my lord.
List number 2.
Case of injury, my lord. Appeal on liability, my lord.
On what ground?
My lord, he is an unauthorized passenger in a goods vehicle, my lord.
Where is the respondent?
Respondent is.
Was this matter after vacation? No representation for the respondent. Yes,
Please.
next.
List number 3, serial number 15, pass over matter.
Serial number?
15, 15.
Yes. Yes, Mr. Janardhan Reddy.
Pain recovery, already the tribunal was pain recovery was granted, my lordship. The claimants also filed an appeal for enhancement. Only 15,500 was to be enhanced, my lordship. The pain recovery is as it is, my lordship. He has also agreed.
Agreed. Some other head also.
So what we say is, appeal of the insurance company is dismissed. Your appeal over and above the amount 15,000.
15,500.
15,500. MFA number 2682 of 2024 filed by the insurance company is dismissed, and MFA number 2014 of 2024 it is submitted that the insurance company is ready to pay an amount of rupees 15,500.
Yes.
Apart from
1,500 over and above the amount that is granted by the tribunal. And they'll file a interest at 6%, and they'll file the memo in the Lok Adalat evening. Yes, next.
The amount may be transmitted to the amount deposit.
Amount in deposit shall be forthwith transferred to the trial court. Yes. Yes, for what is that moved matter?
Matter. Money.
For petition, my lord. My lord, I have filed the petition challenging the order passed of family court, my lord.
This is the petition filed by the husband, my lord. The wife has
Why,
filed.
what is the urgency?
My lord, the warrant has been issued by the family court, my lord, for non-payment of maintenance amount, my lord. Now, as on today, arrears have become 3,72,000, my lord. In fact, by oversight, I had filed a memo, my lord, on other coordinate bench, my lord. The court directed me to purchase the DD for 30% of the amount, my lord. Accordingly, I purchased the DD. Yesterday, I submitted a memo before lordship, my lord. Since there was a strike, my lord, the lordship could not return my memo, my lord. Therefore, due to urgency, I filed a memo, my lord, today that I have.
You said something has transferred on the last occasion.
No, my lord. I have purchased DD of DD for 30% of the entire arrears, my lord.
So there is no stay in this.
No, my lord. Today.
You are ready to pay 30% of the arrears.
Yes, I have purchased the DD, my lord. I am
Comes
submitting.
to how much?
It comes to 1,11,600, my lord. I have purchased it.
12,000?
1,11,600. I have purchased the DD for 1,12,000, my lord.
1,12,000.
Yes, my lord.
And what is the monthly amount?
Monthly amount, my lord. There are two IAs. Through one IA, my lord, 6,000 has been awarded, my lord, to pay it to the child, my lord. And another IA, my lord, that I have to pay 40,000 annually to the school fees, toward the school fees of the child, my lord.
What is your salary?
Salary, my lord, wife's salary is 80,000 per month, my lord.
Your salary?
5 to 6,000, my lord. I am jobless, my lord. Even though I am MBA graduate, my lord, I am, as on today, my lord, I am free.
How you got this 1,12,000?
My lord, my sister has helped me, my lord. Since warrant has been issued, my lord, my sister is working in a.
How much you are continuing to pay?
My lord, just I'll discuss with my colleague.
Otherwise,
My lord,
meager
some,
amount
some,
of.
my lord, now as on today, my lord, I am complying the order, my lord, that 30% DD I have purchased, my lord.
30% DD is one aspect, and you have to continue to pay. What is the amount you are
My lord,
continuing
6,000
to pay?
has been ordered, my lord, to pay every month.
We did that. The tribunal, the family court has directed the petitioner to pay an amount rupees 6,000 per month as maintenance to the wife and 40,000 towards educational expenses.
My submission, my lord. At least half of the amount I'll continue to pay, my lord.
It is submitted,
Till some further orders, my lord.
It is submitted that the petitioner's salary is only 5,000, and whereas the respondent is earning an amount of rupees 80,000, and all these aspects were not considered by the court. Considering the submission of the land council, it shall be still, and it is submitted that further it is submitted that he is ready to pay 30% of the arrears at 6,000.
Yes, my lord.
And already he
Purchase the DD for 1,12,000, my lord.
purchased deposit the DD with the registrar judicial.
Yes, my lord.
He purchased a DD for an amount of rupees. He has taken a DD for an amount of rupees 1,12,000. The same shall be deposited before the registry. Registry next, considering the submission, they shall be stay of all further proceedings on the condition that the petitioner shall continue to pay an amount of rupees 3,000 per month by 5th of every succeeding month. The wife is at liberty to withdraw the amount of 3,000 as well as the DD that is deposited by the husband.
My lord, one submission, my lord. The 40,000 annually that is to be paid, my lord. That has to be 40,000 annually I have to be paid, my lord. That has to be.
When I granted stay,
Yes.
that is also stay.
Yes, yes, my lord.
Yes.
Much obliged.
Huh? Yes.
List number
Lord,
3.
last to come to the court hall.
Huh?
The display board says that I'm needed in the court hall urgently.
Yes.
List number 3. Sale number 48. Pradeep B.
Yes, Pradeep.
48.
This you will see. We'll see some other day after vacation. Yes, next 49.
Timing, my lordship, may grant stay, my lord.
Or else tomorrow. Let me not grant stay without even looking at it. If not, Saturday we'll have it.
Please.
This is matter on Saturday. Next.
Along with my lord, MFS 1769 of
that,
2000.
along with so and so.
Please.
Next 49.
Sale number 49.
For the appellant, Your Lordship. Lordship, the insurance company has accepted the liability. Insofar as enhancement, it's only for the income has to be enhanced, Your Lordship. We've discussed it, and I'm placing this
24 is
dispensation memo for the owner of the vehicle.
Memo is filed seeking dispensation of notice. Accordingly, memo is taken on record and dispensed with. Insurance company is ready to pay.
It is not calculated.
It has to be
just for this-
calculated. Yes, give that.
At
Is
date
it
of
the
accident
same
is
Where the,
Date of accident is 7/1/24.
24, Your Lordship.
1 minute. Case of death,
No, my lord.
Injury.
Injury. Fracture
7/1?
of 7/1/24.
this is an accident.
Please.
Injuries,
Fracture of shaft of femur.
one injury,
Please.
one grievous injury,
Please, Your Lordship.
40,000.
19% disability was taken.
No, next, how many days was in hospital? We'll go in
17
that
days.
order. Huh?
17 days.
Nourishment plus attendant charges, 17,000. Then medical expenses as it is?
53,000.
No, I'm looking at the wrong file. Medical expenses
No,
are 17,000.
17,843.
17,843.
Pain and suffering,
40.
please.
Hmm.
Amenities
Now-
also.
Huh?
Amenities also less.
No. Now, according to the doctor, what is the disability?
19% to the whole body. That was taken.
Salary was taken at
15,500.
50.
15,000?
2024, 16,500.
16,500 has to be taken, Your Lordship.
16,500.
16.
That's what,
Yeah.
16,500.
Please.
So 16,500 into 12 into, what's the multiplier?
15.
Into
30.
19.
5,64,300.
Five lakh 64,300. So loss of amenities, how much is granted?
15,000.
We'll grant 40,000.
Please.
Then loss of income during laid up period.
89,000.
So 16,500 into 4. It comes to 66,000. Any future operation?
No evidence to that effect.
It comes to 7,45,143.
6 lakhs.
It is submitted that the insurance company is ready to pay an amount of 7,45,143 against the awarded amount of 6,10,418, interest at 6%. Yes,
Obliged, Your Lordship.
for the joint memo at 5:15,
Obliged.
5:30. Yes. Next.
Cell number 40.
50.
50.
90,000 global.
Global. It is stated that both the parties are, the insurance company is ready to pay 90,000 globally, 5:30, Lok Adalat.
Cell
Yes,
number
51.
51.
Fresh time to take steps, my lord. Insurance, liability on United States, my lord.
Liability on
United India Insurance Company.
United India Insurance.
Yes, ma'am.
Who appears? You appear, Pradeep, United India. Shall we do the calculation?
No, my lord, we have to consult that.
51, Mr. Shivanagowda takes notice on behalf of the insurance company. The process in respect of, you are R2, insurance,
Yes, my lord.
R1 or R2?
R1, R2, my lord.
R2, in respect of R1, 3 and 4, within one,
Dispensation memo filed.
for all of them.
Yes.
Give that. Huh? 5 Sriram General Insurance.
For Sriram General.
Mr. Pradeep takes notice.
For Sriram General.
Huh? Respondent number 4, Sriram General Insurance. Mr. Pradeep is directed to take notice. Then a notice to respondent 1, a
And
memo
3.
is filed seeking dispensation of notice to respondent 1, 3 and 4 accordingly dispensed with at the risk of appellant. But yes, Admit post of final hearing then.
Please.
All are served. Then IA number 1 of 25 is filed to condone the delay of 712 days in filing. Condone on condition. Admit post for final hearing.
Number
Yes.
52.
What about this after vacation? Memo is filed taking dispensation of notice to R1. Dispense with the risk of appellant IA 1 of 25 to condone the delay of 356 days on condition. Yes, 53.
Number 53.
I appear for appellant, my lord. This TCRs are required.
Why it can't dismiss?
No, my lord. In this case, there is a disability to the extent of 72% the limb and 20.7% of the whole body.
Court has taken.
Taken 20.5%. There's a judgment of the division bench as well as the coordinate bench of this court. If there is a disability to the extent of 20% of the whole body, future prospect is to be considered.
But we will grant for that why TCR is required.
If the future prospect and
20.7%.
Huh?
20.7%.
Yes.
For that future prospect they are asking.
Yes.
30, I think in all the cases, generally where it is granted above 30.
No, this is only 20.7.
That's what I'm asking you.
Please.
Where there is this 30, we are granting future prospects.
Please.
Not in case of 20. According to him, there is a judgment.
There is a judgment to the division bench.
This is Sanjay Gowda's judgment.
No.
Correct, man.
Division
20%. Above this 20%. Here is the case, man, 20.77%. They in earlier.
If it is 21%, then he is entitled.
Please, the Justice Sanjay Gowda has written the judgment up to 20%, no future prospect. After 20, future.
After 20, 0.1 is also about 20 only. It is 20.7.
No. The radius, the fracture you are kindly see in this case.
No, already you have
Considering that, it requires.
You said till 20 not required. 20.7 is about 20. Are you ready or we should have it after vacation? Future prospects, anyhow it will come after vacation. Huh?
We want judicial order.
Judicial order. 2025 judicial order not required now. Yes.
That's
Post a memo for dispensation of notice. Memo is filed seeking dispensation of notice to R2. Same dispensed with. Mr. Sivana Gowda takes notice on behalf of the respondent insurance company. Next 54. Memo is filed seeking dispensation of notice to R1 and R2.
R1.
Huh?
R2 is insurance company.
R1.
1,45,000.
Notice has to go in there.
1,45,000 lump sum.
1 minute. IA number 1 of 25 is filed to condone the delay of 240 days in filing. That is same condoned on condition. It is submitted that.
1,45,000 in addition.
1,45,000 in addition to
What has
been granted. Interest at 6%.
No interest. Calculate.
Yes. Before the Lok Adalat at 5:30. Yes, next.
Then number 59, 55. Non-prosecution.
After vacation. IA number 1 is filed to condone the delay of 38 days condoned. Admit post of file hearing TCR 56.
Till number 56.
In this case, it's a case of
For the
injury
appellant,
later on
dispense
during
for-
pendency he died, my lord. Death is not due to injury. Therefore, my lord, the total 95,000
Then it has to be heard.
Please.
Notice to respondents.
R1 may be dispensed.
Notice is served.
It is heard, my lord.
Where 56. Respondent.
57. 56 there is.
Notice is not served.
Please, we'll take.
You take for Sriram
R1.
General Insurance. Penso takes notice. So the decision is directed to notice. Memo is filed for R1.
R1.
Memo is filed seeking dispensation of notice to R1 dispensed with IA number 1 of 23 to condone the delay of 340 days on condition. Next,
My lords, TCR may be called, my lords.
admit TCR.
Till number 58, 7.
What about this?
Involvement of vehicle
Notice.
Till number 58.
is pay and recovery. Complaint. Pay and recovery order has been passed by the tribe.
Can we do the calculation?
Please.
Yes.
I see. In this case, my lord, But the Sriram General and ICICI Lombard is both party. Either of one will represent the ICICI Lombard. There is no liability against those three.
Against?
ICICI Lombard.
So it's against,
So-
it's Sriram.
Ah.
So come to the table.
Date of access. But 5,07,000. 7,000 is order. 22-year-olds by Malad sustain a dislocation
age?
of right knee.
Age.
Age.
24 years.
22 years.
Hmm.
22 years as observed by the court.
Anyway, it's not a
Please,
minor.
it will not change the
So pain and suffering, what are the injuries?
pain and suffering. Malad, court has granted very meager amount.
10,000 is granted. How many, what are the injuries? Fracture of right
Dislocation of
femur
right knee.
distal condyle with intra-articular extension.
Femur condylar fracture, 42% of the limb and 14% to the whole body. Doctor has said.
No, first we are on pain and suffering.
Pain and suffering, another 30,000 has to be done.
Yes. Then how many days he was in hospital?
15 days he was in the hospital.
15, 1-5. Loss of earning, what is, which year is the accident?
Not 2016, 9,500 is taken.
It comes to 38,000.
Please.
Then future medical expenses, what is the evidence of the doctor? And court has granted 20,000.
Future. But for that, Malad. Postmortem units. He say future operation is concerned. Accurately, they have not stated, but court has granted. Doctor evidence so and so.
The petitioner has sought for a future medical expenses of 1 lakh. The doctor in the examination so and
Which
so.
page? Which page, Malad?
He said 30,000. 30,000 in, that's reasonable. We are granting 20,000.
20,000 it is already granted. It is already granted.
30,000. 10,000
20.
is granted.
20,000.
We'll grant 30,000. Then, which table you are seeing at page 25? Where is 30,000?
But in the communities, 20,000, Malad. Future medical expense.
Correct. 20,000. Now we will tell. No, you are saying already granted. 30,000 we are granting.
It is granted
So,
20,000
medical expenses.
as it is, Malad.
1,60,420. Next, loss of earning is over. Future medical expense. Now, what is the disability?
14% disability was taken, Malad.
As for the doctor?
Sir.
14 only.
Please.
So we are taking the income at 15.
9,500 is
9,000.
already taken, Malad.
Same as it is.
Please.
So 2,87,280. Then amenities
It is not granted.
not granted. You said disability is how much percent?
14%.
30,000. It comes to 6,05,700. What is granted?
5,07,700. 1 lakh.
It is submitted by the counsel appearing for the insurance. Mr. Shivanagowda takes notice. It is submitted that the insurance company is ready to pay an amount of 6,05,700 against the awarded amount of 5,07,700 for joint memo.
And pay and recovery is, pay and recovery order.
And already the trial court has ordered pay and recover. 530. And for which insurance?
ICC number, it is dismissed.
Dismissed, not, but anyway, it's a part.
Direction. You
So and so,
directly.
Mr. So and so is directed to take notice on behalf of so and so. Which respondent it is?
Fifth respondent. Fifth respondent.
Yes, next. This is in 58.
Please.
IN number 1 of 24 is filed to condone the delay of 162 days on condition. Yes, next 59.
Number 59.
On this case of injury, my lord, there is no scope of enhancement. The given heads is correct, my lord. The
IN
page
number
number
1 of
is
24 is filed to condone the delay of 88 days. Condone.
the page
Admit
number is
post of final
27.
hearing.
Page number 27.
60.
Post of final hearing this year. Next.
Serial number 60.
This is connected with company appeal serial number 3, 2781 of 2020. Involvement of the vehicle.
Next, in the
Serial number 3 in that list. List number 3.
Serial number 60.
Earlier passed.
MFA 2781 along with
2781 of 23.
where is it?
list number, serial number 3.
List number
3.
3, serial number
3.
Oh, it is IA number.
278.
But I think notice has to go to the other parties for there. List along with so and so.
Yes. Serial number 61.
Notice list along with so and so.
Ojaraj.
There is no scope for enhancement.
Yes, 62. What do you say?
61.
61.
61.
61. What do you say?
But other head, it has not been enhanced.
What is that?
80,000 has been awarded.
Let's see.
Escalation is not awarded.
Let's see what is the
Page 31, ink page 31.
There are two MVCs. Which MVC?
Please, please. First one, my lord. Page 31 of this. Para 18. Para 18. Internal. Page 31.
Internal page 21.
31, no? Internal 20.
Full page is internal page 21.
Please.
Yes, 21. This is MVC number.
7928. 9,500 has been taken.
For the chart income, the rightly considered.
Future
Instead
prospectus.
also the parents.
Total amount is 15,46,400 is granted. It's a
Bachelor.
case of death. What
Bachelor.
was the income taken?
9,500.
Which year is?
16.
Then
40,000, 40 lakh, 40% has been added.
not added.
Added.
Then what is enhancement you're seeking?
He wants demonstrate escalation.
11,000.
At best, anyhow, if that is the case, now the court will not dispose of. You may get 4,000, that is 8,000 rupees, plus another 6,000, 8 plus 6. That would be the enhancement if at all it has to be done, nothing else.
Please.
But that court will not do it now. After vacation?
11,000.
Huh?
You'll understand.
11,000.
We'll close the
The
matter.
local is sufficient.
It is submitted that the insurance company is ready to pay an amount of rupees 11,000 over and above what has been 11,000 over and above what has been granted by the tribunal. Mr. Pradeep takes notice on behalf of the insurance company. Next,
Filia 4,000.
like today evening, same in the local adalat, joint memo. 63?
62.
62.
75,000.
Huh.
They may be conducted.
75,000
Inclusive interest.
over and above. It is submitted, the insurance company is ready to pay an amount of 75,000 as global compensation. IN number 1 of 25 is filed to condone the delay of 19 days. Mr. Pradeep is directed to take notice on behalf of the insurance company. Same Lok Adalat 530. Next 63.
Exoneration.
What is that?
Exoneration.
Oh, you're exonerated. Notice. Next 64.
Serial number 64.
3 lakh.
Satish Shetty.
Agreed. 3,80,000. 6% interest or inclusive of interest. the insurance company is, it is agreed that they'll pay an amount of 3,80,000 inclusive of interest over and above the what has been granted by the tribunal. 5,000, same 530 Lokadalar. IA number 1 of 25 is filed to condone the delay of 209 days on condition. Even on that order also, they are not entitled for interest for 209 days.
Serial number 65.
For the appellant.
Yes,
Challenging.
they are seeking negligence aspect. Quantum is granted. Negligence aspect. It requires another connected matter is there.
Next, notice
Serial number 66.
Call along with MFN number 1294 of 25.
Give them, give that. Post along with so and so. 66.
66.
Exactly. Ready.
Dispensation memo.
Memo is filed seeking dispensation of notice to R2, R1.
R2 memo.
R2, same memo is taken on record for the first respondent insurance company. Mr. Shivanagowda takes notice. Yes.
Type 3 compound both bonds, communicated both bonds.
No. Come to that
Table.
Table.
How many are the grievous injuries?
2 fractures.
2 fractures.
3 fractures memo.
Huh?
Both the bones.
ಹೇಳಿ ಅದೇ ಎರಡು ಸೇರೆ ಒಂದದು
ಆಮೇಲೆ ಓಪನ್ ಫ್ರಾಕ್ಚರ್
ಅದನ್ನ ನೋಡಿದೀನಿ ಮೇಡಮ್ ಓಪನ್ ಫ್ರಾಕ್ಚರ್ ಒಂದು ಟೈಪ್ 3 ಕಮ್ಯುನಿಟೆಡ್ ಬೋತ್
Yes, 60,000. Next.
Doctors assess 18.5% is
whole body.
18.5 to the whole body. How much was considered?
18.15.
18.15. How much was considered by the tribunal?
7% is. 7%.
Taken 7%. That
Consider 18.15. So which year is the accident?
please 15.
Which year is the accident?
2022. 15,500 taken.
15,500 into 12. What is the multiplier?
18 melo.
18 into
18.
18.15.
Please.
43 years.
43 years.
So multiplier would be
14. 17.
ಇಲ್ಲ 20.
Yeah. No.
Para 17.
20 years.
20 years. Again 47. ಯಾವ್ದು ಬೇರೆ ನೋಡಿದ್ರು.
Court has taken 18 into.
Correct.
18 is
12%
the
disability
right.
was taken.
Yes, court had taken 18. It's coming to 6,07,662.
15.
I mean, it is only 20,000.
1 minute. We'll go step by step. Then loss of amenities, 30,000.
Medical expenses rightly awarded, my lord.
Medical expenses,
I have produced bills.
1,79,822. Then loss of earning during later period.
15, sorry, my lord. 46,000 is awarded.
So 15,500 into 4.
Multiplier.
It comes to 62,000.
ನೀವು ಬರ್ಕೊಂಡಿರೋ ತಪ್ಪಾಗಿ ಬರ್ಕೊಂಡಿದ್ದೀರಿ ಅಷ್ಟೇ. ಇಲ್ಲಿದೆ ನೋಡಿ 20 years.
How many days was in hospital?
16 days, my lord.
Court has reasonably granted 25,000. No enhancement is required in that. Conveyance.
18.
Future medical expenses?
No evidence.
15,000 is awarded.
Huh?
15,000 is awarded, my lord.
ಕೊಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೆ
Again,
ಜಾಸ್ತಿ ಆಯ್ತು.
implants are there, my lord.
Accident of MBC of 20 to 30,000.
Marriage prospectus is not awarded, my lord.
What is the marriage prospects?
It's 20-year-old.
How it is coming in his way? Injury to?
Both the legs.
Open fracture and the
Lower limbs,
third
my
type of communicated both bones.
What do you say on that?
Blood There is no evidence by the doctor to that effect. Merely they are saying that, and the disability which we have now taken is on the higher side, considering the nature of injury.
It comes to 9,94,484 against 6,34,426. Yes, Mrs. Sivanagowda. It is submitted, the insurance company is ready to pay an amount of rupees 9,94,484 against the awarded amount of 6,34,426, and the enhanced amount carries 6% interest. Any delay? IA number 1025 is filed to condone the delay of 2 days. For the reasons stated, delay is condoned. Next, 67.
Number 67, Pradeep B. Syed Abdul Sabur.
Liability is under challenge. What is this non-deposit or 20% of the compensation amount before this court? No, it says that you have not deposited the amount. Notice, all notices are served. Admit, post of final hearing, call for the TCR 68. 3620 of 20. Next 68.
Serial number 68. BC Sivanagowda.
Insurance company appeal on the only on the age factor is concerned.
On quantum.
Please.
Let's see. All are served.
All are served. But he was aged about 49 years as per the document. Election identity card. Therefore, madam, I have filed the review petition.
You know, we have to calculate, pass a judicial order. Yes. Admit post of final hearing, Registry is directed to call for the TCR. 69.
69, Pradeep B.
Admit post of final hearing, call for the TCR.
Serial number
Claimants also filed an appeal.
Post along with so and so, so and so.
8116 of 24.
Yes. 70.
70.
72 matter, my lord. This case, my lord, challenging the liability, my lord, the claim petition filed after lapse of 6 months, my lord, bad by limitation. That issue is pending before the apex court, my lord.
It is submitted that the claim petition is filed after?
Lapse of 6 months, my lord.
After lapse of 6 months.
6 months.
From the date of accident. And on that ground, and still the tribunal had granted compensation on that, the insurance company is before this court. Considering the submission, there shall be stay of all further proceedings on the condition that?
I'll deposit 50%.
On the condition of deposit 50% of the amount before the MACT.
Please.
Notice. Yes, next. 6 weeks.
Please.
Yes, 71.
Senior is held up in another court, my lord. Kindly have it Saturday, my lord.
Look at it. If it is on the quantum, we will ask them to. We can give permission to deposit. I mean, withdraw the amount.
Both quantum and liability.
Involvement of it.
I think on quantum.
Quantum and liability.
Both,
She is
sir.
telling both.
I number 125 is filed, seeking stay, and it is submitted that the insurance, now RTC is before this court questioning the quantum as well as the liability. There shall be stay of all further proceedings, same 50%, 6 weeks before the MACT. On such deposit, the claimants are entitled to withdraw 25% subject to the result, further orders, subject to the result of the MFA. This notice 72,
72, Vijay Kumar T.
For enhancement.
enhancement, notice, which is insurance company.
Shriram General Insurance.
Mr. Pradeep is directed to take notice on behalf of the insurance company.
Please.
Notice, liability is on whom?
But still it has not complete. The
Huh?
MSCT award is not complete till like, we'll verify and afterwards, after vacation.
After vacation.
Please.
Serial number 73.
What about 73?
73, last occasion owner has stated that you will settle with the matter. This fall from tractor, my lord, mudguard. Both have discussed, my lord, what happened. We don't know. Yeah, I guess it- Not possible.
Not possible.
They are challenging the liability.
Who is challenging the liability?
Owner of the vehicle. The liability is fixed as the owner of the vehicle on the ground that, my lord, was sitting on a mudguard of the tractor. As per the judgment of our honorable High Court, my lord, it's well settled, my lord, the owner is held liable to the company.
IF5 for withdrawal of the amount. That you, IA number 1, 5 of 20, withdrawal of the amount, considering the submission to the land council, IA is allowed. Yes.
Serial number 74.
74, the company.
No amount deposited, it's still stay petition is.
Amount has been deposited before this
Yes, next 74.
74.
74, my lord, company appeal is also there, my lord, 1719 of 24. my
Post
lord.
along with so and so,
19 of 24.
admit post of final hearing, post along with so and so.
Serial number
Next 75,
75, my lord, 2,30,000.
no. That is with interest or without?
Inclusive of interest,
Inclusive of interest, the insurance company is ready to pay 2,30,000
30,000.
over and above the compensation that is awarded for before the Lok Adalat at 5:30. Yes, next.
List number 4. Serial number 1, Janardhan Reddy.
That's liability challenge.
Liability.
Yes.
Respondent,
I have
my
to
lord.
take steps to the owner because pain recovery is equal.
For taking steps, a week's time, default order, next two.
Serial number
Much
2.
Connected matter.
This also same.
It is a
Serial number 3.
free also, no policy, my lordship.
Why all these are
I
listed?
don't know, my lordship. Almost 10 cases posted liability matters only, my lord.
Where is your list?
I registered.
You have given the list. Where is Mr. Raghu?
Today also I have given.
Today also you have given. All of them will come tomorrow.
Yes, ma'am.
And if your officers are there, ask them to come tomorrow.
I'll inform you.
Tomorrow, all of them will be listed. Even some of yours also.
Quantum cases list, but matters are not listed. Some other
You also gave. Then why not? Call that Raghu. Call him. Why is he posting all this waste of time?
Serial number 4, Janardhan Reddy.
As per the notice, as per the postal shara, the notice to R2 is returned unclaimed amounts to deemed service of notice. Admit post for final hearing. Call for the DCR. Next 5.
Serial number 5.
My lordship is a quantum, my lordship. There is no scope for
Post of who has to be all are served.
yes, my lord.
Admit post of final hearing DCR. Next,
6 also, my lordship. Liability challenge, my lordship.
somebody expired R5 steps have to
Yes,
be
my lord.
taken.
Yes, my lord.
For taking steps,
What?
list is shall be taken steps time till 5th of June. Next 7.
Serial number 7.
Lordship, there is no grounds for succeeding the appeal, my lordship. The judicial order may be required. Major sons is not entitled like that at the time of your
That
appeal.
is the ground.
Yes.
Give that. Agreed with the orders passed from embassy number 741 of 2019 dated 23rd February 2022. The insurance companies before this court. The tribunal has granted compensation of an amount of rupees 5,49,000. The claimants are the son, 2 daughters. It is a contention of the land council appearing for the insurance company that the major sons and daughters are not entitled for compensation under the head of loss of dependency, and the tribunal has not considered this aspect. Next para. In the light of the law laid down by the Honorable Apex Court in Simarani's case, the contention of the insurance company is not tenable, and this court finds no reasons to interfere. Accordingly dismissed. Next.
Memo for dispensation, they are filing.
Any, all that not necessary, no.
Till number
Yes.
8.
Lordship, connected matters are limited. ಅದಕ್ಕೆ ಇದು list. Connected matter, the
That is
claimants
there.
also filed appeal.
I'll post along with the connected matter after vacation.
Till number
List
9.
9.
Respond number 1 is the owner of the vehicle.
Memo is filed seeking dispensation of notice to R1 dispense with, which is the insurance company.
United India Insurance Company. United India Insurance Company.
You appear?
Yeah.
Yes.
Mr. Janardhan Reddy takes notice on behalf of the insurance company. So now,
Total 3,12,000.
so memo is also there. So process is completed.
Please.
IA number 1 of 2022 is filed to condone the delay of 596 days in filing. Condone for the reasons stated. Yes. Admit post for final hearing TCR 10.
Only enhancement of
10.
settlement.
Designer of check. It's posted Saturday, my lordship, 26.
Saturday.
It can be posted on Saturday.
Saturday.
List this matter on Saturday before the Lok Adalat. 10.
Till number 10.
Is liability, my lordship. No policy as of.
For the process, within a week, the process shall be paid.
Till number 11.
11 and 12 also, my lordship. It is a self-accident, my lordship. It is-
11 and 12.
Yes, my lordship.
Admit post for final hearing, call for the TCR.
Till number 13.
13 also, my lordship, liability.
I appear for respondent. It's a case of death in a 2014 accident. Some urgency is there. Madam. No compensation is reached. Madam. EC.
His list, you have urgency.
Immediately after
didn't
vacation,
You didn't even move a memo for this. On what ground you are before the court?
WC policy, my lordship, concerning the liability, my lordship.
On
There
the
is no,
ground?
there is no employer-employer relationship, my lordship. That's why.
Any grounds or we can?
Yes, my lordship. They have reduced the evidence also, my lordship.
Yes, after vacation.
Yes.
Kindly particular date.
Huh?
Particular date maybe.
List this matter on 17th of June.
TCR ma'am.
Admit call for TCR.
Till number 14.
It's a
What
quantum,
about
my
the-
lordship.
What about this?
Quantum only enhancement is the death case.
We'll do that. Memo can be filed.
No, my lordship, judicial order is required.
Judicial order, no, there is no time for
Yes,
that.
ma'am.
We'll do one thing. No, we will calculate.
Yes, ma'am.
You inform him. We'll place it before the Lok Adalat on Saturday.
Yes,
In the
ma'am.
meantime, you can.
Yes, my lordship. Only 1,20,000 is the enhancement. Consortium only is not awarded, my lordship.
1 minute, 1 minute. Now, which year is the accident?
20, 17, my lordship.
What is this amount taken salary?
Income 15,000, it's approved income, my lordship.
Correct?
Yes, my lordship.
And
40,000, 40% is the future prospects, my lordship.
Granted?
Yes, my lordship.
Then, so as far as loss of dependency is concerned, no scope for enhancement.
Yes, my lordship. Only consortium is because there are 4.
Come to that. Where is that loss of dependency is how much?
30 lakhs 24,000, my lordship.
30 lakh 24,000. How many are the claimants?
4, my lordship.
So 4 into 4.
Yes, my lordship.
1 lakh 60,000.
Yes, my lordship. 40,000 was awarded, my lordship.
36,000, 30,000 towards
Funeral expenses.
funeral expenses. 4, 11. It comes to 32 lakhs 14,000.
Yes, my lordship.
Shall I record that? Insurance company, it is submitted with land comes to the insurance company that insurance company is ready to pay 32 lakhs 14,000 over and above the compensation that is awarded by the tribunal and the interest is 6%. For business matter before the Lok Adalat on 26 for filing a joint memo.
Till number 15.
What about this?
Is the quantum, my lordship? It's an injury case, my lordship.
Give that. MBC number?
MBC number 619, my lordship. 40,000 was awarded by the tribunal, my lordship.
Global compensation.
Yes, my lordship. No medical evidence also. Chara 20A, the medical bills itself 43,900 minutes. But the tribunal, they have not produced the prescription bills, therefore the court is not considered.
You know that he has sustained grievous injuries.
Yes,
That is
Palash.
evidence. Another 40,000. Global compensation of 80,000. It submitted that the insurance company is ready to pay an amount of rupees 80,000 as global compensation. And for filing joint memo, Lok Adalat on Saturday.
Yes, ma'am.
Yes, next 16.
According to 58,000 is the 58,000 plus interest as per my calculation, Malad.
Yes,
My lord,
58,000.
list after vacation, my lord, my senior counsel in out of station.
It is submitted that the insurance company is ready to pay 58,000 with interest at 6%. It is over and above what has been granted.
58,000 plus interest, Malad. Over and above.
Over and above, and a memo will be filed before the Lok Adalat, list this matter before the Lok Adalat on 26th. Next 17. What about
17 Malad, so long back we have settled the 4 lakhs. We have already deposited, Maladship.
But it has
Because at
been-
the time of action, that at the time of appeal, the condonation delay application is pending. Therefore, the court is that is not reported.
It has been settled for 4 lakhs, my lord. Only for
You
the
have already
purpose of
deposited.
condone the delay, it has been remanded back.
So now again, when it has to be listed?
26.
Today also it can be done.
It can be.
Today, it is submitted that already it is settled at 4 lakhs and the joint memo will be filed before the Lok Adalat 5:30. Next.
18.
Appear,
What about this?
I appear for the appellant, madam.
Yes. You the file.
Case, madam. Case of injury, madam. The accident involves a 6-year-old minor child, madam.
Oh, minor child, then we will not hear it now. Admit post of file.
6 years, 6 years.
Directed to call for the TCR. What about 19?
Number 19.
It is self-accident, Maladship. Refer back, Maladship. It is a self-accident, Maladship.
Self-accident. Admit post of file hearing TCR 20.
20 Maladship, we have discussed 1,20,000 or and above. Refer to the matter.
It is submitted that they are ready for insurance company is ready to pay an amount of rupees 1,20,000 with interest.
No, global Maladship.
Globally, over and above what has been awarded by the tribunal. Next, 20 and 21.
21 Act policy, Maladship.
21.
21 Maladship.
21.
Admit post of file hearing.
Much obliged.
22.
22.
It's liability, Maladship.
Admit, no, it's already final hearing.
Yes,
This is matter after vacation.
23.
23.
23 is called a minor boy, Maladship. It is a Master Malika
After
case.
vacation.
Till number 24.
After vacation.
Yes.
Till number 25.
Yes, 25.
Connected matters, which is not liable.
The respondent number 1, kindly list the matter after vacation below.
After vacation, 26.
Correct. It's liability matters.
26.
All connected.
Where is that? Raghu is here. Raghu, I asked you.
Till number 20.
How many cases you have given again list?
26 also after vacation.
75. No, for tomorrow's first.
I gave 50 cases yesterday, but I don't know how much they want to this.
Come. And how many cases you have given?
35 cases.
Only those many?
43 cases, Maharaj.
Sriram Insurance, Sriram General Insurance.
100 cases.
Then give the list.
We have already given. Those cases not posted, whatever their fans in this, they posted another cases which we have challenged the award on liability. It is very difficult to do. So some instruction for them to take it.
Janardhan Reddy gave, he says that he has given 40, 50 list. Not 15, he says 40.
WhatsApp ಕಳಿಸಿದ್ದೀನಿ ನೋಡಿ ಸರ್.
And Sriram, they are also given Sriram and insurance. How many are coming tomorrow? He has given 43. And what about Sriram Dental Insurance? How many are coming? This is today's list is completed. No, she says another 50 are there. Take and post it tomorrow. And also ask Mr. Ravi from your Renuka, your matters are not there.
We are reporting now, 5 o'clock. My bad, I give the list tomorrow.
No, you give a, no, tomorrow, no, what happens is, tomorrow is again Saturday, you know, nobody will turn up. If you can give it today, they will list it tomorrow, even if it is late night.
I can do WhatsApp because after reporting here, and I go in without reporting, if I go to the office now, I can WhatsApp the report.
But what happens is, Saturday is Lok Adalat. But unless if it is listed in the court list, advocates will be there. If it is Lok Adalat, then nobody will turn up. That's why I wanted all the matters to come tomorrow itself.
By 7 o'clock,
8 o'clock also they will upload.
by 7
Yes. Then it will come for the 5:30. 5:30 or 5:50? 5:20.
ಆಮೇಲೆ ಮಾಡಬಿಡ ಈಗ ಆಗೋಯ್ತಲ್ಲ ನಮ್ಮ ಆಮೇಲೆ ಮಾಡಿ ಇವತ್ತು ಮುಗಿದೋಯ್ತು.
along with ಹೇಳಿದ್ರೆ ಸ್ಟೆನೋ ಫೋನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಹೇಳ್ಬಿಟ್ರೆ ಅಲ್ಲ ನೀವು ಸಬ್ಮಿಟ್ ಮಾಡ್ಬಿಟ್ರೆ ಏನ್ ಮಾಡೋದು ಆಮೇಲೆ ಆಗಲ್ಲ ಫೈಲ್ ಆಗ್ಬೇಕಲ್ಲ 1935 ಇವಾಗ ಏನ್ ಹೇಳೋದು ಮೇಡಮ್ ಇವ್ರು along with ಅಷ್ಟೇ ಎಲ್ಲ ಏನ್ ಮಾಡ್ಬೇಕಲ್ಲ ಅಲೋಡು 524 ವಿಡ್ರಾವಲ್ ಅಮೌಂಟ್ ಅಲೋ ಮಾಡಿದ್ದಾರೆ ये नंबर अय्या 24 ಅಲ್ಲ ಇದೆಲ್ಲ ಅವ್ರದ್ದೇ ಮೇಡಮ್
ಈಗ ಅವ್ಳ್ದು ಲೋಕ ಎತ್ಕೊಂಡು ಹೋದ್ಲಾ?
ಅವ್ರು ತಗೊಂಡು ಹೋದ್ರು, ಅವ್ರು ತಗೊಂಡು ಕಳಿಸ್ತಾರಂತೆ ಇವಾಗ. ನಾನು ಆ ಡಾಕ್ಟರ್ ಕರೆಸಿ ಅರ್ಜೆಂಟ್ ಅಂತ ಹೇಳಿ. ಮೇಡಮ್ ಈಗ ಮೇಘನ್ ಏನ್ ಹೇಳಿ ನಾನು ಅಲಾಂಗ್ ವಿತ್ 19 ಮತ್ತೆ 35 ಅಲ್ಲಿ
ಆಮೇಲೆ ಕೊಡ್ಲಿ ಇರಿ. ಕೊಡ್ತಾನೆ ಇದ್ರೆ
ನಿಮ್ ಗುರುತಿ ನಿಮ್ಗೆ ಸಿಗುತ್ತೆ ಅಂತಾರ ಅವ್ರು. ಏನ್ ಕೊಡ್ಬೇಡಿ. ನಾನು ಬಿಂದು ಅಂತ. ಲೋಕದಲ್ಲಕ್ಕವ್ರು ಬರ್ತಾರೆ ಸರ್, ಅವ್ರನ್ನ ಕೇಳಿ ನೀವು.
ನಾವು ಇಲ್ಲಿ ಕೊಟ್ಟರೆ ಇದಾಗಿದೆಯಲ್ಲ ಅಲ್ಲಿಗೆ ಹೋಗಿ ಬರ್ಬೇಕಪ್ಪ. ಲೋಕದಲ್ಲಿ ಹೋಗಿ ಬರ್ಬೇಕಾ ನಾವು?
ಇಲ್ಲ ಸರ್, ಬರ್ತಾರೆ ಇಲ್ಲ.
ಇಲ್ಲೇ ಬರ್ತಾರಾ?
ನಾಳೆ ರಿಪೀಟ್ ಯಾವ್ದು ಇಲ್ಲ ಅದು ಅದೇ ಇದು ಜನರಲ್ TMCPC ಅದೆಲ್ಲ ಲಿಸ್ಟ್ ಕೊಟ್ಟವ್ರ ಫೈಲ್
ಹೆವಿ ಹೋಯ್ತಾ ಆ ಕಡೆ ಬರೆಯಕ್ಕಾಗ್ಲಿಲ್ಲ ಫೈಲು ಅದಕ್ಕೆ ಹೋಯ್ತು
14 ಇದೆ 14ರಲ್ಲಿ 2 ಸಿಪಿ ರೋಸ್ಟರ್ ಇಲ್ಲ ಇನ್ನು ಉಳಿದಿದ್ದೆಲ್ಲ ಇದೆ ಫ್ರಂಟ್ ಕೋಡ್ ಬ್ಯಾಂಕ್ ಅಂತ ಇಲ್ಲಿ ನನ್ನ ಹತ್ರ ಕೊಟ್ಟವ್ರೆ ತಗೊಂಬನ್ನಿ ಇಲ್ಲಿ 14 ಫೈಲ್ ಅಂತ ತೋರಿಸ್ತಾರೆ. ಒಂದ್ CPC ನಮ್ಗಿಲ್ಲ ಇನ್ನೊಂದು ಯಾವ್ದೋ ಒಂದು ರೋಸ್ಟರ್ ನಮ್ಗಿಲ್ಲ ಇನ್ನು ಉಳ್ದವೆಲ್ಲ ನಮ್ಮ ಮುಂದೆ ಇದೆ 12 ಅಲ್ಲ ನಮ್ಗೆ ರೋಸ್ಟರ್ ಇಲ್ದಲ್ಲ ಇರೋದು ಬೇಡ ಇರೋದು ನಿಮ್ಗೆ ಕಳ್ಸಿರೋದು ಎಲ್ಲಾ ಫೈಲು ಲಿಸ್ಟ್ ಮಾಡಿ ನನಗೆ 14 ಕೊಟ್ಟವ್ರು ಇಲ್ಲಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಒಂದ್ ನಿಮಿಷ ಹಂಗೆ ಇರು ಲೈನಲ್ಲಿ ಹಂಗೆ ಇರು ನಾಳೆ ಯಾವ್ದು ರಿಪೀಟ್ ಇಲ್ಲ ಅಲ್ವಾ ಬಿಂದು ರಿಪೀಟ್ ಇದೆಯಾ ನಾಳೆ
ಈಗ ಆಗಿರೋದ್ರಲ್ಲಿ ಯಾವ್ದು ಇಲ್ಲ ಎಲ್ಲ ಕಳ್ಸಿರ್ಬಿಟ್ಟಿದ್ದೀವಿ ಯಾವ್ದು ಇಲ್ಲ ಇಲ್ಲ ಅಂದ್ರೆ ಹೋಗಿ ಫೈಲ್ಸ್ ಎಲ್ಲ ಹೋಗಿದ್ರೆ ಫೈನ್ ಮುಗೀತಷ್ಟೇ.
ಇಲ್ಲಿ 14 ನಂಬರ್ 14 ಫೈಲ್ ಅದ್ರೊಳಗಡೆ ಅಲ್ಲ ಅದು ಗೊತ್ತಿಲ್ಲ ನನಗೆ ಅವ್ರಿಲ್ಲೊಂದು ಲಿಸ್ಟ್ ಕೊಟ್ಟವ್ರೆ ನೀನು ಕೊಡ್ತೀನಿ ಕೋರ್ಟ್ ಬ್ಯಾಂಕ್ ಕೊಟ್ಟೈತೆ ಅಂತ ಅದಾದ್ಮೇಲೆ MFI ಫೈಲ್ ಒಂದು 41 ಕೇಸ್ ಯಾವ್ದೋ ವಾಟ್ಸ್ಆಪ್ ಹಾಕೋದು ಅಂತ ನೋಡಿರೋದು
ಇನ್ನೊಂದು ವಾಟ್ಸ್ಆಪ್ ಕೇಸ್
ಅದು ಅದನ್ನ ಅವ್ರು ಪೆಂಡಿಂಗ್ ಅಂತ ತರ್ಸ್ಕೊಬೇಕು ಅಂತ ನೋಡೋಣ ಇನ್ನೊಂದು ಅದು ಹೌದು ಮೇಡಮ್ ಈಗ ಕೇಳಿದ್ದಾರೆ ಆಮೇಲೆ ಇನ್ನೊಂದು ಯಾವ್ದೋ ಲಿಸ್ಟ್ ಹಾಕ್ತಾರಂತೆ ವಾಟ್ಸ್ಆಪ್ ಹಾಕೋದು ಮೆಸೇಜ್ ಹಾಕಿದ್ರೆ ಈಗ
ನೋಡಿ ಅಂದ್ರೆ ಹೆವಿ ಆಯ್ತು ಮೇಡಮ್ ಬರೆಯಕ್ ಕಷ್ಟ ಆಯ್ತು ಫೈಲು ಅಂತ ಅಲಾಂಗ್ ವಿತ್ ಅಂತಾರೆ ಇವರು ಒಂದು ಅಲಾಂಗ್ ವಿತ್ ಹೇಳಿದ್ದಾರೆ
ಸುಮ್ಮನೆ ಅಲಾಂಗ್ ವಿತ್ ಎಲ್ಲ ಹಂಗೆ ಇಡ್ಸೋಣ ಫೈಲು ಕೊಟ್ರೆ ಮಾಡ್ಸೋಣ ಕೊಡ್ದಲ್ಲ ಇದ್ರೆ ಏನಿಲ್ಲ ಏನ್ ಆರ್ಡರ್ ಆಗೈತೋ ಅದಷ್ಟೇ
ಬೇಡ
ಅಷ್ಟೇ
ನಾವು ಅವ್ರ ಹಿಂದೆ ಸುತ್ತಕ್ಕಾಗುತ್ತಾ